Can take your seats. We will begin.
All right, as everybody's settling in, I wanted to welcome all of you to this terrific event. My name is Amy Wildermuth. I am the dean here at Pitt Law. And Pitt Law is very proud to host this conference on the UN Convention on Contracts for the International Sale of Goods, as you know, the CISG. As we were saying earlier, I am now interested in the CISG, having come to Pitt Law. Now, my field is environmental and energy law. You would think, not a great fit, but here at Pitt Law, we invest so heavily in the CISG, I've had to learn about it, right? So I'm very excited to learn more today from this conference. As you know, we hosted one of the first symposiums on the CISG in October of 1987. A mere 10 months after the U.S. ratification of the convention and 2 months before the CISG's entry into force. Now, I also noticed that we're calling this the CISG at middle age. I would hope that we could call this at a young middle age. Everybody in the room with me? 1987, does that really feel like middle age? I kind of sell myself as not being in the middle age, right? So anybody here, we're going to go with young middle age. Okay. We've also hosted 3 other major symposia on the CISG. The first 2 of these conferences resulted in symposium issue publications in Pitt Law's Journal of Law and Commerce. The latter 2 resulted in books in the CILE Studies series, published first by West and then by Oxford University Press. And the papers from this symposium will also be published in the Journal of Law and Commerce. You all know the critical roles that Harry, who's here today, we're so happy to have him back, and including both his treatise, I should note, and his many songs, which he told me he's not going to sing today, which I'm kind of disappointed I'm not going to get to experience in person. And of course, Ron have played with respect to the CISG. And so many of you here today have a connection to us here at Pitt Law, either as a student or as part of the Vismut, which with Ron's help has been expanding the knowledge of CISG with the U.S. State Department and the Commerce Department in the Balkans and in the Middle East. In fact, just 2 weeks ago, Ron came back, right? He went with our graduate, Janet Checkley, and the current 3L, Elizabeth Taylor. They led a week of Vismut training and pre-Mut in Bahrain for 17 teams from those regions. These programs have developed law school curricula in the countries involved and helped identify the next generation of top legal scholars and leaders in those regions. We are deeply invested in the ways in which the CISG has been used to enrich the education of our students in order to prepare them for a global practice. The ways in which the scholarship of our faculty has highlighted the importance of the CISG and advanced the understanding of its use, and the ways in which our students and faculty have used the CISG to aid in the development of legal education and the legal profession in transition countries. We are so excited. We are just thrilled to have all of you here today. I look forward to many terrific discussions. Thank you so much for being here, and I hope to learn quite a bit more about the CISG. Thank you.
Thank you, Amy. I want to add my welcome. I think I know everybody here, but for those, if you don't know me, my name is Ron Brand. I'm the director of our Center for International Legal Education. I'm the person that when we deal with CISG has followed Harry around and kind of basked in his glow. This is kind of an interesting event for me because it's really not so much like a formal symposium or conference as it is kind of a long breakfast, lunch, dinner and lots of dessert conversation with friends, because let me be quite honest, this, and I want to thank both the current Chancellor, Patrick Gallagher, and the former Chancellor, Mark Nordenberg, but it's because of both of them that I'm able, with the Nordenberg professorship, to spend some money. And what better way to do that than to bring together a group like this, a group of friends, and have a nice time. Talking about things that interest us, that quite often our colleagues on the faculty kind of don't want to talk with us about. But as Dean Wildermuth said, we're making some inroads. People are starting to understand the importance of this. This is our 5th symposium on the CISG. I don't know if there's any other law school who's had more major symposia on the CISG. It's been a wonderful process along the way. And the publications that have come out of that process, even from 1987, the first one, still gets cited in the literature. Our Journal of Law and Commerce has not only published 2 of the symposia, and will publish this one, but they've published many more important articles and student notes on the CISG, and we think has provided an important place for people to look for publication of material on the CISG. So I add my welcome, and I look forward to the discussions we're going to have over the next day and a half. I think whether it's a young middle age or a middle age, whatever it is something we can explore. And I think the topics will allow us to do that. And the question sessions will be important. So now I'm going to turn to my role as moderator of the first panel and make sure that everybody knows that they have 20 minutes to talk. And for all of you who will be speaking, the moderators will have right here, so that if you look like this, you need to speak this direction now and then. Okay. But the reason I say that is because we've built in 20 minutes on each panel for discussion, and I don't want to miss that, because all of you know that sometimes the most interesting things that are said in a conference, a symposium like this, are said in the discussion and in the question and answer time. Our first panel is a great one to lead us off here. Our first speaker, Dr. Stefan Kroll at Bucerius Law School in Hamburg. He's better known as, for the many, as co-director of the VIS International Commercial Arbitration moot, and an author not only on the CISG but on arbitration, and a very busy practicing arbitrator. He's also taken time out of his schedule over the past week to teach a pop-up short course for our students, and we really appreciate that. Our second speaker is Vjosa Osmani. Vjosa is a member of the family coming home again. She received her LLM degree at Pitt and her SJD under Professor Fleckner, and returned to her home in Kosovo, first to be legal advisor to the president, and now a member of parliament, and one of the real leaders who's trying to move Kosovo in right directions. Chiara Giovannucci Arlandi from the University of Bologna is somebody who's been a friend of the law school, has come and taught before. She is in Italy one of the leading experts, in particular on alternative dispute resolution and mediation and arbitration. And then Henry Gabriel, who has been here for most of the other conferences, I think, if not all of them. Henry, and you can ask him about what he and I do in Rio during the break. it's not the kind of thing you might think about. But Henry has, among other things, been a representative to UNIDROIT and very active in that process and important in influencing the instruments that have come out of UNIDROIT. So it's a wonderful panel we have to begin with, and so I'm going to begin by getting out of the way, and I'll see if I can take care of the technology here and key things up. So how do we need to get that to full screen? Here, okay. Is that it? There we go.
Yeah,
Now we got it. Okay. That should do it.
okay, thank you very much, Ron, for these kind words, and in particular for the introduction and the invitation. It's a great pleasure to be here. Unfortunately, for me, it's the fourth time, but I hope it's not the last time that you invite me for the future conferences. It's a great pleasure and honor to be here, in particular, as this conference is dedicated also to Harry. Harry is called in the mood circles the Nightingale of Vienna. He has his famous presentations in Vienna, and I'm glad that at least once speak in front of him, before him, because usually I'm the person in Vienna who has to speak after him, and which is one of the worst things you can do. So when I selected my topic, it was called Courts, Arbitration and the CISG, Moot Court Issues. And when we go to the moot court, it's always about the CISG. We decide, or the students decide, cases, issues on the CISG. But there have been two cases or two events in the moot court where we had a particular arbitration court CISG issue. And the first one was 3 years ago, dealt with the concepts. How do arbitrators apply the CISG? And the second one is this year, a little bit, the law governing the arbitration agreement, can it be the CISG? Let's first have a look what happened at the first event. When you have a look at the CISG, there are two ways of applying it. Article 1A, the direct application, and 1B, the indirect application. When you have a look how state courts apply it, you have contracting states. They apply directly if both parties have their place of business in a contracting state. And if one of them doesn't have a place of business in a contracting state, you may go via the conflict of law approach. This is for courts in contracting states. They are bound by the CISG. Courts in non-contracting states, they're not bound by the CISG. So they do not apply Article 1, they do not apply the CISG via Article 1A. They can only go via Article 1B, meaning their conflict of law rules point them to the law of a contracting state, and then they apply the CISG. The difference with arbitration is arbitration tribunals are not part of the judicial system of a contracting state. So an arbitration tribunal is always in the position of a non-contracting state. That means arbitration tribunals largely apply the CISG under Article 1B. That was something which didn't play a major role in this moot court case, but I thought it plays a role. Then I read the memoranda, and none of the memoranda mentioned that. So I said, okay, if none of the memoranda mentions that, it's not the case, the solution is not dependent on that, don't put it into the arbitrator's brief. Just say the CISG is applicable via Article 1. I had sent out the arbitrator's brief. Within 5 minutes, I got a phone call from a German professor who told me, I thought at least you understand how it works. And then I told him, I'm awfully sorry, I've just written in a book published by Ingeborg exactly that this is the way it works, but I thought no one else will understand it. It's not really necessary. That's for German professors and academics, but people just apply the CISG. And it worked quite well until the final. and in the final we had Ingeborg. And she tried to explain to people how it worked. And we tried to prevent her from doing that, and later on one of the final members came to me and said, what did she want to explain to me here? So you see, that was one of the problems, a major failure. I took it out, fortunately, already in the arbitrator's brief. This year, we have the second problem, where the CISG and the arbitration agreement may conflict. And that is the question of, does the CISG, or can the CISG be the law governing the arbitration agreement? Why is that a problem? You have a lot of arbitration agreements which are part of sales transactions in form of an arbitration clause. And the arbitration agreement differs from other agreements in two ways. It is a contract like any other contract, but its primary effects are it distributes jurisdiction. It takes away the jurisdiction from the state courts and it prorogates the jurisdiction on the arbitral tribunal. In addition to that, we have what you would call contractual effects, but they are all ancillary effects. They are ancillary obligations which would normally arise under other contracts as well. Mutual obligation. The first one is you should not seek dispute resolution in the state courts, and the opposite of that, you should seek dispute resolution in front of an arbitral tribunal. Second, there is an obligation to participate in the constitution of the tribunal, meaning to appoint your arbitrator. That's also mutual obligation. Third, you have an obligation to pay your share of the advance on cost. And fourth, you have also an obligation, contractual obligation, to comply with the award. These are the most important ones. There are a number of other ones which have been discussed in practice and in the legal literature, but these are the most important ones. So you have, on the one hand, primary effect, just determining jurisdiction, secondary effect, kind of contractual obligation. And you see this distinction between contract on the one hand and procedure on the other hand, also when you look at the laws which are applicable to the arbitration agreement. In the arbitration agreement, you have a number of different laws which govern that. You have the question of arbitrability. That is clearly a procedural question which regulates the enforceability of the arbitration agreement. That means normally you look to the procedure law to find the relevant rules. You have the question of form requirement, which is also regulated in most jurisdictions, actually in the procedure law. You have it in the antitrust model law. You have a provision which deals with a form requirement, again, something which deviates from the general contract law. However, then you have the question, which law governs the contract as a contract? Which law governs its conclusion, which law governs its interpretation, and which law governs its validity? And there you rarely, as far as I know, I'm aware of 2 or 3 arbitration laws which have some rules but very short and not covering all these questions. But the majority of countries have to rely on the ordinary contract law to solve these questions. So that would be a possibility where the CISG could be applicable, at least for the question of contract conclusion and interpretation of the arbitration agreement. And then you have something, the law applicable to the parties. Can they conclude a contract? There you have a mixed approach. You have sometimes provisions in the arbitration law that certain parties, such for example consumers, cannot enter into arbitration agreement or can only enter into arbitration agreement after the dispute has arisen. But the majority of rules are in the substantive law. That means in the provisions which deal with certain type of transactions. So the dichotomy between procedure and substance, you see that also in the applicable law. And when you look at it, at the case law, the first case which dealt with the question, is the CISG applicable to the arbitration agreement, was the famous or infamous Philanto-Chilwich decision, the first decision from the United States, dealing with the question, is an arbitration agreement which was contained in a contract between Chilwich and its Russian buyer, is that included into the contract between Chilwich and Philanto, the party producing the shoes? And the question arose, how do we determine the inclusion of the arbitration agreement? The court realized that the arbitration agreement had to be in writing, but applied the CSG to that, at least said it applied the CSG to that. The commentary by Harry Flechtner and Ron Brand said they applied something, but not really the CSG. They applied it in one way or another. But what I want this decision for is that they came up with a very fine statement saying, because we applied the CSG now and not the UCC, because the State Department undertook to fix something that was not broken by helping to create the Sale of Goods Convention, which varies from the UCC in many significant ways. So you have a difference between the UCC and the CSG, and here we had a question, which law applies? The Philanto Court didn't even look at it. So they just applied the CSG, or a mixture of CSG and UCC. But in the commentary, Harry and Ron mentioned that one of the areas where you have a major difference is the battle of forms. So it may make a difference whether a contract has been concluded or an arbitration agreement has been concluded, whether it's evaluated under the CSG or under the UCC. And then came the case, again an American case, which influenced this year's problem. That's the case Transmar with Naranjo. It concerned the delivery of cocoa beans from South America to the United States, and they entered into a contract which was badly drafted and provided for some provisions referring allegedly to the CMAA standard contract, and the CMAA standard contract contained an arbitration agreement. However, the references were not completely clear in the contract. What happened? The Peruvian producers didn't deliver. We had an arbitration, CMA arbitration, award and damages in favor of Transmar. When they tried to enforce it, the Peruvians woke up. Until that time, they hadn't even participated in the arbitrations, and hired an American lawyer, and the American lawyer managed to have the award set aside at first instance for an excess of power. And the first instance court, the district court, came to the conclusion the parties never agreed on an arbitration agreement, because in the contract itself, in the contract document, the references were so unclear that the Peruvian cocoa producers, they couldn't be considered to have really consented to arbitration. The second instance, Second Circuit of Appeal, they came to the opposite conclusion. They said, it's not the law which you have applied, New York law, but it's the CSG which applies to that. Please have a new look at that case from the CSG perspective. And what they said, there's a major difference here. New York law differs from the CSG in two respects. In particular, Article 8.3 requires the court to give due consideration to the extrinsic evidence of the reasonable expectation of the parties. Then they said you're not only bound to look at the document, the Four Corners rule, which applies under New York law, but you can also look at the CSG. What the court didn't discuss was, is the CSG is all applicable to the arbitration agreement. They just assumed it, like the Philanto case. And you also find, a year before that, you find a large article in the American Review of International Arbitration by a colleague who said that is settled. The CISG is applicable to the arbitration agreement. The problem is you will find a decision from the German Supreme Court, which is very influential on the CISG. And I see most of you cannot read it. That is because PACE had not obtained its database. That is a decision, that's probably the decision why the American courts got it wrong, so I tried to translate it for you. They said in the forum selection agreement, it's not an arbitration agreement, but the forum selection agreement, which has largely the same consequences as an arbitration agreement, the only difference is you go select a particular court. They said forum selection clause in sales contract falling within the scope of application of the CSG, though they explicitly mentioned in Article 19.3, Article 81.1, are governed in relation not by the CSG, but by a different law. Different law would then mean a law determined on the basis of the conflict of law rules of the forum, which would probably mean the standard contract law of a particular state. So the question rises, Who is right, the Germans or the Americans? I don't want to answer that question. That would politically be not correct. I can just highlight some of the problems, why that may be a problem, because of two things. You have the doctrine of severability, and you have the scope of application of the CISG. The doctrine of severability means you have the arbitration clause is a separate contract. And the CISG, the second is the CISG applies to contracts of sale. Now, if you have a look at it, most arbitration agreements are arbitration clauses in a contract. But once you look at it from a slightly different perspective, there are also arbitration agreements which are concluded after the dispute has arisen and are concluded with a time lapse between the dispute arising and the arbitration agreement. In these arbitration agreements, hardly anyone would ever suggest that they are subject to the CISG, because they have been concluded a year later, 2 years later, and they're clearly not sales agreement, contracts for the sale of goods, but they are procedural contracts, arbitration agreement. It gets a little closer when you conclude an arbitration agreement directly when you conclude the contract, but still in a separate document. You see that from time to time because some countries require arbitration agreement to be in a specific document, at least if they are concluded with smaller business or consumers. And the problem then arises when you have it in the same contract, when you have it as an arbitration clause. However, under the doctrine of separability, the arbitration agreement still remains a separate contract. And we have, in a number of cases, we had a different law applying to the arbitration agreement or to the arbitration clause than applying to the main contract. So that is something which happens again and again. Probably one of the most famous case is the Sul-America case, where you had everything in Brazil, the contract submitted to Brazilian law, but then the place of arbitration was in the UK, and the English court applied UK law to the arbitration agreement. So the question arises, is the arbitration agreement covered by the scope of the CISG? And you have already seen the two arguments raised by the German Supreme Court, where they said, no, despite these two arguments, it's not covered. You have, in the sales convention, you have agreements dealing with jurisdiction mentioned at two places. Article 19.3 says that additional quantities or terms, etc., extend to one's party, or the settlement of disputes are considered to alter the terms of the offer materially. Is that really a regulation of these types of settlement of dispute agreements, of arbitration clauses and these other dispute resolution clauses? You could read that easily in a way saying, no, what we do here is we regulate how they affect the contract. That means we regulate the sales contract question, but we're not regulating what happens with these, so we're not regulating the clause itself. The other one is more difficult to deal with, because here it really affects the dispute resolution agreement. It regulates the arbitration agreement, that the arbitration agreement is not affected by termination of the main contract. The German Supreme Court said this is not really regulating that, they are stating the obvious, repeating the obvious, so they are not regulating something there. And for that reason, they do not fall within the scope of application. The problem with the Supreme Court decision is they invoked the CISG all the time, so they were not consequent in their decision either. But at least it's not a clear-cut answer. You can argue largely both ways. So largely it's in the end a decision what you can argue both ways. What do you consider to be the better solution in these things? There's no conclusive argument, and you have to look at the effects in practice and whether CISG provisions are really suitable for regulating arbitration agreement conclusion, interpretation of arbitration agreement. The effects in practice, you have that frequently that the arbitration clause is treated differently than the main contract. The best example is the writing requirement. The arbitration agreement has a writing requirement. It may be invalid, though the rest of the contract is valid. So there is a difference. The arbitration agreement is submitted, maybe submitted to a different law. So that is nothing spectacular. Where it may become a problem is when you have the arbitration agreement in general conditions. It's very difficult to explain to anyone that from the general conditions, 90 clauses are included, but clause 91 is not included because you have a different provision dealing with inclusion of general conditions under the sales convention and under the applicable local law. In Germany, that's, for example, the case that the sales convention has stricter requirements. If the German local law would be applicable, it could be that the 90 other clauses have not been validly included while the arbitration agreement has been validly included. That is an odd solution, at least to most business people, which have not the completely distorted mind of a lawyer. An arbitration lawyer has no problem with that. Yeah, so that is separate. We just treated it separate. But then let's have a look at the suitability of the CISG rules. The general rules are, in my view, suitable with one exception, and that is the form requirement. But for me, the form requirement is generally excluded by the specific provisions in the procedure law, in the arbitration law, or in other things. You have people who say the CISG is applicable to everything, but I think that is, in my view, not tenable. The formation rules are also suitable. The question which I will pose, and which I cannot give an answer now because my time is up, is, are there provisions on the remedies and breach of contract? Are they suitable for dealing with the contractual obligations we have under the arbitration agreement? The obligation to participate in an arbitration, which may give rise to damages if you start court proceedings. The obligation to pay your advance on cost. Is it then, can you then say if one party is not participating, is that a fundamental breach which entitles you to terminate the contract? And I get the sign that I should terminate my presentation, but before that I want to thank the State Department that they fixed something which wasn't broken, otherwise I wouldn't be here. And thank you for having me and thank you for your attention.
Thank you, Stefan, and thank you for setting the example, starting off of keeping matters moving on time. Very much appreciate that. We now move if I can get there, to Vyosa Osmani.
Good morning, everyone. I apologize about my voice. I've been battling a cold for a couple of days, but I'll try to speak despite of that. It's a great pleasure to be among so many great names and great people and scholars of the CISG, and at the same time to be back to what I consider my second home, not just because of the many years that I've spent in Pittsburgh, but because of the sense of family that this university has always given to each and every student that has studied here. Before I start with my presentation, I was reminded when I met Professor Petra Butler today of the horrible events in New Zealand and similar attacks that happen around the world. Every single time that I'm shocked, and I'm sure everyone else is, by such events, I think of the University of Pittsburgh. And people may ask why. While teaching the CISG, Professor Brandt, Professor Fleckner, and everyone else at the law school here have brought so many people together, have fought hate and prejudice, and made sure that we talk to one another, no matter the color, no matter the ethnicity, no matter our background and the country we came from. And that has had such an enormous impact, not just on small countries like Kosovo, but I'm sure on so many others. So for that, I want to thank the University of Pittsburgh for the great role that they have played and for the model, the example that they have shown and still continue to show
to the world. I just wish the US government would understand this excellent role. I mean, who would have thought that through teaching the CISG, you can actually also fight prejudice and hate. So I felt like I had to make that comment before we move on while I was looking around and seeing all of you. Now, as Professor Brand mentioned, I did my SJD, my doctorate degree, under the mentorship of Professor Fleckner. And mainly we've tried to work on how the CISG has influenced not just Kosovo, but also how the example of Kosovo can be seen by other countries around the world. It is a very tiny country, but with some quite interesting developments, especially in terms of how the CISG has applied. So for that reason, the topic that I've chosen in consultation with Professor Brand and other colleagues was domesticating the CISG by taking examples from several jurisdictions. As you may be aware, the term was mentioned by Peter Winship many years ago in 1991, if I'm not mistaken, if not even before. And then we had late Professor Peter Schlechtrim talking about this phenomenon in 2005, which is what brought my attention to the topic. So the phenomenon of domestication of the CISG, which, as I mentioned, has already occurred in a number of countries, primarily involves the borrowing or the copy-pasting of the text of the CISG in the domestic sales of a certain country. Now, depending on the approach, this may result in the application of the CISG not only for the cross-border sales, but also for sales where both parties come from the same country, so are located in the same country. So you can imagine in a tiny country like Kosovo, a sales contract between Pristina and Mitrovica, which is my home city, just 1 hour away, would be governed by the text of the CISG. Now, the reason why this topic is also something that I was interested on is because Kosovo is one of the countries that took the text of the CISG and made it its own domestic law for about 12 years. Now, how did that happen? My country became independent only in 2008. It's the youngest country in Europe, and it emerged from the dissolution of Yugoslavia. But when it became independent, it took over to continue to apply every single treaty that had been signed by Yugoslavia before through the principle of succession. But before independence, the territory was administered by the United Nations for almost a decade. Now, what happened when the UN came into that tiny country? The United Nations practically had to draft almost every piece of legislation to run the country because we had a legal vacuum right after the war. So in a war-torn society, you need to make sure that you have those rules quickly. One of the very first regulations, which was actually a law that was adopted in Kosovo, was Regulation 2068 on the sale of goods. So the UN people, instead of drafting it all anew, they just took the text of the CISG and made it Kosovo's domestic sales law. Obviously, they felt the need to make a couple of changes. But first of all, let's try to understand why they did that. I interviewed some of the main people who were running the UN legal office at that time. They weren't ready to give too many details, as you would imagine. They are always too afraid to give those details that someone might use them for other purposes, especially if they're talking to a person that is an academic, but also a politician. But one of the main reasons they've mentioned was that they wanted to make sure that when drafting legislation, regulations for Kosovo, they use the best international standards out there, be it in the area of trade or human rights, or let's say issues like intellectual property. So they thought instead of, sitting down and drafting it all from the very beginning, they should take the CISG because they believe that's the best out there in terms of trade, in terms of sale of goods. The second reason, according to them, was lack of time. They needed to do things quick. They had no time to form working groups and include professionals and politicians and different kind of parties in order to go through the normal procedures of drafting a new law. So this is what became one of the very first regulations adopted in Kosovo. Now, what's really interesting in that text? Article 1 of that regulation requires that while interpreting the convention and the parties' rights and obligations, the courts are required to observe uniformity, not encouraged, required. So again, let me get back to that little contract between Pristina and Mitrovica, 2 cities just 1 hour away. A judge or an arbitrator working on that contract or in that case between the 2 parties would have, according to that obligation, to check how the judges or arbitrators in the United States or in China or somewhere else around the world have interpreted that same provision of, let's say, a fundamental breach before deciding their own case. So as we can see, this is even a higher standard, a higher requirement than CISG Article 7, which encourages the parties to observe uniformity, but is not per se a strong requirement as the language that has been used in this regulation. Now, why has that put the judges in Kosovo a little baffled and, in a situation where they didn't know what to do? One, we're talking about a war-torn society, so these were judges whose jobs, the buildings were burned down during the war, so they had to kind of improvise and go to some other buildings. They had no laptops. Most of the documents that they had previously worked on had been burned down as well. No laptops, let alone internet, let alone, someone to translate all of these cases, because most of them, because they were educated in the previous socialist system, couldn't speak any foreign languages. So from a practical point of view, it was impossible to observe the uniformity requirement that was required by this convention. Even in today's circumstances, where the judges do have the good offices and the good laptops and the good internet, most of them, again, despite of many reforms, don't speak the languages that are required to go to all of these online platforms that would allow you to check different cases from around the world. In the meantime, though, lots of training took place for judges, but especially for practitioners, for lawyers representing companies, on the importance of applying the CISG. So this regulation, apart from Article 1 that I've mentioned, had to make a couple of other changes to the text. Now, all the uniformities mentioned at the introduction under Section 1 of the regulation, they've deleted Article 7 of the CISG from the text of the regulation entirely, obviously because it speaks about the international character of the convention. They've done that with a couple of other articles, such as Article 28, because obviously that is also related to cross-border sales. Article 1, which talks about application of the CISG only in cases where the parties come from 2 different countries. And of course, also the final provisions which talk about accession to the CISG, ratification process, and even succession. But all in all, over 90% of the text that relates to the parties' rights and obligations, issues of breach, issues of damages, had been Kosovo's domestic sales law for about 12 years, until 2012, when Kosovo decided to undertake a reform on its law and obligations. Now, we had to make a decision. And when I say we, most of the people in the institutions of Kosovo are former Vismutis. People in the Ministry of Justice, people working in arbitration institutions, people in the parliament. So we kind of get together, and when we have these kind of important pieces of legislation, of course, some of us know, we think that we know what we're talking about, and we've always had the help of great professors from Pittsburgh and Ghent and others while discussing these issues. So the decision was to reform the law on obligations, but not really copy-paste the CISG and make it domestic law again. The decision was to take into account tradition, to take into account the fact that we're coming from a civil law system, and to make sure that the law that is adopted is actually implementable by judges. Because the regulation that we had for so many years, it was there, but the judges would just, leave it in the drawer somewhere and resisting its application and going back to some old law from the 70s. Yeah, they were not supposed to do that, but again, imagine a system in a war-torn country for a couple of years where everything is being built and transformed from an old system to a free market economy. So everything had to change. Everything had to be built from scratch, from the Constitution to every other piece of legislation. So the new law on obligations has its own chapter on sales. However, the influence of the CISG is very much evident. When we look at the provisions on contract formation, when we look at the offer, the acceptance, the counteroffer, we can see how much influence the CISG has had, and especially provisions related to breach, provisions related to damages. Absolutely, the CISG has played an important role in the harmonization process and the reform process of the law on obligations. And then we made sure that there's an article in the law which says that the CISG will apply to contracts of an international character where the parties come from two different countries. So as the situation stands right now, Kosovo has a domestic law which is largely influenced by the CISG, but it's not a copy-paste, a domestication of the CISG, and then it does apply the CISG to its international sales. I'm not going to get too much into the issue of succession and how, as a country, we've unilaterally adopted the automatic principle of succession, which means that from the day of independence, we've decided to implement every single treaty that had been adopted by Yugoslavia before, including the UN treaty, because it's a quite complicated issue. It took me an entire PhD thesis to work with that. But again, that's an important area, which again makes Kosovo quite an interesting case, both in terms of public international law, as well as the example of the CISG. Now, I have 5 minutes left, so let me get back to a couple of other examples. While we were drafting our law on obligations, we checked what would be the best examples from the world. As we've seen in the introduction or the introductory papers sent to us, the Nordic countries had been mentioned by Professor Schlechtrim as places where the CISG has had an enormous influence. Let's take the Norwegian model. Norway is one of the countries where the CISG was copy-pasted and adopted as a single act, as a single piece of legislation that applies to both domestic and international sales. Obviously, they've taken this different way of making the CISG applicable instead of having it separately as the international law for sales. So the ratification was made through a separate piece of legislation and was adopted by way of a consolidated act. Now, many authors have criticized this because despite of taking over the text, they've made a couple of exceptions, a couple of changes. And according to Kruger, for example, the method of adopting a unified code has not worked because now we have the same wording, the same provision, which needs to be interpreted differently for a domestic sales contract and differently for an international sales contract. So this, according to some authors, has actually contributed more to the homeward trend, which is already quite apparent in some cases, rather than to the purpose of uniformity. Now, other countries in in the Nordic area have not taken this example. For example, Sweden and Finland, they simply introduced the CISG along their domestic sales law, which is based on the CISG, but these are two separate acts. Denmark, on the other side, doesn't seem to have been that influenced by the CISG. There's another country, again, very similar history to the one in Kosovo, Estonia, where the CISG, during the process of transformation of that society from the former system to a system of based on a free market economy, where they wanted to modernize their legislation and harmonize it. Of course, they took the CISG as an example, and there have been a couple of great papers already published on the topic, but if we look at Estonian law on sales, we can see, again, just like in the case of Kosovo, the influence that it has played, especially on three areas: contract formation, breach, and damages. So practically, this is a very good example. But what was really interesting for me while I was looking at this was to see that the CISG has influenced also big countries like China and Russia. Practically their reform and harmonization process of their sales law had also been influenced quite a lot by the CISG, especially in the case of China, which is also evident on the many great cases that are produced by some Chinese courts, and especially courts of arbitration. So as we can see in the long run, and as Professor Schlechtrim has argued, this influence in the harmonization process is even more important to determine the influence of the CISG internationally than the cases of domestication where the text was copy-pasted. But nevertheless, even these few cases where the text has been entirely copy-pasted, and I forgot to mention Tokelau Islands, which were mentioned many years ago, a territory under the trusteeship of New Zealand. But even those cases show and I think need to be noted as one of the indirect successes of the CISG, apart from the direct success that it has had internationally with a large embrace in the legal systems of 84, together with Kosovo, 85 countries. So with that, and I forgot just one element, obviously with every country in the European Union, with the EC directive on consumer sales goods, that is a directive that has been largely influenced by the CISG. And obviously when you're in the European Union, or even striving to become a part of the European Union like my country, and we have an obligation to have each piece of legislation in line with acquis communautaire, it means that through that indirect way, through that directive, we are having the influence of the CISG in each and every member of the European Union and beyond in the countries that are striving to become members of this union. So thank you for your attention. I think I finished on time.
So we move from domestication of the CISG to looking much more specifically at the CISG. And Chiara Giovannucci-Alandi is going to take us into questions of burdens of proof.
Thank you. Can I come here? Thank you so much.
Microphone working okay?
It's okay? I think it works. First of all, I would like to thank Henry and Ron to invite me here, because it's a big honor, but it's even a big pleasure to spend time with them and for them, in particular for Henry today. Having said that, I would like to make just some remarks in respect of this subject, because the procedural issue and the CISG would deserve a greater attention, just like Stephen's intervention remind us today. But for sure, the issues of evidence are fundamental. Firstly, to make it possible for individuals to know which instrument they must have in order to be able to obtain recognition of their right if and when violated, and to try to predict the effectiveness of the instruments in the eyes of the judge. Moreover, all the problems relating to the framing of rules of evidence as a substantive or procedural law matters arise precisely from this requirement. The decision of the Italian legislator of 1942 to insert the evidence provisions in the Civil Code is therefore consequential and coherent, developing under different but complementary profiles. In that context, in fact, the evidence assumes importance in general as a means or tool granted to anyone to assert or, depending on the case, to defend their rights, not only in court, but outside and before the judgment. The most evident practical effect of the above-mentioned approach are to be found in the consolidated principle, typical of the Italian legal system, but not only of it, according to which the rules on the burden of proof and on the admissibility and relevance of the evidence belong to the substantive law, by this nature so-called two-phased. However, the tendency of a reform in Italy is today in favor of the inclusion of the entire discipline of evidence in the Code of Civil Procedure, giving it a uniform procedural qualification. But in any case, a classification of rules of evidence can have a big impact on the application of convention of uniform law. In fact, the law of evidence in the CISG has been affected for a long time by the unresolved issues of whether it is to be ruled by substantive law or by exclusively procedural law. In this sense, the law of evidence has been the topic of endless and, for the most part, unsolved debates concerning its substantive or procedural nature. The question of whether evidence should be governed by the lex fori of the lex causae becomes extremely relevant for the resolution of conflict of laws issues in international disputes, since in most countries the rules of evidence are classified as substantive, not as procedural rules. In the rules of evidence were to be considered rules of substantive law, they would automatically be interpreted in the light of the Convention. On the contrary, if the rules of evidence were to be considered rules of procedural law, then the lex fori would be the law to be looked at. Anticipating the conclusion I will get to later on, it is important to highlight from this very moment on the fact that any issue concerning evidence in relation to the Convention would not be solved even with a clear answer to the question above, since such issue would need to be addressed on a case-by-case basis, starting from common principles. Therefore, instead of wondering whether an issue has to be categorized as either procedural or substantive, we simply have to decide if this subject is regulated or not by the CISG itself. Deciding whether an issue is covered or not by the CISG is particularly important in relation to the burden of proof and its allocation. It has been subject to long discussion if the burden of proof has to be considered an issue going beyond the CISG scope of application and consequently be governed by the non-harmonized national law. It has been highlighted, however, how the CISG is not an exhaustive body of rules. In this regard, a distinction needs to be made between the external gaps or lacunae praeter legem issues and the internal gaps or lacunae intra legem ones, and the way these gaps are dealt with. The principle of onus probandi incumbit equidicit non qui negat has been recognized by the majority of countries. This principle establishes, as you know, in general, that each party has to prove the existence of the factual prerequisite contained in the legal provision upon which such party wants to rely on for its claims or defenses. This does not depend only on the fact that this principle is considered a matter of substantive law, as it is often considered, but because there are inside the CISG itself clues, direct and indirect, entailing its inclusion in the CISG basic principle also. I know that Harry is not in favor, but we will discuss about that. As a consequence, even though the CISG does not contain a general rule on the allocation of the burden of proof, a rule on the burden of proof is expressly included in Article 79 of the CISG, and this is enough to rebut the argument that the CISG does not cover the issues at hand. It is important to keep in mind that the rule on the burden of proof is also essential to allow a judge to decide the case. It is indeed defined as a rule of judgment, enabling the judge to issue, in any case, a decision against the party that did not fulfill the burden of proof prescribed by law, the so-called burden of persuasion or the risk of not persuasion. In subjective terms, the party having the burden of proof bears the burden of factual substantiation. Burden of proof in its objective sense means the risk of a party bearing the burden of fact not being sufficiently established. This is particularly true and essential in the countries where gathering the evidence is on the parties and not on the judge. In this case, we talk about the burden of adducing evidence. The content of the notion is also influenced by the nature of the system in which it is used, whether it is an adversarial system or whether it is an inquisitorial one. It has to be seen as a reference to the substantive facts underlying the claims and presented by the parties, and most of the time as a connection to the procedural position held by each party. But this is not always true, and that is why it would be wrong, in my opinion, to use the expression onus probandi incumbit actori. Sometimes the legislators intervenes directly on the allocation of the burden of proof through presumption, and the example is indeed to be found in Article 79 of the CISG. But the determination of the burden of proof thus ends up being carried out by the judges based on a criteria completing and qualifying the legal case by adaptation to the specific case, such as, for example, the appearance, interest, normality, and the negative nature of the fact to be proven. We have no time today, but I think it's very interesting, also important to verify how to regulate the thema probandum. For instance, in many legal systems, not objecting to a fact means that such fact does not need to be proven anymore. But at this point, the proof of proximity criteria enters into play because consideration of equity based on the notion that each party has to prove the facts originating from its sphere support or somehow modify this rule. For example, proof by debtor that he has performed his obligation is sometimes easier than proving the negative fact of the non-performance by the creditor. In Italy, for instance, the proof of proximity principle went from being occasionally cited to be a fundamental principle of the system following a decision by the joint session of the Supreme Court on a domestic sale contract issues a few years ago. Starting from the fact that the Supreme Court stated that it is easier for the debtor to prove the performance of his obligation than for the creditor to prove the negative fact of the non-performance, according to the rule, negative non sunt probanda. But another issue strictly related to the burden of proof is the standard of proof. Different opinions exist even on this issue. Numerous scholarly writings and various case law consider the standard of proof an issue of procedural law, and therefore to be regulated by the Lex Fori, even if they believe that the burden of proof issues is within the scope of application of the Convention. Only recently, the trend has started to change. Indeed, many notable scholars consider the standard of proof to be inferred from the Convention. Using the term inferring raises the question of whether the issue is considered to be regulated by the Convention or it is instead extracted by this general principle as per Article 7.2. The question of which one is the actual standard to be sought is easy to be answered. It is logical trying to identify it within the Convention itself. The prevalent opinion believes that the reasonableness criteria should be the reference point to start from. Also in the highly unified principle of transnational civil procedure, Article 21(2), states that facts are considered proven when the court is reasonably convinced of their truth. And its commentary specifies that the standard of reasonably convinced is in substance the standard applied in most legal systems. The Article 11 of CISG states the principle of freedom of form and the freedom of evidence. It is worth mentioning that not all the delegation agreed to take this principle from the Hague Convention and insert it into Vienna Convention. In the end, this approach was accepted with a compromise, and the inclusion of Article 12 and 96 in the text of the Convention was agreed upon. The Article 11 of CISG, with the freedom of proof and its freedom of form, may in fact be excluded where one of the contracting states, within which one of the parties has its place of business, has declared the reservation contained in Article 96. Except for this limited case, Article 11 sets forth clearly two fundamental rules. It establishes, on one side, a substantive rule according to which no formal requirement is needed for a sale contract to be valid, and, on the other side, a procedural rule according to which no formal requirement is needed to prove the contract itself. The same principle is expressed included in the third paragraph of Article 8 of the CISG, relating to the proof of specific will of the parties. In one of my previous writings, I have already commented on the 1998 decision MCC Marble Ceramic versus Ceramica Nuova d'Agostino, where for the first time the court, it was a federal court of appeals, not any ordinary state court, succeeded in overriding a well-established domestic principle of law, the parole evidence rule. In its reasoning, the court did not confine itself to the mere exclusion of the application of the parole evidence rules, but it went further by creating an important precedent as to the future enforcement of the parole evidence rules. Contrary to its name, this rule was considered by the court as a substantive rule of law, since it did not purport to exclude a particular type of evidence as an untrustworthy or undesirable way of proving a fact, but it prevented litigants from demonstrating that fact. As such, it was the court's belief that the rule should not have been automatically applied by federal courts as any other proceeding matters. Consequently, under the Convention, especially in the light of its Article 8 and 11, the parties' intent, regardless of the form of their statements, must prevail, if unambiguous, even against written documents. In conclusion, as we mentioned, the goal of uniform application of the Convention can only be achieved, in my opinion, through the widest possible admission of a probative method. In my view, the only serious limitation to the free admissibility of evidence can derive from domestic public policy aimed at safeguarding well-established fundamental principles of law, and I could try to explain better in my paper. A good level of uniformity in substantive law is unfortunately still colliding with a series of potential differences that, at the judicial level, show their most problematic aspect. The tendency to ignore the theoretical classification of rules as a substantive or procedural, simply referring to what is within the Convention or not, has helped to in the resolution of the various issues, starting with the one of the burden of proof. However, this tendency is not enough to guarantee a completely uniform applicability. Personally, I still believe that the ideal situation would be to reach, if not uniformity, and harmonization of the rules on evidence to be utilized in the international cases. Consider, for instance, the principle of transnational civil procedure aiming at the reconciliation of differences among various national rules of civil procedure by taking into account the peculiarities of transnational dispute as compared to purely domestic one, but also to the draft of Uniform European Code of Civil Procedure presented by Storm Commission many years ago. Unfortunately, they do not catch a lot of attention. The big impact that the rules of evidence might have in an international proceeding made clear the need to allow and to prefer the coexistence of customary law principles set forth in different jurisdictions. I go to my conclusion. In light of this, two aspects have gained particular attention. On one side, the need for predictability, and on the other side, the strict respect of fundamental due process principles. To achieve this, the best arbitration practices have started looking in depth to the conflict and the possible compatibility between principles and rules set forth by different jurisdictions. In addition, it went further by materializing this approach into means of soft law. Consider, for instance, the Ansital Note on organizing arbitral proceedings or the IBA rules on taking of evidence. It is not a coincidence that substantive law issues originating from uniform law as the Convention have been more and more presented to arbitrators, to the point of increasing the number of awards in such matters that are regularly cited next to judicial case law now, even thanks to this moot. It is obvious that in civil proceeding, the party autonomy is weaker than that the influence of the state on its own rules is not present in arbitration. However, as we have seen before, the power of the party to achieve directly or indirectly changes to the rules of evidence that were once impossible to even imagine is constantly growing due to the increased necessity of a collaboration between the parties and the judge. However, it has to be kept in mind that there are rules that cannot be changed in the judicial proceedings that are of public nature. Hence, for the instance, the parties in arbitral proceeding can freely and by mutual agreement refer to the IBA rules. This is not possible in a judicial proceeding. In conclusion, we do have to remember that an arbitrator or a judge's freedom needs to be limited by the due process principle, which requires him to clarify to the parties which facts need to be proven, which party needs to prove such facts, and which one are the means to prove such facts, or, if that is the case, which means of evidence are not permitted. And that until the moment in which the parties cannot change or integrate their defenses any longer. That, in my opinion, simply in order to avoid unforeseen outcomes for the parties as a result of the unexpected evaluation of the evidence by the judge or arbitrators. Thank you.
Perfectly within time. We appreciate that. So we move from burden of proof and standard of proof to Henry Gabriel, who's going to talk to us about misplaced reliance on default rules in international sales contracts.
And if you don't mind, I'll sit here as well, because otherwise I'll start walking in circles and you won't be able to follow me.
You can avoid the time sheets too when you're over there.
Okay, but I'll watch that part. First of all, I'd like to congratulate Harry on his career and retirement, and I want you to know you're the only person I've ever known to retire and move north. It's a first, but it's wonderful. And thank Ron and Pitt for putting this together. And the answer to his question is we were hang gliding in Rio is what we were doing. And what I learned from Ron is if you're going to jump off 2,800-foot sheer cliffs, don't tell your wife about it until after you do it. The idea of what I want to talk about really came from as I was updating my comparative sales treatise. And the first edition was easy because I was so certain of what I was doing. The second edition, not so certain, and now I'm working on the third edition. I'm pretty sure I'm clueless. And that's where this stuff expands. And the thesis, the idea I want to convey this morning is not very complicated. It's a simple idea, and that is a structural drafting matter. If you're clever enough to put a choice of law clause in your agreement, and if you're clever enough to put a choice of court or arbitration clause in your agreement, you ought to be clever enough to get around a series of default rules that are built into the CISG that are the rules that cause the most controversy, the ones that we have the most case law out there. And I want to start off by by pointing out what I think is two sort of structural problems in this CISG that's just built in by the necessity of it. One is, what is the scope of the CISG? And the second question is, if you can figure that out, what does it mean? And those are fairly simple questions, I think, but as we look through the hundreds, the thousands of cases in arbitrations, we see that there's a lot of question of what that means. And I think a lot of the problem is, well, let's start with the ambiguous scope of the CISG. I mean, it actually purports to cover very little. The convention governs only the formation of contracts, sale of rights and obligations, seller and the buyer from such a contract. Okay, it deals with international contracts for the sale of goods. There are a lot of things it doesn't deal with. It doesn't deal with tort, agency, negotiable instruments, negotiable documents, letters of credit, all the other stuff that is necessarily going to be in an international transaction. And so we've got this structure here. We've got the CISG, and then there's everything else that would govern the transaction, the external gaps, and then the internal gaps. And the problem is, and I don't think this scope is a minor issue, the validity of standard contract terms. That's generally based on some other's law, but the meaning, is that within the CISG or without the CISG? And the answer is, go to the Clout guide and see the literally 5 pages of little print on we don't know what that is. Does estoppel, is that within the CISG or not? We don't know. When I say we don't know, we have some guidance, but there are conflicting provisions. And this gets kind of complicated because what it does is it suggests that we have to interpret a text, that being the CISG, to determine the boundaries of the text in order to determine whether we need to look at another text to turn around and interpret the text. Now, that's somewhat of an interesting academic game for professors. It is absolutely a nightmare and a burden for practitioners. Now, the CISG gives us some guidance on the question of scope. And it says, well, you know, if it's not directly dealt with within it, you can look on the general principles on which it's based, and then if that doesn't answer it, then you fall by default to whatever would be left, rules of private international law. Now, this notion of general principles on which the CISG is based, I'm not sure what they are. Now, again, when I say that in an off sense, that's a huge debate. And we can't really determine what those are. The Unidroit principles on international commercial contracts, are they the general principles on which the CISG is based? There's a lot of suggestion that they are, which I find kind of interesting since the Unidroit principles were basically drafted after the CISG, and it's hard to put the cart before the horse, sort of theoretically. Let's assume that they're there, and you just want to compare those two things. So what are we going to do? So we're going to fill the gaps with the Unidroit principles, the gaps of the CISG. Well, what are those gaps? What is the CISG? Is it the text of the CISG, or is it all the interpretation of the CISG? And I suggest that to a large extent, if you include the interpretation of the CISG, it's going to fill in all the gaps, and that squeezes out the Unidroit principles. And I just point that out as a simple exercise that we're not, it's very difficult to figure out how one would do that. Now, sometimes we try to treat this as a simple proposition. A new document that Unidroit put forth is model clauses to adopt the Unidroit principles, okay, which one has to do with a soft law instrument. And one of my favorite model clauses is the model clause that says that the CISG governs this contract, but to the extent that the CISG doesn't govern the transaction, the Unidroit principles apply. Well, that at least gets you around the third level. You've got the CISG, then general principles, and then whatever comes outside of the general principles, what's actually outside the scope. And by using a choice of law clause, you don't fall into the trap of, and everything else is governed by rules of private international law. Because the problem with being governed by rules of private international law is you don't always have certainty of what the rule would be. So you always want a choice of law clause to at least get rid of that. So that puts us in that gap there of what is what do the unit droit principles cover? And again, it's that same circularity. The unit droit principles purport to cover, certainly they cover areas outside of the CISG, but to the extent that they overlap, I don't know how to pick one over the other because I don't know where the unit droit principles are in variance or interpretations are in variance with the CISG, which would be the general principle. So I don't think a choice of law clause per se resolves this issue of what are general principles on which the CISG is based. Now, if we can get around that scope, and I just leave it on the table because I think there's a problem, then we have to figure out, well, how do I interpret what is the CISG? Now, the CISG, like most commercial codes, are primarily default rules, and that's what I want to talk about now. And of course, they're default rules. And default rules are very important in sales law and this, that, and the other. We don't really want to negotiate a contract every time we go to the store and buy a six-pack of beer and some bananas. And default rules work very well. But when we look at contracts, sales contracts, we have contracts that are non-negotiated. They're just wholly based on the underlying law, the default rules. You have contracts that one or both parties have forms for repeated transactions, and then you have actual bespoke negotiated contracts. Now, for contracts for the international sale of goods, it should be rare that you're actually going to simply rely on the full panoply of default provisions, the CISG, that you have no other agreement other than that. How do I interpret the CISG? And the CISG gives us some means of interpreting the CISG. So if we haven't said this is what's going to govern our agreement, we look at the CISG of the text. And excuse me, Article 7.1 lays it out and it says, well, it's autonomous interpretation. And we all know what that means. It means that the CISG should be interpreted in the way that the CISG is interpreted, and you should not fall back on domestic law. Okay. Now that makes a lot of sense in theory, because over the long haul, one should have a body of interpretation based on international transactions, and this domestic law doesn't pop up. But the other rule that goes with interpretation is uniformity of interpretation. And in theory, that makes a lot of sense, but I suggest that the two rules fall against each other. They grade against each other, and you get inconsistent notions, because it never will work in principle. Because the problem with the notion of this great body of autonomous interpretation of the CISG is that if you go through the cases in arbitral awards, you'll see there is no consistent autonomous interpretation. I mean, that's the whole thing. They go different ways. So how do I have uniform interpretation when the interpretations are consistently, in many areas, inconsistent in the sense that they have different views? And it seems to me it's not surprising in these circumstances that courts, on a fairly regular basis, will fall back on the closest interpretation to their domestic law. Why not? I have to pick one over the other, and I'm going to pick the one I feel most comfortable with. Now, that does, of course, go against the notion of autonomous interpretation, but it is a ready explanation for how we're getting to this problem in the first place. So it seems to me that those structural bases in the CISG And I don't see them necessarily as flaws. How else are you going to draft this thing, right? You've got 52 countries over 20 years trying to meld together all the various legal systems, and you come up with the CISG, and it's a pretty good approximation of how one would have rules that govern from a variety of legal perspectives. But having said that, we have all of these problems. And it seems to me, and what I want to just suggest is that many of the problems can be resolved by simply getting around the default rules that the CISG provides and simply put in a term in your agreement that says, this is what we want, okay? I mean, when you start with what are the goods? Well, if you haven't defined the goods, then let's walk away. You don't have you don't have a contract, okay? But then how about the price? How about the price? I remember 10 or 15 years ago standing right here having a discussion on the question of whether the CISG requires a price term. And we all know Article 14 and Article 55 and blah, 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 blah. Well, we should not be having that discussion. You know, we should not be having a discussion of whether the CISG requires a price term. We should have a price term. I mean, it's that simple. It's that simple. And if you don't have a price term, you can go through the analysis. Well, the CISG, for example, allows a price term. But what is it going to be? It's going to be somebody's determination of what the reasonable price is at the time and place. Or I tell you what it's not going to be. It's not going to be necessarily the price that either party would have reached. You know, so we can resolve that, it seems fairly well. An issue that doesn't necessarily come up because it is technically excluded from the CISG is questions of title. And American lawyers are very good at ignoring the question of title to the goods. Why? Because under American law, we don't care. Because title is resolved easily under Article 2 of the UCC, and for purposes of financing, secured financing, which very often, as you know, goes with a international sales transaction. We don't care about title because we abolished it for purposes of secure transaction. But the rest of the world hasn't. And there's all sorts of creditor and debtor rights that are floating out the side there that could be affected by questions of title. And it's just one of those things that I think we need to resolve. Formation. We law professors love CISG questions of formation and how does it resolve with other questions, and we have a dispatch and a receipt and all these different rules. Come on. Now, first of all, if we have a contract that's been performed, we're not going to have a lot of formation issues because it's hard to deny the existence of a contract that's been performed. But prior to performance, we can have these arguments. And it seems to me that it seems to me that if we're actually having a legitimate in a court or arbitration argument over whether a contract's been formed, we have made a fundamental mistake. This is how we form our contract. Here's the offer, here's the mode of acceptance, end of discussion. You know, these are questions that should not be in front of us. Fundamental breach, I love fundamental breach. First of all, I don't know what it is. Because I know what Article 25 says, and I know the general concept, and I know that it's something that's abolished, for example, in some domestic systems as a mode of getting away from the contract. But the problem with fundamental breach is, I don't know what it is. And again, when I say that's a shorthand way of saying that the way that people interpret this is so varied amongst the various courts and arbitration decisions that you can't really nail it down. And the second problem, and the more fundamental problem with fundamental breach, is that it doesn't necessarily reflect what the parties actually would want to do. Because in the case of a non-performance or a faulty performance, there's the question of under what standard should one party be able to walk away? And that is something that the party should articulate. But by relying on this amorphous concept of fundamental breach, we probably haven't articulated precisely what risk the parties would want to undertake for terms of when they should or shouldn't have to perform, and they should be thoughtful about that. Implied obligations, Article 35, one of my favorite it shouldn't be in your face situations. I don't know what, for example, fit for the ordinary course means. And I certainly don't know how long goods should be fit for the ordinary course. Those are the two factual questions that are always built in. If you're actually having a dispute over the extent to which Article 35 applies, you've probably made a fundamental mistake in your contract drafting. Get rid of the implied obligations and rely on express obligations. State precisely what it is that the seller is intending to do. Don't rely on these things. We have the same problem, for example, in American domestic law, but we don't have as many varied opinions on what that means. It's still a problem, though. As you mentioned earlier, who has the burden of proof on this? State it. Knock it off in the contract. Get that. Article 8, I love Article 8 because it lays out a layer of potential interpretation that again, we're not sure what the extent is. And not only are we not sure what the extent is, but we're not even sure how to read Article 8, right? I mean, is Article 8 to be, is it to be read by paragraph 1 actually being an exception to paragraph 2? Which is how an American would read it, or do you read it the other way? And again, I don't really think we should be having these arguments. Make it go away. Put in a merger clause. Payment. How am I going to pay? What currency am I going to pay? And if there's a question of interest, what's the rate of interest? I always found it interesting that the reason the CISG does not define a rate of interest is for the obvious reason that the drafters of the CISG couldn't agree, which is fair enough. But we can agree, so we should cover this. We should cover that. Remedies. Look, do we have a contract? What are the parties supposed to do? And if things break down, who gets what? That's it. Those are the only real global issues. Specific performance. We have these arguments, whether to the extent of specific performance. It's not much of a remedy because, in fact, in most situations, the ability to get specific performance in a timely manner makes it not much of an effective remedy. But if the parties want it, put it in and put in a mechanism for getting it. The last point I want to make is the general notion of damages. Now, Article 74 is wonderful. I love Article 74 because it says you get what you're entitled to get, which is exactly what it should say. But of course, it doesn't tell us anything. And we know, for example, consequential damages. Nobody gets consequential damages. That's the single most excluded provision in any sales contract. And the problem with Article 74 or any overarching notion of damages is it doesn't necessarily and rarely actually reflects the risk that the parties intend to undertake. If I don't perform, if I'm the seller, what do you get? Will I fix it? Will I replace it? Do you get lost profits? This, that, and the other. Those should all be specified. And if we just take those little areas that I've mentioned, and everybody's going to have a couple of more, if you put those in your agreement, you probably have gotten around the major problems that the default provisions of the CISG have caused us over, I guess what we're to the middle age now? Which is nice, it's only middle age, because I've blissfully passed through middle age, and I'm long beyond that myself. Thank you.
I want to thank our panelists for all staying within the time limit, because it gives us time for questions. There's a lot of rich material here from which to ask questions. When you have a question, we have a microphone. Rick, do we have the microphone? And so please speak into the microphone. We'll start with Professor Spencer, right here.
Thank you very much. Stefan, I have a question or comment for you. I mean, we agree on many things, but there are some things where we slightly disagree, actually. And just for information, unfortunately, we have not published it yet, but the CISG Advisory Council has decided on the black letter rules on a new opinion, dispute resolution clauses in CISG contracts, which addresses not only arbitration agreements, but other dispute resolution clauses where I think the things should be similar, but are not very much discussed. Well, the point I wanted to raise is I do not want to take a stance which law we apply to the arbitration agreement, be it the law applicable to the substance of the contract or the law of the seat of the arbitration. My point is, if you come to the decision that you apply the law of the seat of the arbitration, and this seat is in a CISG country, then in this country you have two sets of rules. You have the domestic contract law and you have the CISG. And then you have to decide which of these two laws of the seat do I apply. And actually the CISG Advisory Council, well, the reason why we haven't published this opinion yet is we have decided on the black letter rules in October last year, but the comments have not been finished yet, so we can only publish the opinions once we have also agreed on the comments, which depend on the work of the rapporteur. I think, and the CISG Advisory Council takes this position, if the seat of an arbitration is in a CISG country and we apply according to arbitration law or arbitration doctrine, or case law, we apply the law of the seat of the arbitration, then it should be the CISG if there are no indications by the parties that they wanted the domestic law, contract law of the seat.
Stefan, do you want to? We have the microphone on the table.
It's a pity that, or keep the rule for you until the moot court is over. Yeah, though I took that question already out of the moot court problem. Yeah, by putting in that in the country which may be applied, there is a rule that they apply the CSG to the dispute resolution clauses. And as I said, I'm not against, in a way that is a balancing exercise where you have to go through every single rule and say, is the CSG suitable or not? From what we have there, I think there is no clear-cut answer. Yeah? You can, 19.3 in my view says nothing about whether it's applicable to that. 81.3 is different. Yeah, you can interpret both ways. And then the question arises, which one do we follow? And I'm happy that the CSG Advisory Council has dealt with the issue, and I'm looking forward to see also, probably you have also dealt with the various rules, whether they are then applicable or not, yeah, to which extent to the various contractual obligations. And I don't have a firm point of view on that. So in my view, you can have both. There are arguments for both. Probably the better one are, in particular, if you deal with the question of inclusion of general conditions, where it would really be odd, yeah, to have one clause in the general condition which is not included because you have a slightly different rule. To explain that to someone who is not a lawyer is very difficult.
Yeah. Please give your name when you begin the question. Can we take the other microphone back if the one's not working? Okay.
Thanks. Milena Đorđević from University of Belgrade, Serbia. I would like to thank to all the speakers for their insightful contributions. I will comment on some of their presentations or include them in my presentation at the third panel. But the two presentations to Ron's, well, to our left, will not be a part of my presentation, thus I thought I should make some remarks here to you. First of all, I would like to appreciate and thank Stefan for reminding us of the difference on application of the CSG based on Article 11A and 11B. And in that regard, I would like to move to the Kosovo story, or the saga of application of CSG in Kosovo, and just illustrate the problems that this might raise by a few examples. Going back to 11A and the application of the CISG to the contracts for international sale of goods where the parties have the places of business in different states. My question would be, would a Pittsburgh court ever apply the CISG when dealing with, let's say, when having a contract between the seller from Kosovo and buyer from United States? And I will answer this if you want. I mean, and I can hear your comments if the answer is different. The answer would be no. And the reason why that is the case is because Kosovo is not a state within the meaning of Article 11A. And if you look at the UN depository list of countries members to the CSG, Kosovo is not there. 89 states are. Kosovo is still not there. And Vjosa might explain later on, as she has written amply about this topic, on the potential for succession of Kosovo to the CSG. I come from a country that does not consider Kosovo an independent state. So if I were to ask a question whether a Belgrade court would ever apply the CSG on a contract of sale between a Belgrade entity and Kosovo entity, the answer would be no. And not because of these issues that I have mentioned, not because of not recognizing Kosovo as a state, but because we recognize this as a domestic transaction. So the Serbian law of obligations would apply to a sales contract dealing with Kosovo and Belgrade party. And then the next question or the next scenario might be, would a Madrid court, Athens court, Moscow court, Beijing court, New Delhi court, Sao Paulo, Buenos Aires, Mexico City, just to name a few, would they ever apply the CSG with a contract between Mexico seller, for example, and Kosovo buyer? And here the answer is yes. Based on 11A, because these states do not recognize Kosovo as an independent state, but they would deal Kosovo entities as coming from Serbia, which is a CSG member state, and thus the CSG would be applicable. Thank you, that's all.
Yeah, I would suggest perhaps a different answer on the first scenario, the Pittsburgh party with the Kosovo party, because it seems to me, and what we see here, it seems to me, is that not only are there problems of private international law, there are problems of public international law in the applications here. And Kosovo is one of those great examples. But I would think in Pittsburgh, it seems to me, and you took us in a little different direction, Melania, but if the judge says, well, we're not certain Kosovo is a state, if you say it is a territorial part of Serbia, then 11A gets us there. And if you say it is a separate state, Kosovo, and Kosovo, and if that, quite frankly, if that judge looks on the UNCITRAL website, you'll see Kosovo as and that's interesting. Do we refer to them as a contracting party or a contracting state? And I would suggest that a U.S. judge might well rely on the UNCITRAL website and say, in that case, 11A gets us there too. It seems to me that whether you take the idea that it's still a part of Serbia, you get to the CISG, or if you consider Kosovo independent and look to the UNCITRAL website, you get to the CISG application under 11A as well. And I'll let Vjosa, did you want to?
Yeah, if that's possible. Sure.
The
Does the mic work here?
The mic right there, to your right.
Oh, okay. Kosovo is very much a state within the meaning of the CISG. It has been recognized as such by 160 members of the 16 members of the United Nations, including the United States, Germany, and I think practically every country from which you guys come from, apart from Serbia, if I'm not mistaken. Do we have anyone from?
Bosnia.
We know the reasons why Bosnia doesn't recognize Kosovo. Everyone does, because of a very bad international experiment with that country that has gone through hell. For every single judge, either in the United States or in any other recognizing country that understands well the principle of succession in international public law and has studied this principle well, and also understands what the principle of automatic interpretation of succession means, they might take into consideration the fact that on the day of the Declaration of Independence, through its Declaration of Independence that the ICJ considered to not violate international law, a case where I represented Kosovo, by the way, and also through its constitution, Kosovo undertook, through succession, to implement every single international treaty to which Yugoslavia was a party. So if a judge understands that principle, they might consider Kosovo a party from the day of independence, because that would also be the interpretation according to the Vienna Convention on Succession of Treaties. Now you would ask why Kosovo is still not listed in that UNCITRAL website. It's not because it's not considered a state, because keep in mind, there are some UN conventions that are only open to members of the UN, but the CISG is not one of them. It's open to all states, therefore it falls within the all states formula. Now, the reason why we're not in the list is purely administrative. Countries have been required to send a very bureaucratic document, which is called the Notice of Succession. There's this, huge practice of the UN Secretary General as depository to UN treaties, including the CISG, which shows how that goes. And it explains basically, one, that it's an administrative document to make the job of the depository easier, but that does not have the legal effect. Let me take the example of Macedonia, which, although it sent the Notice of Succession about 10, 15 years after independence, if you see which is the date under which is listed when it became party to the convention, it has a retroactive effect. So they take the date of independence. It's the same with every other country, not just in former Yugoslavia, but other countries as well. So it's not the date when you send that letter, but it's the date when you become independent that UNCITRAL consider you to have become a party to the CISG. So we consider ourselves, through the principle of succession, and because through the Declaration of Independence and our Constitution, we're applying that principle to be a party to the CISG, but because of bureaucratic issues, obviously, we're still, and purely political issues, as you've noticed now, we're still not listed there. I'm sure that we're going to resolve this problem. So although right now we have 116 members that recognize Kosovo, and of course it would depend, as I said, on how much the judge wants to get into the international public law issues rather than just look at the website. If they just look at the website, we know the answer. But for these 116 countries that have recognized Kosovo, the answer is definitely not, let's consider Kosovo part of Serbia and therefore apply the CISG through 11A, because they don't consider Kosovo part of Serbia. They consider Kosovo part of Kosovo as an independent state within the meaning of the CISG.
Yeah, I would say on this issue that this is not a question that's unique to Serbia-Kosovo, and it's not unique to the CISG. The same questions arise for the New York Convention. Palestine is an example of a question of where does it fit in this, and these questions of where it fit. What you see, though, is an example of the richness of the discussions we have in our LLM classes here at the University of Pittsburgh, because we do draw from the Balkans a fair number of students and work with their Vismut teams, and it's a wonderful process when we get together and have those discussions. We have time, I think, for one more question. Oh, we had Professor Magnus, and then two more questions. Professor Magnus and Professor Kåre.
Just for the last point, it would be very helpful if Kosovo would apply for being included in that list, like Palestine did. that would clear probably for everybody the situation.
I agree.
I would like to come back to Stefan. You constructed actually a sharp difference between the US courts and the German Supreme Court with respect to the separability of the arbitration agreement. And you quite rightly cited a quotation from that judgment. But if you read that judgment, there are also other parts in it which probably show that it is misleading to say the validity as a whole is outside, and that includes the formation of the arbitration clause or contract, is outside the CISG. I think if you read the judgment as a whole, you see that the court meant only the substantial validity, and that is outside according to Article 4 of the CISG anyway. And therefore, I wouldn't go that far to show such a sharp gap between those jurisdictions. I think what you in the end said, the formation rules of the CISG should apply, and also the German Supreme Court would probably follow that aspect. There are other decisions that go at least a bit in that direction.
Do you want to comment?
Yeah, as you rightly said, I'm not sure whether they really dead on with substantive validity, because the question was the form requirement. The form requirement, the way they understood it, is largely formation of the contract. Yeah, so it's, and there they clearly said this is not covered by the CISG, though they were referring all the other times to the CISG. As I said, this judgment is not 100% clear, but in the official thing that is the translation of the official head note, yeah? But the Supreme Court has done on several things. The official head notes are not really reflecting what they do. But there is, in the other case law dealing with arbitration, where it was not really an issue, you have there's two decisions from 2017 where the Supreme Court left it open, yeah? So they are considering that to be at least a question. What I wanted to show, that is not a clear-cut. It's not the American approach. You don't look at it at all. You just take it for granted. Yeah? The difference here is that the German Supreme Court at least says there is a problem. In most of the cases, we left it open. The one case where it played a role, the formation of the contract, there they came up with at least the general head note where they said for the formation of the contract, as far as the form requirement is their concern, where the CISG is not governing the issue.
Okay. Last question, Professor Korb.
Yeah, hi. My question is for Henry. So I think we know why many parties don't draft their contracts in the comprehensive way you're recommending. It's just because they're short on time and they don't really want to be bothered. They think the relationship's not going to go sour, so it's all going to work out. So we're not going to waste time paying lawyers to draft these provisions. But to get around that, you choose a body of law that has default rules that will then supplement the holes in the contract, so that things do go bad, you know sort of what probably will happen. And I take from your comments, you just think people should be better contract drafters, which I think we can all agree with, right? But I think that the question I have, so it depends on how comprehensive you want to be and what issues you want to address are going to be shaped by what you think the governing law is going to be if this thing does go into a dispute. And I know that a lot of these parties in the United States, they may choose the law of Pennsylvania, not realizing they're going to get the CISG if in fact this contract is an international sales agreement. So I guess, how would you advise these folks who aren't, they're not sophisticated drafters, they don't really know what they're going to get? Should they be drafting better contracts with an eye to Pennsylvania contract law? Should they be drafting better contracts with an eye to the CISG, with an eye to both, recognizing there are costs in doing it this way? And if you have a form contract for your agreement, for your company, how much tailoring do you really need to sort of solve all the problems that you're identifying?
Well, my position is rather optimistic. And I say that having yesterday graded my sales finals and noticed that 2/3 of the students could not accurately point out to me that the law of New York State happens to be the CISG. So we're not going to get there. The point is, if you can disclaim the CISG, and that gets rid of some of the problems, but then you just walk back into a whole panoply of other problems. Because the difference, for example, between the UCC and the CISG is the UCC is vague and the CISG is vaguer in the sense of interpretation, because you have a broader range. So you're either going to stumble into a small hole or a large hole. And what I was trying to talk about is, here's a way to try to stay out of the large hole, and merely moving to the small hole solves it somewhat. So yes, what we need, I suspect, is some form to say, look, these are the issues that that you should try to deal with, understanding time, resources, and this, that, and the other. And the fact is that 98% of the transactions are going to work out just fine anyway, and so we don't really care. But there is that balance, and I think that just falling back to the small hole, which is the disclaim, is not really solving the problem. So if you want to address the problem, you have to do something sort of optimistically, like I'm suggesting. I don't know if that answers it, but it's...
That question, 2 points that leads us to, what is, in 2005, we had this wonderful conference on drafting into the CISG, where we provided sets of, not only identified the issues, but provided clauses, and Susanna Cook provided a full set of general terms and conditions for the seller. People just haven't read the book enough. But all of that leads us nicely to the panel that's going to be after our break, which really gets into opting in, opting out, and contract issues. But before we take that break, I would ask you to join me in thanking our panelists this morning. We are scheduled to have a 20-minute break and be back at 10:10. That's only 15 minutes from now, so we'll be back at 10:10, and we will start at 10:15.
So, all right, everyone, if we can take our places. The next panel is coming up, and we want to make sure we give them the time because it's an amazing panel. I am Harry Fleckner, for those of you who don't know who I am, and very good. And nice to meet all of you, too. I've reached that point in my life when I can't remember anything, so it's wonderful to have a chance to meet you all again, as a matter of fact. Yes, I haven't been around to the law school here since the beginning of the semester, so everybody here has forgotten me also. But it is my extraordinary pleasure to be the moderator for this next panel, which I think is going to be really fascinating. I am going to keep my introduction extremely brief because the bios of all the participants are in the program, and because it would take all of the time in order to do justice to any one of the people who are going to be speaking in this particular panel. Our first speaker is Ulrich Magnus, who for virtually everyone here needs no introduction anyways, but is of course the professor for civil law, private international law, and comparative law at the University of Hamburg, and that barely scratches the surface, but I will let him take over at this point. Thank you.
Dear Harry, dear Ron, dear friends, and ladies and gentlemen, it's a particular pleasure to be here and to attend the conference in honor of Harry. Harry is one of the leading experts global experts on the CISG, and I'm particularly glad to have the honor to say some words on opting in and opting out. Can there be uniform interpretation, or does variatio dilectat given. I would like to start with a little story. First, a short survey what I'm going to do. Introduction, what is desirable, what is the present status, summary and conclusions, very short. But now with a little story, namely by Franz Kafka, written 1915. A man comes to the law, and there is a gatekeeper at the door of the law. And the gatekeeper says, you may enter, but there are horrible dangers there. The man decides not to enter at the moment, and he waits and waits, in fact, all his life long. Shortly before his death, he asked, why is there no other person coming to enter this door? The gatekeeper says, the door was assigned to you. I will close it now. That, I think, is a sign for many who do not like to enter the CISG. They are not cautious enough, actually. This is with what we start, and now what is desirable in respect of the uniform interpretation of the CISG. I think uniform interpretation, that was already said today, is a desirable aim, but Harry pointed to the fact, and not only he but others also, that the CISG itself says there are other aims that must be taken into account when interpreting the CISG, namely regard to the international character, observance of good faith, and there might be differences between a uniform interpretation on the one hand, a completely uniform interpretation on the one hand, and a reasonable interpretation. In this last case, I would always prefer the reasonable interpretation. Even if there is a uniform, almost uniform stream of understanding, there might be sufficient reasons to go another direction, into another direction, and form and support another interpretation, if that is reasonable. So, that is what is desirable, as uniform as possible, but also reflecting on certain limits of that uniformity. What is the present status? First, the convention is automatically applicable if the conditions of its application are met. So for the opting out, the parties must do something. They have to agree on the opting out, and there is the question, have they to do that expressly or implicitly? The text is unclear in so far. The parties may exclude the application of this convention, or subject to Article 12, derogate from it, or vary the effect of any of its provisions. From that text, some older US decisions inferred that only an express exclusion was possible. Here the mainstream is clearly different. It's the international overwhelming view that the exclusion can be implicit. So we, as Harry put it, have to regard these old US decisions as loose language. In fact, it was not decisive whether the exclusion was expressly or implicitly in those cases. As Ingeborg just mentioned, the exclusion is a question of agreement and intention of the parties. And that should actually in each single case be decided. But there are typical situations. And if there are no signs to the contrary, you have first the choice of court clauses, and you can assume that the choice of a court in a non-CISG state is an exclusion, always in the absence of contrary indications or indicia. The choice of a CISG state, of a court or courts in a CISG state, should be regarded as the choice of the CISG, implicit choice of the CISG, no exclusion. Choice of jurisdiction clauses, where there is an exclusive choice of jurisdiction in a CISG state, that is no exclusion of the CISG, where it's a choice of exclusive jurisdiction of a non-CISG state, that should be regarded as an exclusion of the CISG. Almost the same with arbitration agreements. I fully support the view that where the seat of the arbitration is in a CISG state and the arbitration tribunal would apply the law of that place, then that should be the choice of the CISG and no exclusion of the CISG, and vice versa, where the seat is in a non-CISG state, the exclusion of the CISG. Conduct during proceedings, very often parties or their representatives plead on the basis of national law. That should be taken as an exclusion of the CISG only where it's clear that the parties or their representatives are aware that the CISG might apply. And I would recommend that judges should point to that aspect and give a hint to the parties that in the case the CISG might apply. Other situations may include, for instance, references to a specific national code, for instance, the French Civil Code and provisions of that code. It's regularly an exclusion of the CISG then in those cases. I have some examples here. First, English law is chosen regularly exclusion of the CISG. Why? England or Great Britain is no member state, no contracting state of the CISG. Swiss law is always the inclusion of the CISG because Switzerland is a CISG state. French law under exclusion of the CISG, that is also a clear express exclusion. New York law applicable, that's normally no exclusion of the CISG, but it is the application or the implicit choice of the application of the CISG. Why? The CISG is applicable to New York on the construction of the whole state, actually, and on the constitutional law, and therefore New York law is always, if there are no indicia to the contrary, leads to the application of the CISG. Australian law applicable under exclusion of ancestral law in an international sales contract. Exclusion or inclusion of CISG. It has been understood by an Australian court as an exclusion of the CISG because ancestral law in that case would only mean the CISG. All disputes and disagreements are to be settled on the basis of actual legislation of the Russian Federation. The Russian International Arbitration Tribunal held that as an exclusion of the CISG, although the CISG is material part of Russian legislation, actually. Therefore, I would not agree with the outcome of that interpretation. I would decide other way around. Choice of an Incoterm is always never an exclusion of the CISG. The CISG is only excluded in so far as provisions of that specific Incoterm is in deviation of the CISG. Doubtful, exclusively Austrian law, except private international law and UN sales law. Under German grammar, the comma after in private international law would only mean that private international law is excluded, not the UN sales law. Nevertheless, the highest Austrian court said that meant the exclusion of the CISG also, but the court relied mainly on the intentions of the parties. Supplies and benefits shall exclusively be governed by German law. The application of laws on international sales of movable objects and on international purchase contracts on movable objects is excluded. That was meant by a US court. What would you think? May I ask you? The application of laws on international sales of movable objects is excluded. The court held that was no exclusion of the CISG. Why not? Because there is no international sales law of movable objects. And then the court said objects means to object against something, and that wouldn't fit here. A strange interpretation, I would say, but nevertheless, the court so decided. Law governing this agreement as per European Common Market, EU, that was a case I myself had in the Court of Appeal in Hamburg. Exclusion of the CISG? No. Why not? There is no European Common Market sales law or law, so far at least. We have the European Directive for consumer sales, but not for merchants, and therefore that was also no exclusion of the CISG as one party argued. Opting in. This is a rare case, and there are some controversies, more in theory, not in practice, I must say. In principle, such opting in is always permitted. However, choice of the CISG cannot oust applicable mandatory law, especially consumer law, cannot be ousted by the choice of the CISG. You may choose the CISG, but you cannot free yourself from the mandatory law of the otherwise applicable law. That is at least the prevailing view. The substantive scope can be extended to other contracts, for instance, distribution contracts, and also for excluded goods, ships, planes, and so on, but not to sales by execution. Oh, I must hurry on. Next point, summary and conclusions. There are certain stable rules. Almost complete uniformity, that means exclusion of the CISG as a whole is possible, but must be expressed in clear and unambiguous way. Otherwise, it's not valid and does not replace a CISC. Choice of the law of a non-CISC state is regularly an exclusion. Choice of an Incoterm is no exclusion, and the parties can opt into the CISC. These are clear rules that there is almost global agreement on that. Then there are rules with clearly prevailing views. Some courts are of different view. Expressed but also implicit exclusion is permitted. For express exclusion, unequivocal circumscription without necessary use of the term of CISC possible. Implicit exclusion must be particularly clear. And there is no general presumption of an intention of the parties to exclude the CISC. Then I will not repeat the rest that was also already said. Then there are rules where we have a prevailing view, not a clearly prevailing, but nevertheless a prevailing view. And in most cases, I think we can and should follow those views. Opting into the otherwise not applicable CISC is generally accepted. Though details are still disputed, not many details are very much disputed. That is a rather rare case at the moment. The choice of the CISC instead of national law depends on whether the applicable conflict of laws permits such the rules on conflicts of laws permit such a choice. That reminds you probably also on what Stefan Kroll on arbitration already mentioned. The choice of the CISC cannot circumvent the mandatory provisions of the actually applicable law. Then the extension of CISC's temporal and territorial scope is unproblematic. CISC can be made applicable to contracts and goods outside its original scope and application. International case law. When we look in essence on summing up, there is much greater uniformity than diversity. It's globally accepted that exclusion of the otherwise applicable CISC should not be assumed lightly. There is almost unanimity on a number of central rules, and at least a clear prevailing view on quite a good number of further rules. A certain degree of differences in the interpretation of single CISC exclusion clauses, like the Russian clause, for instance, or the clause in that German case I had, that I think is unavoidable. Taken together, and this is not only for the opting in, opting out issue relevant, but I think for the whole interpretation of the CISC. That is what we most probably can reach. It can only be expected that there is a certain extent of uniformity, but no completeness, no complete uniformity, at least as long as a world court is lacking. When we come back to Kafka's Before the Law, one can only encourage to enter the CISC and to follow the lead of Harry, who explored the CISC cosmos in all its breadth. Thank you for your attention. So, thank you.
So I think, having looked at the examples that Ulrich put forward of attempted choice of law clauses, we can all agree that what Henry recommended in the first panel is certainly a wise idea, and we can all despair that it will ever be achieved, unfortunately, the way things go. You may have noticed a certain theme that is running through this particular panel, as Ulrich talked about opting out. And our next speaker, John Coyne, who is and I have to make sure I get this correct from the bio, the Reeve C. Ivey, the second-term professor of law at the University of North Carolina, and who has done some very interesting work, and will also be talking about opting out. I do. You do. Yeah, I'm really highly techy, as you can see. I didn't realize that.
Here we go. Fantastic. Okay. Thank you all. Thank you, Harry, for the lovely introduction. Thank you, Ron, for having me, and for everybody else for being here today. It's really a thrill to be here to present my work to you guys, and I hope it sparks some interesting conversations. So my project, the presentation I'm going to give, is about CISG contracting in the United States and Canada. And to set up the project, to set up the terms of what I'm trying to do here, there are many ways of trying to evaluate whether the CISG has or has not been a success. And across a great many metrics, the CISG has been a spectacular success. In terms of number of ratifications, it's one of the most ratified commercial law treaties in history, widely adopted, commercial, sort of large states, small states, developed, undeveloped, it's just been adopted everywhere. In terms of its drafting, I think everybody who has read it, Henry's concerns about its vagueness notwithstanding, vagueness is the price you pay when you're trying to harmonize the sales laws of many different jurisdictions. I think most people agree that the drafters did a very, very good job on that. And in terms of substantive harmonization, the CISG is trying to solve a problem. We have dispersed and disparate national sales laws, and by bringing them all together and sort of saying this is the rule, it solves that problem. So across all these metrics, I think we can all agree the CISG has been a resounding success. My paper, my project today, is looking at one other metric of success where perhaps the evidence of success is a little bit more equivocal. And this is the question of how often the CISG is actually used in practice. As we all know, Article 6 gives contracting parties the power to essentially opt out. If they don't want the CISG to supply the governing law, they can include in their choice of law clause a statement saying, don't do it, as we just heard from Magnus in his work. And the question I set out to answer is, well, how often does this happen? Is this common? Is this uncommon? Do people often opt out? Do they rarely opt out? How exactly do we see this playing out in the real world of contracts? Now, to answer this question, I was sort of limited because most of the time contracts are not out there to be found by researchers. They're tucked away. They're in computer hard drives. They're in file cabinets. They're not easy to find. However, there are batches of contracts that one can actually lay eyes on, and these are contracts that are filed in the United States by public companies. These are material contracts. And public companies in the US are required to file these things with the Securities and Exchange Commission, and these contracts are then made available online. You can search and read exactly what's in these contracts. Some of these pieces are redacted, but for the most part, the contracts are there, and the choice of law clauses are almost always there. Similarly, Canada requires its public companies to file its material contracts with the Canadian Securities Administration, the CSA, and this is also a group of contracts you can actually see what they're saying and review the actual choice of law clauses and agreements to see how they're dealing with the CISG. So I looked at an enormous number of these, more than 5,000 contracts referencing the CISG in the United States, and about 270 odd contracts in Canada doing the same to see, well, why are people talking about this treaty? Are they talking about it to choose it and make clear they want it to apply to their transaction? Or are they talking about it to exclude it as a source of governing law? What I discovered is that, at least in the United States, overwhelmingly the parties reference the CISG to exclude it as a source of governing law. 99% of the contracts I looked at said, we're excluding it, right? 1%, 61 contracts out of 5,000 odd contracts said, we want to choose the CISG, which is interesting. But this is over, remember, quite a time period. It's from 1996 to 2014. And when you look at the pattern of contracts I found that are opting in, that are naming the CISG as the governing law, what you see is the number is actually weirdly going down over time. You have this huge spike in 1998, which To be clear, it was the result of one very enthusiastic company in Massachusetts that just loved the CISG, and it was entering into lots of material contracts that year. It was a biotech company. They had like 6 or 7 that were all choosing the CISG. So that's where that spike in 1998 comes from. All the rest are just kind of random contracts over the years filed by companies in which the CISG was chosen as a source of governing law. And you would hope that over time, maybe you see a slight uptick in how these things are being played out, but the contracts I looked at showed the opposite. You're actually seeing fewer opt-ins in 2014 than you saw way back in 1995. In Canada, I didn't find a single one of the contracts I looked at that was naming the CISG as the government in order to choose it, right? All 277 contracts in the Canadian CSA that I pulled were mentioning the CISG to opt out. Okay, so the takeaway here, the initial takeaway, is that when you look at these publicly available contracts from companies in the United States and Canada, you're not seeing any evidence that the people drafting these contracts, the companies entering into these contracts, are choosing the CISG with any regularity. All right, so that's the takeaway. But again, there are some objections to saying, well, what about this, right? The first objection one might raise, and this is an entirely fair objection, is look, these are not ordinary sales contracts, right? These are material contracts, which by definition are important contracts not concluded in the ordinary course of business. And moreover, these contracts are all being entered into and filed by public companies. And public companies are maybe not your typical company. They are generally larger, wealthier, better resourced than the average company. Yes, this is absolutely right. You could say that this information I'm presenting is biased in favor of these things, and therefore it may not paint an entirely accurate picture. You could say, however, that, well, okay, fine, fair enough. If we stipulate this is how public companies in the United States and Canada are doing this, I would be curious to hear, well, why would the private companies be doing something wildly and radically different, right? I mean, is there really a compelling argument that, yes, all the public companies are opting out, but the private companies, the smaller companies are opting in? That might very well be happening, but I'd be curious to hear the sort of the story about how that would happen, because by and large, in my experience, the smaller private companies follow the lead of the larger public companies, and you don't usually see a disparity in the way they're doing their contracts, and certainly not in the way they're doing their choice of law clauses. Another objection, though, and this is also an incredibly fair objection, is that, look, Coyle, you're only looking at one thing. You're looking at contracts that expressly reference the CISG. They're naming it. And most of the time, you're only going to name it to opt out of it, right? If you want it to apply, you can just choose the law of New York, again, as Magnus was telling us, or choose the law of a Canadian province like Ontario or Quebec, and not mention the CISG. Don't mention it at all, but the parties all kind of know that, look, if this is an international sales contract, and if the counterparty is in a state that has ratified the CISG in the US or not in Canada, well, guess what? You're going to get the CISG even if it's not expressly mentioned in the contract. So what you're looking at here is sort of missing it. You're sort of getting some piece of it, and that's interesting. But what about this other way of choosing it that's more indirect? How can you be sure people aren't choosing it that way? Well, to try and answer that question, well, to respond to that, right? First argument I would say, well, I don't think that's probably what's going on here, is that I was once a corporate lawyer, right? I sat around drafting contracts for clients. I worked with a lot of other corporate lawyers. And one thing I can say about corporate lawyers is they're not like people who like to hide the ball, to be very honest, right? They don't like drafting these sort of contracts and aren't saying what they mean. I think if they really wanted the CISG, they would say so, right? I don't think they would rely on these sort of, well, we're choosing New York, and in choosing New York, we know we get CISG. They might be doing that. I can't prove that they're not, but in my experience, that's not the way corporate lawyers drafting contracts tend to operate. They prefer contracts that are clear to contracts that are opaque or oblique. So I'm not convinced that that's sort of a drafting decision most corporate lawyers would make, at least not in the US and Canada. Second, there's actually some reasons why you may want to name the CISG as the governing law if that is in fact what you really want. What are some situations where you might want to do that? Well, distribution agreements. Again, Magnus is just telling us it's not clear. In fact, it seems to be that maybe the CISG doesn't usually apply to distribution agreements. Maybe if you want it to apply to yours, you want to say so in your contract. Software contracts. Is software a good? Well, we can argue about that for a long time, right? There's at least some reason for ambiguity, so maybe if you want the CISG to govern your software contract, say so. And people don't seem to be doing that. Counterparties in Hong Kong. There are all these cases in the United States where the US courts are trying to figure out, well, is Hong Kong a party to the CISG or not? Some have said that it is, because it's part of China, and China is, part of the CISG. Some have said that it's not, because it's not really a part of China, right? So that's sort of a debate ongoing there. Again, if you're contracting with a Hong Kong counterparty, say you want the CISG to apply, if that's what you want, And again, we're not seeing any evidence of that. What if you have a counterparty that has different places of business, some of which are in a CISG ratifying state, some aren't? Maybe choose it then. We're not seeing that. And sometimes, again, in a lot of companies doing business cross-border, they may not want to choose the home state law of the other company, right? They don't want to give them the home state advantage in any litigation or arbitration, so they want to choose the law of a neutral state, right? You often see people choose the law of England or the law of Switzerland or perhaps the law of Singapore as a neutral. We're not choosing your home law, my home law, we're choosing a neutral home law, we're choosing this national body of law. Why not choose a CISG, right? You could do that very easily. It's sort of what its intent was, kind of almost as a neutral law. And again, you're not seeing that happening either. So again, if you were truly seeing this sort of subterranean enthusiasm for the CISG, where people really supported it, even though it's not showing up in the contracts I'm looking at, you would want to see some opt-ins, and at least some of these situations to suggest there's some support for it. And again, in the contracts that I looked at, I just didn't see very much of that, at least not, again, among public companies in the United States and Canada. All right, but I recognize that people may not again, be convinced by these arguments. I did more. I went back into these databases maintained by the SEC and the CSA to look for other contracts. I looked for international supply agreements, right? Contracts for the sale of goods between two contracting states, both of which had ratified the CISG, that essentially had a choice of law clause that didn't name the CISG, but that chose the law of a US state. Right? And because of the rules we know about, if you choose the law of New York without mentioning the CISG and it's an international sales contract, guess what? You're going to get the CISG. So I found, 44 contracts. I started off with 5,000 contracts, right? But after scaling them all down, I got to 44, where I said, you know what? I really think the CISG would apply here. They didn't mention it, but I think it probably would have gotten there. Is that what they meant? Is that what the parties who drafted this contract, the companies that did this, is this what they wanted to see happen? And so I sent letters to all 44 of these companies saying, hey, look, you guys, you don't know me. I'm just sort of rando, calling you up, asking about your contracting practice and your choice of law clause in this contract 10 years ago. But bear with me here. When you chose the law of Florida in this international sales contract, were you secretly wanting to get the CISG or not? And here are the responses that I got. The first one, we did not consider the CISG at all. The second, we had no clue. The third, we did not intend for the stated choice of law to be eviscerated by the CISG. We have an updated provision in our new contracts to explicitly disclaim the effect of the CISG, but several legacy agreements done when we were less sophisticated have not been updated. We do not have a policy of choosing the CISG indirectly, and we would affirmatively state if it was to govern, if that was the intent. We would never select the law of Indiana, say, as a means of getting to the CISG. We are just not that Machiavellian. And last but not least, I would bet that the folks on both sides of the agreement were not aware of the CISG and the manner in which it trumps local law. So again, the evidence here that people are sort of secretly evidencing their preference for it by choosing the law of a US state, knowing they're going to get it, it was not borne out in the interviews I conducted and the email exchanges I found, right? There was one particularly illuminating exchange. There was only one time, so I sent a letter to both sides of the transaction. Most of the time, it was one of the US companies that responded, but once I got an email from the president of a US company saying, you know what, I don't know exactly what was happening there. We normally exclude the CISG. It must be our counterparty. You must have insisted that it be written in. The Swiss counterparty also wrote to me to say, our policy is to exclude it. The American company must have insisted upon it. That's the only thing we can explain, right, why that would have happened. So again, I just wasn't finding the enthusiasm for the CISG I was looking for. The same results obtained for the Canadians. I looked up a bunch of Canadian companies that had contracts to which the CISG probably would have applied because they select the law of the Canadian province, sent them similar letters. The responses I got, I don't think people realized that the CISG was immediately applicable. I ordinarily carve it out. In retrospect, we would have carved it out. I wasn't aware of it. We're not as smart as you. That was my favorite response, right? We're not as smart as you, and we did not consider either including or excluding the CISG. It was never discussed or considered in any manner. My intention in choosing Texas law was to exclude the CISG. All right. There was one response, right? And I apologize, the line, so it's supposed to be right above this line, not going through it, right? It's the formatting got messed up. This was from a non-lawyer. It was from a guy who basically does a lot of contract work for a company in Quebec, a biotech company in Quebec, who's kind of like, you know what, I kind of like this treaty. I kind of like the CISG. I've never worked with a lawyer who wanted to exclude it kind of all as a matter of course. We always look at whether or not we should or shouldn't and base our decision on that particular analysis. And I was like, okay, finally, Finally, after 3 years of looking, I have found someone who is kind of excited about the CISG. Maybe the difference here is Quebec. Maybe Quebec is coming from a civil law tradition. They speak French. We all know the French are kind of more excited about the CISG as an ordinary course of things than perhaps the Americans are and the Canadians are. Maybe there was some sort of difference between French Canada and Anglophone Canada when it comes to the CISG. So I kept going, right? Again, I just like collecting these things. I just keep going, right? So over Christmas, I randomly emailed 30 commercial lawyers in Quebec, right? Did a search for the 10 largest firms in Quebec, tried to find those lawyers who represent entities doing commercial trade and things like that. And I randomly emailed 30 people to say, hey, look, again, you don't know me, I'm just kind of a random person, but tell me, what do you say? Are you guys generally excluding it? Are you generally using it? Like, what's your general course of practice here? I got 9 responses, which to me was incredibly high, given the fact these people had no idea who I was. 5 of them said, we always exclude it, right? Just like everybody else, we're just out of this thing. 2 basically said, interesting, they said, when our Canadian clients are sellers, we exclude it. But when they're buyers, we generally prefer it. Unfortunately, our foreign counterparties often insist on the application of their own home state law and the exclusion of the CISG, so we don't always get it. That's what we recommend our clients do. And then 2 lawyers basically said, well, it depends, sometimes this, sometimes that, we don't really know. So the takeaway here is that, generally speaking, my research here shows that U.S. lawyers generally opt out of the CISG, and in fact, there's very little evidence to suggest that most U.S. lawyers who know about this would opt into the CISG, whether expressly or indirectly by choosing the law of the U.S. state. Canada, the results are generally similar, but there is this tantalizing hint out there that perhaps lawyers in Quebec are perhaps more open to and receptive to the CISG than lawyers in Anglophone Canada, and that's a topic that I didn't have time to sort of follow up on, but it's a topic that's worthy of further research. However, and this is sort of like just a cautionary note, in the course of researching this paper, I came across this statute that was enacted by Newfoundland and Labrador. And the statute in Newfoundland and Labrador basically says, and this is in the implementing legislation in that province to give effect to the CISG, that if you are in that province, and if you have a contract, an international sales contract that selects as the governing law, the law of a province in Canada or something like that, this statute directs courts in that place to interpret the selection of that provincial law to exclude the CISG, which is, again, as Magnus was saying a moment ago, not the ordinary rule. The ordinary rule is if you choose the law of a province or a U.S. state, you're implicitly choosing the CISG. In Newfoundland and Labrador, you're actually seeing a statute that directs courts to reach the opposite conclusion. All right, a couple of final thoughts. So you can think about the CISG in many different ways. And one way to think about it is as a product, right? It is a product that was designed to solve a particular problem, which is these inconsistent national sales laws, try and harmonize law across national borders. What we have seen, what I am seeing at least, is that this product is not gaining any market share in the United States and Canada. Okay, it's just not. People don't seem to be picking up on it, using it, sort of moving towards it. And it's been 30 years. It's been a while. So the question to ask now isn't to sort of blame the US lawyers and Canadian lawyers for being foolish, for not appreciating the merits of the CISG, right? It's not to that. It's to ask ourselves why. Why is it that this particular product isn't getting any market share in the United States and Canada? It's a really interesting question. It's a really complicated question. But again, I think that's the question we should all be asking ourselves. And also, again, I realize that there are sort of methodological issues with the way I've done this, right? And I recognize that you can sort of not be convinced by the contract analysis I performed, but I do think it's useful. It's shining lights on certain aspects of contract practice that really haven't gotten a lot of attention before. And I would love it if it were possible to replicate this analysis to see whether the United States and Canada are outliers in the sense that they are sort of largely skeptical of the CISG and their contracting practice, or are they more typical than we would appreciate, right? Again, it's hard to find these sort of databases of contracts in other countries, in part because other countries take data privacy more seriously than the US and Canada do, so there's that. But if we could somehow find these sort of repositories of agreements in other countries, replicate these studies and sort of see if we're seeing different patterns of practice, that will be a really interesting step forward, I would think, in figuring out how actual parties drafting contracts deal with the CISG in the real world. Thank you very much.
Well, thank you very much, John. I'm going to try and do this in order to bring up the PowerPoint of Susanna. Let's see, I think I'll get it. That is a unlikely scenario. There we go. Yep. It's good? That's the right one, right?
That's the right one.
Okay. And we'll do this. There we go. Good, I think I did it. I do wonder if anybody out there is expert enough on Canadian law to tell us whether a provincial law that in fact is a treaty obligation under the country's treaty would in fact stand up. That's an interesting question, because I do believe those provincial laws in fact do violate a treaty obligation pretty clearly. Not that the United States doesn't do that routinely itself. So just a thought about it. Well, our next speaker, and this is interesting that this is the, I don't know, the all about, not the CISG in a certain sense panel, because all three are talking about opt-out, and Susanna Cook is going to be talking about it from the perspective of someone who's actually involved, very heavily involved, as you see that she is the international group partner at Cohen and Grigsby, and has dealt with this a lot. She's also the person who in this entire room has probably done more to try to make the CISG practically applied by drafting a full contract, a full-form contract that is available, as Ron mentioned, to people, and yeah, they just need to use it. That's the only problem. So, Susan.
I'm happy to be here. I graduated. I'm from the University of Pittsburgh in 1988, and it's always nice to come back. It's homecoming day. When Ron approached me last year, whether I was willing to participate in this symposium, I immediately said yes. CISG has always been the one academic thing I've done throughout my otherwise practitioner life. Then when I actually started thinking about it, what I was going to say, I called Ron. I said, Ron, we don't use the CISG very much. And what else am I going to say? I think you're expecting me to have a little bit more than that. That would be a very small speech. And then I got into it, and I do have more to say. Ron was very kind and just kept encouraging me to proceed. And yes, it was also a good exercise for me. Somebody who, when I graduated from law school in '88, was very optimistic. I always knew that I was going to be an international practitioner, and the CISG was going to be a solid part of that. That was my expectation. And as you can tell, that did not materialize at all in my practice. Yes, it comes up, but not that much. But I got to kind of take a look at why I thought that happened, and also examine the times when I did have interaction as a practitioner with the CISG. And just up front, I mean, a few thoughts, and I'm going to get a little bit more into it. I think part of it is that the Uniform Commercial Code is such a success. So when I talk to my clients about Uniform Commercial Code, they may not know anything other code out there or law, but they know what I'm talking about. And they generally have a good feeling towards it. So in essence, CISG is always up against probably one of the biggest successes of unification of law in the United States. And that's a high hurdle. So from my impression of readings, if you have a less developed sales law, or one that isn't really highly regarded, probably parties are more likely to choose CISG because it is a good law. I always say that. And then the other observation I have, be that it's true or not, my US clients generally feel they come from a better place than anybody else. have the better laws, and probably have the bargaining power to do this, and everybody else would recognize this is the better solution anyway, to deal with US law. So, given all those inclinations, yes, we do not deal with the CISG that much. Now, I took inventory a little bit of what, when has the CISG come up, actually? And this involves Harry, actually, here. A while back, we had a piece of litigation. One of my clients, who is, and I forgot my prop. I actually have a prop for this. But anyway, one of my can manufacturers, in making cans, it's a rather crude process. It's just basically you have a steel and it's brute force. You punch out these cans. And this can manufacturer had also operations in American Samoa. So we know, and the contract for the purchase of equipment for the can manufacturing operations in American Samoa in the middle of nowhere was a Spanish company. The executive in charge of that purchase had dealt with that company in Europe before, liked their equipment, and ordered it for American Samoa. It was about $1 million piece of equipment. And like all these cases, this case is kind of just illustrative of how the CISG comes up. The parties knew what they wanted. They knew and understood the type of machine they wanted, the specifications of the machine, and the contract was pretty detailed for that. But they had nothing legal in there. No choice of law, nothing. No choice of jurisdiction. And here we were. Also, usually bad cases go to court. And this started out bad because the manufacturer was behind in the manufacture. So we had a trial in Spain to manufacture cans. Normally you would have the equipment run for at least a day, but they were behind. So here's my prop that I forgot. There was one can they produced in Spain to ship the equipment to American Samoa, and the litigator who worked on it still had it in his office. So there was one sole can that was produced in Spain. We shipped the equipment to American Samoa, and American Samoa too, it might have an effect that it's just a harsh climate. Being an island in the middle of the ocean, it's humid, so I don't know if that had something to do with it, but this equipment did not hold up at all. It basically, this crude punch at one point just shattered. The manufacturer sent their head engineer over for a while. They tried to fix it. It just did not work. So what are we going to do? Being in American Samoa, it's a tuna fish production. So the tuna fish just keeps coming. And we have no cans. And you can't do that. So you have these additional losses unless you get cans, because the tuna will not last forever. So what do? We fly in cans from the mainland, so adding to the damages. So this, by the time we got involved, there were probably $2 million worth of damages out there. My client tried to negotiate, but we were just too far apart. And the company in Spain, actually, they went bankrupt in this process as well. So there was no money. Anyway, we contacted Harry and drafted the complaint. And when I looked again at the complaint, I pulled it out, and worked with my litigation partner, and he could immediately identify this isn't normal, this isn't normal, this isn't normal. So there were additional issues that we had to address because of the CISG. In this case, it was the timing, the main issue that we saw was the timing of discovery of the defect. Because, you can see how, yes, there was a little bit of a trial in Spain, then it came over. And really, we pleaded when the machine finally, after a month or two of operation, fell apart, that we could not have foreseen that or detected that before. So you can see where, yes, this made the complaint also a little bit more expensive, more burdensome, a little bit more, it wasn't your run-of-the-mill type of complaint. And what happened in this case, we filed the complaint. The other side, we were not totally sure whether jurisdiction in Pittsburgh was defendable, but we thought we had a good case, but it wasn't a home run. The other side made the mistake of appearing and then changing their mind. You can't do that. So that was never really debated of whether jurisdiction was in Pittsburgh or not. And then ultimately we got a default judgment and tried to collect, which wasn't too successful either. So yeah, it was a bad case, right? The parties did not do what they were supposed to do. So in a way, it is a typical CISG case. Also, the conclusion is a little bit, if you're a little bit more sophisticated, you're probably going to be better dealing with the CISG than a company that's about to go bankrupt. And because there are more legal fees involved. I really think working with Professor Fleckner mitigated that. And it was very helpful to have somebody kind of look over our shoulders and say, okay, yeah, no, you're right on.
A less bad case. A less bad case.
A less bad case. But yeah, there were additional legal expenses, I can assure you, because of that. You'll hear throughout my presentation that legal expenses matter. It matter to my clients, and even so they matter to me. And yes, CISG will raise the legal expenses, at least in the short run, somewhat. So it also comes up in counseling clients. And there it comes up more often than in the litigation area. I, by the way, did send out a message to all my partners whether CISG had come up, and I did not hear back. So that is that answer. Now, I would not put my hand in the fire to say that there may not have been a case where it just wasn't recognized. It just happens all the time, in my estimation. Judges don't recognize it, practitioners don't recognize it, so I don't have an opinion on that. But counseling clients on international sales transaction, and it's basically a 4-step analysis, often just the 3. We do present the option that yes, there is the international sales contracts that where the CISG could be applicable, i.e. both parties are in contracting states. I would say that yes, there is US law, there's the Uniform Commercial Code, it's good law, you know about it, you've worked under it. We could try to get that and choose that, and we pretty much know what we have. There's a lot of case law, a lot of experience with that. Then we would say yes, and then there is some other law. I don't think that should be our choice out of the gate, but the other party may say we want French law, German law, whatever, and that would not be desirable. There is this other law, the CISG. It's also very good law, but it is a little less known. It probably would, if there is a dispute, it probably would be a little bit more involved than dealing with the UCC. But it is good law, and it might be a good compromise position because it does have a good reputation worldwide. And in some other parts of the world, like China, it's actually a little more acceptable than here in the United States. Typically, what happens is that my client will choose the UCC. And really, I mean, given this little speech, you can't blame them for that. That being said, are there maybe cases where I would more vehemently advocate for the CISG? Yes. For example, I've talked to clients a little bit more seriously about having international terms and conditions. Like this is a company that trades internationally a lot. And so, yes, I think it's a reasonable position in that case out of the gate to say, let's just choose the CISG rather than deal in each case whether US law will be acceptable or not. For example, Brazil typically never accepts a foreign law. So, there are good examples where that makes sense. Then there seem to be some industries where it's more acceptable, like the wind power industry internationally seems to accept it more. So, in that case, you might as well go with the flow. So that is the typical four-part, analysis. Let me, in a way, conclude here where I think we are. Yes, it's a very good option during negotiation. I prefer it any day over foreign laws. But, as I said, I started out, my clients often have the bargaining power to just choose the UCC, and I can't argue with that at all. Now, concluding, though, I do have to say I'm glad the CISG exists. I really do. For example, a couple of days, one of my partners came to me, and he was looking in the context of an M&A acquisition at a contract. It was like due diligence. The contract, again, did not contain a choice of law clause. It provided, so we said, okay, we're in the CISG. Which, again, if we couldn't have concluded that in 2 minutes, this would have been maybe a couple of hour analysis. So yeah, I'm glad it exists. Then further he asked, the contract provided for FOB. What I thought that meant in the context of the CISG. I said, well, so you're asking me, is that FOB the UCC kind of term, or how we understand it domestically, or the FOB Incoterms, which is superior any day? And we kind of concluded, looking at Article 9, and you guys may have additional thoughts on that, that, looking at the usage and practices, that probably in that context, in the international context, the term FOB would mean Incoterms, or at least we could make a very good argument for that. If that had been under US law, it would have been, FOB, whatever that means in the United States, which are 100 different interpretations. But, so yeah, I thought it was helpful. And with that, I conclude. Thank you.
I got to say, it's interesting, particularly for me, because when I give my little talk this evening at the dinner, I'm basically going to be part of this panel, it turns out, in terms of what I'm going to be talking about. But we have now time for some questions, and we have the mics going around, so Marco and then Ingeborg. Yeah.
Marco Torsello, University of Verona.
Yes.
Thank you very much for the very interesting talks. I would have comments for all of them, for all of you, but actually I will like to focus on John's very thought-provoking presentation. And I would like to make two remarks. The first one is the data you presented are very interesting. The conclusion you draw from them may be a little bit more questionable to me. And what I would suggest in the first place is that if public companies in the US in the 99 or even 100% of cases opt out of the CSG, that is a success of the CSG, because the CSG is meant to be a set of default rules. And if the parties are induced to draft their own tailor-made rules in the view of the CSG, that is probably because they are aware that they have special circumstances or will to invest and to bear the transaction costs that are involved in the drafting process. So I wouldn't conclude necessarily that is a failure of the CSG, because that is what default rules are meant to be, just a fallback in case that the parties don't want to draft something differently. The second comment, if I may, is that I think that you should look into the structure of the market. And it is not only in the US, it's probably everywhere, and irrespective of the availability of the CISG, that big, large companies will want to rely on their own contracts, on their own tailor-made rules. They don't rely on the default rules, it being the CSG, or it being English law, or it being whatever other national law. So if you, and probably the one factor to be taken into account is that the US and Canada, small businesses are less likely to enter transactions with known national counterparties. So the international contracts are less frequent than in other jurisdictions. I happen to be, apart from an academic, also a practitioner in Machiavellian Italy. And as a result of that, I could give you a list of hundreds of contracts where Italian small companies were entering with contracts for the sale of goods with US-based or foreign companies. And behind the scene, I was consulting with the party, say, don't worry, New York law is fine. Why? Because it will be the CISG, don't worry. So it's easier for us to manage in that event than in case of a different option. So I think that in cases of small companies, the CSG does play that important role of set of default rule that the parties rely on. I think it's difficult to determine how that could be visible from the data, but that is a factor that should be taken into account. Sure. Thank you.
Ingeborg, go ahead.
Yes, I also wanted to address your field research, John, and you mentioned yourself, I mean, looking at the data that mentioned the CISG gives us a false picture. And even looking only at contracts that had a choice of law clause gives us a false picture, as we just have seen, because I don't know percentages, but many international contracts don't have a choice of law clause at all. So where the CISG applies via Article 11A without a choice of law clause, so you did not get all these cases, and it would be very, very interesting, although I think even impossible, to look at these cases where there was no choice of law clause at all. And then coming to your point that the parties who chose a law didn't like the CISG. Well, I would recommend all of you a new book of field research, a very thorough field research by Gustavo Moser, with the title Rethinking Choice of Law. He did a global field research. What were the expectations of the parties when they chose a certain law? And in the end, did they exclude the CISG or not? And it turned out that they expected something entirely different, and that they excluded the CISG for reasons that were totally irrational. And so I think we have to think, what are parties thinking when they are choosing a law. And to come to your observation, Susan, I think you're perfectly right, and I think every American party wants to choose the UCC, and that is natural because they have been raised, they have been educated with the UCC, and the home-cooked soup, that's the best in the world, everywhere. But you already mentioned maybe such a choice of law may not be recognized. And it's not only Brazil that doesn't recognize a choice of law clause. There are many other, especially developing countries, that do not recognize choice of law clauses. So you better don't litigate in these courts. And second, well, I have seen so many contracts where the American party didn't have the bargaining power. And, for example, I was involved in an arbitration between an American and a German company, and, well, they had a contract that said, and that comes out in the end very often because the law second mostly chosen in the world after English law is Swiss law. And parties have no idea what they choose if they choose Swiss law. And that was a choice of law, Swiss law, to the exclusion, and now you see how much they know about CISG and any other international instruments, Swiss law to the exclusion of any UNCITRAL and UNIDROIT laws. So they had heard of UNCITRAL and UNIDROIT, oh, we exclude all that. And actually, the American party would have won the case if they had not excluded the CISG in that case, because they had no idea about Swiss law, actually. And as regards your argument about expenses, in that case, I think the CISG, litigating or arbitrating the CISG is much less expensive, because you can easily access it. You have no possibility to access Swiss law as an American lawyer. Yeah, you need a Swiss counsel. You need a Swiss law expert. So, well, I'm happy, because I'm very often acting as Swiss counsel or a Swiss expert. But that's not. That's much more expensive than if you were to litigate under the CISG. And last but not least, you mentioned there are big differences between nationals from different countries. For example, a Chinese party would never agree to exclude the CISG. Why? The CISG is the Chinese contract law, yeah, more or less. And the CISG is not only taught as a mandatory course at law schools, it's taught at every studies, at all universities. So it all burns down to the question of education, yeah? And why do they exclude the CISG? Because of ignorance, because we do not educate our students in the CISG, because we do not make it a mandatory course in each and every law school. So I think that's the question we have to face, and that's where we have to work on.
Can I say something in response?
Yeah, please.
Thank you. Thank you very much. So two very quick points. I mean, obviously you can't, if an international contract lacks a choice of law clause, right, you can't do anything about that. Did the parties want the CISG when they didn't have a choice of law clause, or are they completely unaware of choice of law? I feel like that sort of doesn't really tell us very much other than the parties are unsophisticated, and that doesn't necessarily mean they like the CISG or they don't, right? We just don't know based on that. In terms of the education point, I mean, in principle, I agree with you, right? That if attorneys in the United States and Canada knew more about this particular treaty, they may very well be more likely to sort of advise their clients to enter into it. But let's be very clear, this isn't a new kid on the block. This thing has been around for 30 years. I mean, Harry and Ron and I and others have been teaching international business transactions to US lawyers for 30 years. This is all US law schools. It's not happening, right? It's got to be something more than just education, because we've tried that and it doesn't really seem to be catching on, notwithstanding 30 years of American legal education teaching students about this. So I think there must be more going on than just that.
Okay. Yes. Yes, please.
I was wondering, John, in your research whether you differentiated at all between sellers and buyers. And the reason I say that, you mentioned the Boston biotech, and I wondered if they were in fact a seller, because we tell our students, and the general myth is that certainly it is more pro-seller than buyer as compared to the UCC. And so I'm wondering if we're really missing a slice of this, besides other reasons we might not get all of it because of the public contracts and all that. But if we're really missing the sort of small companies, like in Rhode Island, where I'm from, we have lots of little companies that do export, import, and sell products overseas, and whether those companies really choose CISG more as sellers than buyers.
Yeah, so I didn't look, for the 5,000 contract study, I didn't look at buyers and sellers. There was just too many things to look at there. I will say that in the Canadian context, the two people I spoke to in Canada said they actually preferred national sales law when they were selling, but they preferred the CISG when they were buying. So that was sort of cut, if anything, the other way, which is weird, but maybe Canadian sales law is different. What's that? They may have a different point of comparison. That's exactly right. Yeah. Yeah, and I will say that, in the data set, there were also contracts between non-US parties. There were several contracts involving Chinese solar companies that were buying and selling solar panels, and the Chinese companies opted in to the CISG far more often. Like, there were many more Chinese companies opting in affirmatively than there were in the United States or in Canada.
My name is Nevena Yevremovic. I'm Manager of Corporate Learning with the International Association for Contract and Commercial Management. And I'd like to thank you for the interesting presentations. And as a general kind of comment, it's so great to hear from research that is from practitioners and both the legal side. And I like especially the comment that you emphasized from somebody who's a business person saying that they would prefer CISG in their contract, whereas all of these lawyers are saying, no, we don't necessarily want it. Which I think highlights a very important issue that we need to think about, which is that there is this commercial side of contracting, right? The people who are heavily involved in contracting processes are contract and commercial managers who are not necessarily lawyers. And if we want to tackle the education aspect of CISG, we need to think about CISG as well, I think, in the context of how can the CISG be an instrument that gives fair and balanced approach for both the legal and commercial concerns of these parties. And it's important how we teach CISG. If we teach it purely, from a choice of law perspective, then we might not be sending the right message. And research that IICCM has done shows that top most negotiated terms over the past years do not concern choice of law clauses at all. They concern different things that substantively revolve around the contract, and they try to protect themselves. And I think CISG can be a really, really good answer to that. So this was just a general comment, and thank you for the presentations once again.
I just want to say one thing. I just want to mention that my late great co-author and participant in past Pittsburgh conferences, John Murray, used to give, I think twice a year, would do programs for purchasing managers on the UCC for that very reason, as a matter of fact.
John, your study is very interesting. I did one of my own, but instead of having a sample of 5,277, I had a sample of one.
Basically the same.
I think it says something about relating to your study. It was a former student who had studied the CISG here, who represented a privately held company headquartered in Liechtenstein. And they sell all over the world, and including North America. And they have, in their contract, affirmatively opted in to the CISG. That's their form contract. And she said, we have no problem with that, except in the United States and Canada, where we get pushback on that. The rest of the world, we get no pushback. So once you, so the study of the U.S. and Canada with a sample of 5,277 is maybe consistent with my study of one.
Do I have time for one here? As the first speaker after lunch, who's going to talk about uniformity, I wanted to ask Ulrich a question. As I recall, you said something to the effect of, we should prefer a reasonable interpretation over a uniform interpretation. I may not have that exactly right, but I think that's what you said. And that's interesting to me because most of us who teach contract law in the United States, there's a couple of cases we teach, particularly in teaching the UCC, where a court was faced with 3 different possible interpretations of a rule and went through the 3 different interpretations. And in one case, Judge Posner, in dealing with different terms under UCC 2207, said, you know, I'd get to it this result, A, but B is closer to uniform. It's the majority approach. And therefore, in the interest of uniformity, I'm going to choose B. In another case, dealing with the timing of when the buyer learns of a breach on a damages issue, another seminal opinion, the court went through and said, you know, there's 3 different ways we can look at this. And one of the ways, let's say A, that's the majority approach. And that has something to be said for it. But I actually still like B better, and so I'll choose it because it's more reasonable. And I actually happen to like both of these opinions. But it strikes me that if indeed, as reasonable as it sounds, if indeed we choose the reasonable interpretation over the uniform interpretation, we'll never get to uniformity because we all believe our interpretation is the most reasonable. Food for thought.
Very well argued, I must say, but nevertheless, I defend my position. I must say, the outcome probably depends on the weight of the question, on the seriousness of the problem, actually. For instance, the rate of interest in the CISG is open, and the clearly prevailing view is that national law should step in. There are others, and that might seem reasonable. Let's say we should adopt a reasonable rate of interest, an autonomous rate of interest for the CISG. In that case, I would say we should follow the mainstream, the majority here, and not follow a reasonableness in that direction or that direction. Why predictability and reliability of law is a value that should be preserved also under the CISG. And now we know that most courts in the world then apply the applicable national law and the rate of interest there. In other cases, but I have no example for other cases, I must say. I would be reluctant to say, we should follow the mainstream, but not the reasonable view. I think when I speak of a reasonable view, it's not my personal view, it's not the view of only one or 2 others. It is sometimes a view that is then supported by a number of high-ranking colleagues. And you see that in certain cases, you find that after a while, a reasonable view then becomes the mainstream view. I have an example that is the set-off. It was clear for a couple of, actually for decades, I must say, that set-off is not regulated by the CISG. It's always outside the CISG. But in the meantime, and that was supported not only by me, but by a number of colleagues, it was said that set-off is regulated by the CISG when we have claims that fall both under the CISG. Then you can use the mechanics of the CISG to have a set-off here. And the highest German court follows now that view, and I hope that other courts will also follow. Why? Because that is reasonable. You need not apply the foreign law on set-off. You need not apply private international law rules. It's more practical to apply what the CISG says. And the CISG has some rules on that. I will not mention them now, which give sufficient support for that solution.
Thanks for the distinction, and thanks for raising the issue. It's a nice setup for me this afternoon, so I appreciate it.
Okay, thanks. May I just add, if I may, the reference to the CISG in what you mentioned, John. If you ask for the reference to the CISG, you probably find only contracts which exclude it. You do not find any other contracts because they do not refer to the CISG.
Chinese solar companies opt in all the time.
Yeah, Chinese contracts might be a difference. Then you find some examples where contracts opt in, but the huge majority which do not mention the CISG at all are not on your radar, so to speak. Then you said the consumers do not, we should not blame the consumers, we should blame the product. It's all about, as Ingeborg said, about the misinformation of consumers, of the lawyers, and I understand that lawyers are conservative. If you don't know the law that you should apply or could apply, it's not necessary to apply if you have another law that you know very well and that you applied for many, many years already. Therefore, it's all about the misinformation or lack of information of lawyers, actually, what you found out. And that has to be changed. That has really to be changed.
Well, with that, let us end. No, I get the last word, actually. Because when I speak this evening, I have the absolute answer to everything we have been talking about here. Foolproof, absolutely. It has one small flaw, that it would never stand a chance of ever being adopted. But besides that, it is the foolproof answer, so you should make sure you be there for that, as a matter of fact. And I think Ron has a couple of announcements about lunch.
After we thank Ben.
Yes.
And the moderator. Yeah.
A little bit of housekeeping. For those of you who are registered for CLE credit and got the check the box sheet, go back, give it to them, pick up a new one because the one you have has some errors in it. Second, I do want to mention two things that are coming up on the CILE schedule. Not necessarily CISG, but one is Monday, April 1, when we have our annual McLean lecture on world law, and we have Peter Trugoff from Covington and Burling in Washington, who's coming to speak on lessons from a life of international legal practice. And for those in the audience who want even more CLE credit than you're getting here today and tomorrow, you can join us in Verona with Marco and Francesca in late May, early June for our annual summer school there, which I think is going to be wonderful. And it's a little sunnier than this room normally, and that's nice. Finally, you may be wondering about the red dots on the name tag. The red dots get you into dinner tonight at the University Club. The name tag, with or without a red dot, will get you into lunch on the second floor in the Alcoa room. If you can go upstairs, or if you go up the elevator, simply turn right and go until you see the sign that says Alcoa room, and it's another right in there. Keep in mind that Professor Spencer is incredibly excited about her panel this afternoon, and so really wants to start it right at 1:30. So we'll be back here at 1:30 for that. Thank you.
Good afternoon, ladies and gentlemen. This afternoon we will discuss uniformity, which has come up several times already this morning. Do we want uniformity? Do we get uniformity? Should we get more uniformity? So we will first hear a paper on, I guess, the general questions of uniform application and interpretation under Article 7 of the CISG, and then we will have several papers addressing different issues under the CISG where there is not so much uniformity, or where at least we could enhance uniformity. So we start with Jack Graves. Jack is a professor at Touro Law School in New York. He has been involved not only with the Wismut, but with the CISG in general for decades already, I dare to say. And he has one other prominent feature, and that he is engaging now in online legal education, which poses real problems and is a real challenge, but I think it's the future. So Jack, the floor is yours.
Unmute this. I have this habit of walking around, so I convince them to give me a mic so that I don't have to stand anywhere. Let's see if I can get slide 1 and 1.
Start with that. That's just over the scheme.
End of slideshow. Sorry. Is that somebody else's?
Yeah, that's just
okay. That's
and then
somebody.
we'll go down.
Got it. Thanks.
Now the pointer should, okay.
Great, thanks. So last summer when Ron contacted me and was not great enough to invite me to this event, I thought, what can I talk about? I've been focused primarily on online ed lately, teaching people about the CISG through online platforms, and I hadn't really dived deep for a while into any of the CISG issues. So I thought, well, I'll take out something easy, uniformity. And of course, when I thought about uniformity, I was thinking in terms of what I do as a law professor, which is I tell first-year contract students or students in my sales class, well, of course, uniformity is essential because the whole purpose of the CISG is to give us a uniform answer to the sorts of questions that arise in international transactions in goods. But of course, like many things, the more you learn, the less you know. As I started to go deeper into questions of uniformity under the CISG, I recognized that there's some real challenges here. And in fact, of course, I started with 2 articles written by Harry Fleckner, who we're here to honor today. And Harry raised some really good questions, and I read some other pieces, and I've started pulling it together. And the more I read, the more I got the sense that any broad goal of uniformity is at least challenging, if not elusive. And so I started rethinking, what can we accomplish with uniformity? And I started to focus more and more on the idea of maybe a uniform way of thinking about the issue of uniformity under the CISG, or at least a proposed structure for doing so. So what I'm going to propose today is maybe at least an idea for thinking about issues of uniformity under the CISG, because if we can at least come to some level of agreement about that, then I think we've got a fighting chance with uniformity. So uniformity under the CISG, you all have read Article 7.1, I'm sure thousands of times. And as someone else has mentioned, I think Professor Magnus mentioned it earlier today, Article 7.1 doesn't just talk about uniformity. In fact, uniformity isn't even the first important principle it mentions. It starts out with international character. It talks about and uniformity and good faith, and of course it just talks about regard is to be had. We're not entirely sure how much regard. And there's also some serious questions as to whether international character, uniformity, and good faith necessarily even will lead us in the same direction when we give effect to all of them. It's also at the outset worth mentioning that the preamble talks about uniform rules, in effect uniformity. In fact, many articles talking about the importance of uniformity mention it's not just in Article 7.1, it's also in the preamble. But the preamble also says something else. And take into account different social, economic, and legal systems. Now, I'm not entirely sure I know everything, all about what that meant to the drafters, but it seems to me that at least implies that the CISG is a compromise, and a compromise of limited scope. Because we recognize there are differences, and you can overcome some of these differences through compromise, and maybe you can't overcome all of them. So when I read the preamble together with Article 7.1, it suggests to me that certainly uniformity is very important. It's an essential principle under the CISG, but that the international character of the CISG may move us in a variety of directions. Yes, it's an international treaty. We should interpret it on its own terms. But we also need to recognize that based on its international character as the product of different social, economic, and legal systems, it probably has its limits, and it's probably, in many cases, the subject of a compromise. And then good faith. Others will talk about good faith. Professor Tepish back there, I know will talk about good faith in the next panel, but I think there's some real questions as to good faith itself isn't uniform. It means different things in different legal systems, so it might well additionally take us in different directions. So with that in mind, I think the question is, how far should we go in our quest for uniformity under the CISG? Is uniformity even realistic when we consider the international character? We've got people from very different perspectives trying to understand and apply the CISG. And does the current state of the CISG at middle age, and I'll come back to this, particularly with respect to Professor Coyle's observations, does that provide us with any guidance? So with all of that in mind, what sorts of questions do we have that require uniform answers? And I'll start with the most traditional. I think we're all familiar with the notion of internal versus external gaps. And I'm not sure we should even call the external gaps gaps as much as things that aren't governed by the CISG, but most people use this terminology. So internal and external gaps under the CISG. And I think filling internal gaps is probably where we have the greatest accord. I think almost everyone, there's a few stray articles that say, one in the US that suggests we should use the parole evidence rule under Article 7.2 to interpret Article 8, but for the most part, with a few outliers, I think we're all in agreement that you fill article gaps under Article 7.2, or internal gaps under Article 7.2, and that you do it by reference to the language and the general principles, and only if there is no other way do we go to the rules of private international law. So that's not subject to a lot of disagreement. Now, when we start thinking about external gaps, I think maybe we've got some divergent views. There's a traditional view that says that we essentially, if we've got an external gap, that means the CISG doesn't govern the issue, and for better or worse, we've got to go to private international law unless there's some other convention that would address the question. We go to the rules of private international law and domestic law, or some, the UNIDROIT principles if the parties chose the UNIDROIT principles, but certainly not the CISG. On the other hand, sorry about that, I jumped forward. On the other hand, there are some who would suggest that even with respect to external gaps, in the name of uniform sales law, we should expand our notions of uniformity. We should look for uniform solutions under the auspices even of the CISG in the interest of uniform laws governing sales. So there's some level of divergence in views on external gaps. There's a further distinction that I bumped into in doing the research for this piece, written by Alan Blair. Oddly enough, I should have known about it. Alan will be a co-author in the next edition of my book. But Alan talks about the difference between rules and standards. And I think Harry actually alluded to, I don't think you used the term rules and standards, but I think you alluded to a similar difference in one of your pieces. For example, Schwartz and Scott, both of whom have written a lot about rules and standards, in the most recent piece give an example of a rule would be buyer must provide the notice of a defect within 90 days of delivery. That's a rule. We know what the rule is. You either provided the notice of defect or you didn't. On the other hand, a standard might say that the buyer must provide reasonable notice of any defect. And you might say, well, that's kind of a quibble, but it's not really, because to a large degree they serve different purposes. A rule, at least in theory, serves on an ex ante basis to guide conduct. The parties need to know, how quickly do I need to examine the goods? How quickly do I need to report any defect? If we've got a rule and it's 90 days, we know that guides conduct. By day 89, I better be doing that, because if I run out of time, I'm in trouble. On the other hand, a standard, yeah, I know it's important because there is a standard that says I have to do it within a reasonable time, but I may not necessarily know in advance what a reasonable time is going to be. Particularly when the standard itself is designed for ex post application by the arbitrator, by the judge in resolving a dispute. Was notice given within a reasonable time? And this is my own answer to the question I posed for Professor Magnus today. I think that a reasonable approach is more important than a uniform approach when we're dealing with standards. Because in fact, when we try to impose a uniform approach to a standard, we defeat the whole purpose, which is to give the fact finder, the person resolving the dispute, the opportunity to reach a conclusion in the context of the party's specific dispute. So the more we try to find uniformity when we're dealing with standards, I think we defeat the purpose of the standard. On the other hand, when we're dealing with rules, it's pretty critical. Uniformity is very important because rules are all about guiding our ex ante behavior. So, the beginning of my framework, which isn't mine, this is just relying on the standard internal versus external gaps, and Professor Blair's further distinction between rules and standards. But it seems to me that we can draw some additional distinctions here. First of all, there are rules involving internal gaps in the CISG where we know there's a rule, and we know that the drafters thought they had found agreement, and they wrote a rule. But in trying to apply this particular rule, interpreting the CISG, we can't figure it out. Where there's a gap, we don't have a clear answer. And in those cases, it seems to me that uniformity is pretty critical. And I think most would agree that trying to find a uniform solution is a worthy objective. But there are also rules, I'll give an example of one in a minute, there are also rules upon which the drafters couldn't reach agreement. They're not standards, they're not intended to be vague, they just couldn't reach an agreement. When we look at gaps, there are two kinds of gaps. There are express external gaps, like Article 4. Validity this convention doesn't govern validity. And there are implied external gaps. We don't see it in the convention. Classic example is hardship, which was near and dear to Professor Fleckner's heart. It doesn't appear to be there. We'll talk a little more about it when we get to this issue. But it seems to me that these two issues in red are the most intellectually challenging. What do we do with these? Again, not everyone agrees, but it seems to me that if we've got rules where the drafters all thought they were in agreement and we just can't find the solution to the particular problem, we ought to try to find a uniform solution. Seems to me standards, we probably shouldn't look for uniformity because it defeats the purpose of the standards. And with express external gaps, seems to me that we ought to recognize, for better or worse, the CISG doesn't answer those questions. But these two in red are kind of tricky. So rules upon which the drafters couldn't reach agreement. And this is another one that I first discussed with Harry. Article 25. You know, we've got a rule of foreseeability, and that's a pretty clear rule. But the drafters could not agree whether we should limit foreseeability to that which is foreseeable at the time of contract, or whether we should provide for, whether we should also be willing to measure foreseeability at the time of performance. The seller who didn't realize at the time of contracting that if he delivered goods with a particular nonconformity that would render them completely useless to the buyer, but learned subsequently. If the seller ships those goods, is it foreseeable that the buyer would suffer a substantial detriment? And that seems to me we've got a rule, but we don't have a clear answer, and the drafters left out the timing of foreseeability because they didn't have an answer. They couldn't reach agreement. So what do we do with that? It's seemingly a rule, but when? There was no agreement among the drafters. Do we resolve it by reference to good faith? And if so, can we find a uniform answer to what good faith would tell us in this context? Or, good faith, it seems to me, is a standard. So once again, how do we come up with a uniform answer to this question based on good faith? I'm not sure we can. Sorry, I'm clicking this too many times. Or should we look to the evolution of a uniform rule? Should we treat the convention as a living document, the way we do a constitution? Or at least some people think we should. There's a whole debate about that as well. The point is, should this rule be changed? Should it change over time? Or should we be trying to determine whether this was a rule that we can reach a uniform result on based on the time of drafting of the convention? And can we at least agree on a uniform process for resolving this? Because resolving this question, when do we measure foreseeability under Article 25, seems to me to require us first to agree on a uniform means of approaching the problem. Because if we don't have a uniform means of approaching the problem, I can't see how we ever get to a uniform solution. And again, this is a rule, so we ought to be able to provide guidance to our seller as to, can I ship the goods? Or guidance to our seller, can I rely on what I knew about at the time of contracting? Under Article 25. Same issue under Article 78. We have a rule providing for interest, but it's clear that the drafters couldn't agree on the amount of the rate. Does that mean that that rule providing for interest, that we can't get to a uniform solution on it today? Or should we continue to search for a uniform answer to a rule that the drafters couldn't agree on? So it seems to me that these are, and certainly more examples than these, but it seems to me that these each sharply raise the question of, is it appropriate for us, the community, for courts, for arbitrators, to try to find a uniform solution on a rule on which the drafters themselves couldn't agree? Considering that this is a convention of limited scope, and considering that it was a compromise. Implied external gaps. Again, the hardship case is a classic example. The CISG doesn't expressly address. I'm not sure anybody can claim that Article 79, when you look at the remedial provisions of Article 79, that it contemplates hardship, because it doesn't contemplate the remedy. So whatever your view on this issue, I know this is a moot issue as well this year, Seems to me it's not in Article 79. So that leaves us with the question, it's not excluded under Article 4, so should we try to find a solution? And if we don't, is it impliedly preempted? I think Professor Fleckner would suggest that not only is it not included, but Article 79 preempts the field. And that's a decent argument. I still haven't thought through which one. Or is it simply not addressed, which means you can still resort to hardship under the applicable domestic law based on the rules of private international law? I'm not sure. But again, I think if we had a process for dealing with these kinds of questions, the questions of what do we do with implied external gaps, I think a uniform process will go a lot farther than try to look for uniform solutions until we've agreed on a uniform process. And then the last is this intersection of uniformity and legitimacy. The CISG has yet to find broad acceptance, certainly in the United States and Canada. I understand the limits of Professor Coyle's work. I think most of us who deal with the CISG, with lawyers, with business people in the United States, anecdotally, we run into the same thing. Nobody wants it. So if that's the case, if the market isn't buying, how do we change that? Our efforts at application should always consider issues of legitimacy. Because if we don't get to legitimacy, then uniformity is a pretty hollow victory. So it seems to me that whenever we think about uniformity, particularly when we think about an expansive approach to uniformity, we've always got to combine those questions with questions of legitimacy. To what extent is this what the countries of the world agreed on when they came together to draft and adopt CISG? And is this what would advance our cause in terms of finding uniform acceptance with CISG? So I think we've got to look at uniformity and legitimacy hand in hand. No answers, but a lot more questions, and we'll explore those in the paper. Thank you.
Thank you so much, Jack, especially for exactly keeping the time. We now turn to the next speaker, which will be Francesco Mazzotta. Francesco has originally received his education in Italy, but then after studying here at Pitt, he was convinced to stay in the United States. And currently, Francesco is Chief Judicial Clerk with the Supreme Court of Pennsylvania. Francesco, too, has published extensively on the CISG and was involved in the Wismut also. And today he will talk about uniform interpretation relating to the notice of conformity, where there's also a lot of problems. So we'll bring up your slides. Please, Francesco.
Thank you very much. Thank you for the introduction. Thank you, Professor Brand and Professor Fleckner and everybody else involved in the process, inviting me here in Pittsburgh and as a speaker. It's even a greater honor to be here. Obviously, it didn't take too much once I received the email from Brand, Professor Brand. Francesco, are you willing, interested? I don't think he even had time to send that I already replied. Of course, I say yes. It's Pittsburgh, it's my alma mater, and then Professor Brandon Fleckner here, and I said, I have to do it. And also this morning I was with Milena downstairs waiting for the bus to take us here, and I was thinking, and she kindly reminded me that it's about 20 years since graduation. But she pointed out, well, you graduated a little bit before me. Thank you very much. I appreciate that. Anyway, it's about 20 years ago that I graduated from this school, and in 2000, then 2005. So what I'm going to talk about today is the notice of nonconformity under Article 39. My presentation is going to be short, hopefully short, and it's going to be only about, I'm fully aware, obviously, that Article 39 is strictly connected with Article 38, 40, 43, and 44, but obviously there is no time to go into those kind of details. And also, I'm fully aware that, as Professor Spencer just mentioned, it's one of the most litigated, along with 78 provision of the CISG and others probably. So I try to limit my experience, my paper, mostly on the US experience. So it's going to cover just the last few years and mostly about the United States. In the past, I wrote extensively, to some extent, on how badly U.S. courts behave when it's about Article 7. But today, for the first time, I will not say that they are as bad as they usually are, which is something new for me. So let's go ahead. So let's start with this apparently simple article. In essence, Article 39 says if there are problems with the goods, and again, I'm talking here very loosely because it can be used under different circumstances. If there are problems with the goods, then you have to give notice. There are two problems that arise usually with this provision. Number one, specifying the nature of the lack of conformity. This is problem, in my presentation will be problem number 2. But most importantly, I'm going to talk about within. So when you need to notify about the problems, you got to do it within a reasonable time after the buyer discovered or should have discovered the problems. And here I can also say that my presentation, based on what Professor Graves just said, and early this morning, Professor Magnus said, as you will see in the end, while I'm generally more for a uniform interpretation, under these circumstances relating to Article 39, I'm more prone to a reasonable interpretation as opposed to a uniform interpretation. It's a matter of standard, it's a matter of, in my opinion, guidance, and most importantly, 39, as opposed to other provisions, for example, 78, does give us guidance. It's not that you have to pay interest, go and figure that out. 39 does tell us how to do what is reasonable. Now, we can discuss, and that's the reason why we're here, what reasonable means, but there is some guidance. So I mentioned about this. So what is it reasonable time? How do we usually, generally, what does it include? So it's a well-established that includes, obviously, the case, the circumstances of the case. It's important. Trade usages, practices between parties. All of these are relevant because, again, we are not talking about a strict rule that says you got to do it within 30 days or 20 days or 15 days. It tells you got to do it within a reasonable time. In order for you to determine what is reasonable, you got to do it under the circumstances. Now, early cases, especially in German cases, they used to set this term very strictly, very short period of time. Recently, there has been, I'm talking about a few years, there are these cases where they start from, again, a strict interpretation of this term, very strict, very short, to a much more easy way of proceeding. So, and here, then we, like I said, there are many interpretations. That's what includes Article 39 includes. And then here, we need to talk about the Nobel month, thanks to Professor Spencer. So, what is it? All of you, obviously, you know this. Basically, and I'm paraphrasing here some language that used by a friend of mine, Camilla Anderson, in an article published by the Journal of Law and Commerce in 2012. So it's not to be taken too literally that it means it's usually 30 days. And Camilla says the concept is not to be taken too literally as always being 1 month. It is intended to be a yardstick, again, a guideline, another framework of 1 month notification, which can be altered depending on the specific factors concerning the goods. That's exactly what the Noble Month is. And Professor Swenser, of course, will tell me better later on. That was the scary part. When I realized that I will be on the same panel with Professor Swenser, I said, it doesn't look good.
That's fine.
So I agree then also with Camilla, and I'm assuming that also that she was paraphrasing what Professor Swenser was saying, that there is a benefit with this approach. If courts were to use this approach, there is no question. I mean, it's a reasonable approach, the reasonable notice. So it will increase. If all courts or the majority of the courts will use that approach, that will increase predictability, and there will be also less diversification in terms of what happens and how is used, and most importantly, will kind of somehow fight the homeward trend, this trend of applying your own law as opposed to CISG. And this is where my trouble starts. While I truly believe that predictability and uniformity are essential for the CISG, I believe that I have some reservations with setting some fixed times frame for determining whether it's reasonable or not reasonable. First of all, like Camilla said, this is not a rigid rule. It's not a mechanical rule. It's a yardstick. It's just a guideline. It gives you a framework. Now, if it's just not a strict rule, if it's just a yardstick, what in the end is going to do, if you just say there is a standard 30 days and then we're going to fight within these 30 days, it's not going to change much in terms of the dynamic while arguing your case before the judge. Whatever you have to say without the rule, you will have to do it regardless anyway, because you still have to, the only thing that is going to change is probably the burden. Who's going to go first on demonstrating that is reasonable or not reasonable? So just setting a rule that says it's 30 days, I don't think is going to help the dynamic, or is not going to change how the determination is made, in my opinion. Second, and here I needed some help because of course it will be only me saying that, I needed Professor Fleckner. So I went back, looked at his book, and that's why it's reason number 2. Article 39 used the word reasonable within. And it's not just by accident, it's a choice. If they wanted, the drafters, they wanted to, and they had the opportunity and they discussed other approaches. If they wanted, they had the time and the opportunity to do it. Instead, they opted for something else, something that is unpredictable, a reasonable standard. Now, the other thing that we have to also keep in mind that I think Camilla in her article was saying, well, think about, there was one case from the US where for the same kind of transaction, the court said 6 months was okay, and another case, I forgot the jurisdiction, I think it was a European case, that very set of facts, the court concluded otherwise. I can assure you this happens within the same jurisdiction. If you check cases from the Second Circuit, the Third Circuit, whatever, or state law, or state cases, even the very similar set of facts, they will produce different results. Not necessarily will produce the same result ever, always. So this is even more likely in an instrument like the convention. So, and also keep in mind that these matters usually are to the discretion of the court. And we, as academics or practitioners, review these things, we review while sitting in our chair and say, oh, I think that was wrong. They are the one, the judges, they are the one that sit there and listen to the evidence and listen what they had to say and made a call, and made a judgment call. And it's very difficult, and again, it's based on their discretion, as the convention says, and it's very difficult for us to say otherwise, or to reach a different conclusion. And then, even if we were to say today, that's what courts should do, I can assure you, U.S. courts will not do it. They're just very simple. Again, there are very good examples, very limited, where they do take in consideration anything outside U.S. Most of the times they don't. And then what they usually do is something that, again, I don't know how they do it, even after almost 30 years, and despite their Professor Brand and Fleck and everybody else in this room teaching a lot of students to do otherwise, but they still do the same thing after 30 years. And I will explain what they do. So Camilla, in her article, was saying, and I'm going to read it for you. So a research of all reported CSG cases on Article 39 shows that none of the cases talk about the Nobel Month or something comparable. Welcome to the United States. That's how courts do, mostly of the time. So, and it says they're not embracing a comparative approach or attempting to formulate a more predictable guideline for this notice. Unfortunately, this is not the only case. It's true in many other circumstances. And here I have this article. Then we have this decision. Is a recent decision. Actually, Professor Kroll early this morning talked about the very same thing. And you should read. This is a 2016 case, U.S. District Court for the Southern District of New York. It's too little here, but. So the court says, yes, there is it is a CSG case, but you know what? Delki tell us we can rely on UCC cases. By the third sentence, we are already in UCC. It's all gone. There is no more CSG. It's all gone. And this is, again, like I said, this is a specific case about Article 39, the way the courts do, but it's very common. U.S. courts, they do all the time, and not only U.S. district courts, but also Court of Appeals. It's a misapplication of the convention, and it's a misapplication of case law. Delk is a very bad case, but the way it was applied is even worse. And here it's a little bit of a digression here. It's the following case. It's not about Article 39. And actually, this is the case, this is the case that Professor Kroll was talking about this morning. So there was a Peruvian seller and an American New Jersey company for the sale of goods. I forgot exactly what it was. There was an agreement and some paperwork that went along with that agreement. So the Peruvian company did not deliver, and there was an arbitration agreement. The arbitration agreement says, they go before the tribunal, and the tribunal says, well, there is no indication that the parties actually agreed on the arbitration clause. And then, miracle here, the Court of Appeals, the Second Circuit, the same court that authored the Delki case, basically told the trial court, you understood very little what's going on here. Because the trial court applied New York law. And the reason for applying New York law was because the case law on CSG is scarce. So, you know what? Let's go ahead and apply the UCC. That's the explanation. The sad part was that was not mentioned by the Court of Appeals. The sad part was that the party that was looking to get this the CISG applied, they relied on UCC case law. It couldn't be any worse. So the trial court didn't know what they were doing, and counsel for both, for at least the party that was looking for the application, CISG, had no clue what they were doing either. So, but again, the Court of Appeals, the Second Circuit, sent it back and told the court, by the way, Article 39, the way we determine whether there is an arbitration agreement or not has to be done according to the CISG. And the CISG rules are different, by the way, from New York laws. Try to remember this when it goes back. Stephen just told me that in the meantime, the other week he was talking to the counsels for both this case. Both companies are bankrupted by now, in the meantime. So there will be we will never know what happened to the case. So I have only a couple minutes here. So what I'm going to say is that, yes, I agree that we should have more uniformity whenever it's possible. Yes, that it's a goal that is set in the convention. However, when in a situation like this, where the convention itself states what the rule is, or actually the standard is, and the standard is very clear. When we know from the work in preparation of the drafters what they were doing and saying, in my opinion, we should not try to create fixed rules of what will be reasonable, as opposed to just leave it to the parties and the judges. They're actually dealing with the case. That's essentially my presentation. Thank you very much.
Thank you very much, Francesco. Well, Francesco, you directly asked me to explain what I meant by what Camilla named the Noble Month. Actually, it was in the beginning of the 1990s when I was called to author in the Schlechtrim commentary Article 39 and 38 and 39 and other articles. And there were already the first German Supreme Court decisions out there. And they just applied what they always had done under German law. They said reasonable means 3 to 5 working days, full stop. And I'm a comparatist. I knew in the United States under the UCC it's entirely different. There are many other countries where you do not have a duty to examine and give notice. It's mostly only the German-speaking countries or those countries relying on the German law. So I sat there at my desk and I thought, what am I going to do? I want uniformity. And I have to convince the German Supreme Court, but on the other way, I have to find a compromise. Maybe that would be acceptable for American lawyers too. And so I sat down and I said, okay, it cannot be too long. That wouldn't be accepted by the German Supreme Court. It cannot be too short. So I sat there and said, okay, if there are no other facts that indicate otherwise, I mean, I also write in my commentary, there may be a couple of hours to give notice in the flower trade, for example. But if there are no other facts in case of durable goods, we should start from a thumbstick of 1 month. So, and actually the German Supreme Court took it, and also the Swiss Supreme Court. The Austrian Supreme Court instead followed Ulrich Magnus, who is advocating an overall period for examination and giving notice of 2 weeks. So that's another standard replacing the reasonableness. But I do not want to give a second paper. We now move to Professor Johann Ehrau. Johann is a professor emeritus at Ghent. He has been involved in comparative international commercial law and contract law, arbitration, civil procedure around the world, and he is still teaching and active around the world as professor, arbitrator, counselor, and expert. Johan, the floor is yours, and Johan will be talking about time limitations and cut-offs diminishing uniformity in and around the CISG. And I'll try, no, you don't have any slides, please.
Thank you, Ingeborg, for a very flattering introduction. I'm so pleased to be here, grateful for the invitation, happy to be part of the session that honors Harry. Ladies and gentlemen, friends, indeed, time limits or time bars or prescription rules, they are not part of the CISG. I guess, colleague, that would be an explicit external gap, is that? Anyway, they are left to national law. And I think everyone at the time of the drafting of the convention, which started in the convention of 1964, the uniform law of 1964, they were aware of the importance of the issue, but it was such a difficult issue. You will appreciate, ladies and gentlemen, the first issue already is the question of classification. Is this a procedural matter, or is this a material or substantive matter? Countries absolutely have different opinions on that, and then, and I mentioned that in my written presentation, and then, of course, you have all the differences in duration, in the time span of the limitation period. They also differ, of course, in technical aspects, which I want to stress today as a very important aspect. They differ with regard to the date of commencement of the running of the limitation time or the accrual of the action. They differ in the term, as I have said, but also in, for example, the effects, the interruption or the extension, the cessation, the renewal, and the effects of the termination. So the time limits is a complicated section of the law, and there are differences all over. And so the drafters nicely stayed away from that. But of course, at the same time, they initiated the effort to introduce a United Nations Convention with regard to the limitation period. And then in '74, it came into existence, that convention, with an adaptation in 1980. But that convention has not been half as successful as the CISG itself. We have 30 member states and 23 that have ratified the updated version, which relates to the entry into force of that convention. It is interesting, and I make several remarks in my written presentation, because it could stand for us as an example of all the issues that are involved. For my presentation today, I must say I was tempted to choose this subject because I had been involved in a Canadian case, as I was consulted to help the court with the explanation about Article 40 of the older uniform law. But that article is exactly the same as the CISG article, so today I'm not going to speak to you about the differences between 1964 and 1980. I'm going to pretend that in Canada they were just discussing 1980. But the issue in the Canadian case concerned a claim of a Canadian buyer of a fryer, an industrial cooking machine in the cooking of poultry in the state of Alberta. This buyer had bought the fryer from another Canadian company, and that Canadian company had bought the fryer from a Belgian company. The Belgian company had bought parts of that cooker from a German company. So we have consecutive sales, and at least the Canadian intermediary buyer had done a sub-sale or a resale. The sale was concluded in 1993, at the end of 1993. In just over 10 years later, a factory burnt down in Alberta, Canada, causing damages of up to $12 million. The lawsuit is still running since after 25 years. The claim was introduced after 14 years against the Canadian intermediary. That Canadian intermediary, after 2 months, sued in a cross-claim, sued the Belgian company. That was what the case is about. I will return to that case after I have made the run-up to my discussion of Article 40. So if we return, and I will use some rules that we see illustrated in the United Nations Convention. But if we look at Article 39, I'm happy that you were all reminded and your memory was refreshed by what Francesco explained to you. But if we look at Article 39, we will focus on the 2-year cutoff term with regard to the notification. So that article is clearly has only to do with nonconformity as a possible claim, and it will take away the remedies of the buyer in regard to nonconformity. And also, it is only related to the notification issue. So this is clearly described by the commentators like Ingeborg and also Stefan Krull and others as not being a statute of limitation. The cutoff term of 39.2, the 2-year maximum to have notified the seller, is not subject to rules with regards to extension or tolling, and therefore the term is very strict. And the harshness is also clear, of course, when you understand that it starts to run at the time of handing over of the goods. And then if you look at hidden defects or latent defects, they could pop up much later. But as I say, the harsh and strict rule is after 2 years, you have no more cause to complain. You have no more occasion to notify. And that rule also applies in instances of a sub-sale where the first buyer would have sold onwards to his own client as an intermediary in the trade. And that explains to you that those 2 years are very important and give rise to many cases, contrary to what others would say. And I am today going to look with you at yet another term, because we always are reminded that Article 38, the examination as soon as it's practicable, and then the notification term, that we speak of 2 different terms. I'm going to speak to you about a 3rd term, which is the actual limitation for the case where somebody enters a lawsuit and has a dispute with regard to that notification. Yeah? So when you bring these 2 together now, the cutoff term of 39.2 and a reference to time limits or time bars for procedures, you have some very special issues. The authors, and also Ingeborg again and others, emphasize that if you would be confronted with a very short term, such as was the case at the time of drafting of the CISG in Germany and Switzerland, if that would be just 1 year, the 2-year term of the CISG would be allowed to you. But we more often are confronted with longer time limits. So I have not done personal comparative research. I have supported on the work of others, and I referred in my text to Ingeborg and to Stefan and others. The limitation times in national law can be 2 years, can be 4 years, 5 years, 6 years. And in the United Nations Convention, if that is applicable in the relation for the countries of which the parties are domiciliaries or residents, then that would be 4 years. So the limitation, let's take the example of 4 years, is there, and the cutoff term is also there. So we should be clear, I think, in looking at this, that if a party is allowed to commence a lawsuit up to the 4th year after the handing over of the goods, a judge could accept to look into the matter, and then the judge applies the rules with regard to notification and could deny the buyer remedies based on what Article 39(2) says. But the claim may have begun or had started later, right? So that distinction, I think, we should keep before our eyes. And then I would like to show you, illustrate to you a few complications. Just with regard to the time limits, you could have a serious extension or a serious interruption. The extension could come because a lawsuit was introduced between the same parties over this cause of action, and then the time limit would be suspended. The running of the period, the time bar would be suspended. That does not influence the matter of the 2-year cutoff term. The United Nations Convention, for example, says if a party introduces a lawsuit within the allowed time limit, within the 4 years, then the claimant gets at least another year to look at the time limit is extended. The time limit is extended if the cause was introduced within that time period. Then it can be extended. Another complication, for example, has to do with the issue of a sub-sale. When a buyer, in turn, resells the goods, the question is, when does a time limit commence for the buyer to address, before a court of law, to address the original seller? That means, if you look at national time limits, that you could have to do again with another extension. The United Nations Convention says if the buyer is sued by his sub-purchaser within the period of the time limit running, he may address his seller, yeah, and he would then get at least another year. He would get at least another year after having been addressed by his sub-purchaser. Technical matters, difficult matters. If you look at the Belgian and the French time limitation rules, we get into a serious set of issues here. The Belgian and the French text, they say I have the text, that when the buyer is informed of a defect in the goods that he purchased through a lawsuit of a sub-purchaser, he gets a short delay to sue his seller. So there is a sales, an onward second sale. The intermediary knows nothing. All of a sudden, the intermediary gets informed. He gets a short delay to address his seller. The rules in Belgium and France are based on the identical text of the civil code, and in Belgium, the short delay that you get is anywhere between 1 and 2 years, a short delay. In France, between 2 and 3 years, on the same text. Yeah. The question is, the difficulty is, in this case, that there is no notification necessary, and the commencement of the term of this short delay is at the time of notification. So if you are notified 10, 12, 14 years, as in the case that I will be mentioning to you, 14 years after the original sale, you still have to respect that the intermediary has a 2-year limitation period. The issue is the date of commencement, right? In Canadian law, that was also at issue in the case that I will mention, in the Canadian law, the time limits are 2 years. The time limit is 2 years. The time limit is 2 years from the date that an action took place that gave cause, that a handling took place that gave cause to the legal action. So 2 years after a fire, or no, after a delivery of goods, 2 years after the delivery of goods, you must, under Canadian law, have introduced your action. And then you have the time bar. I must then now quickly introduce Article 40 into this, because as I said, in 39, whatever the time limit to sue, the judge then looks at the notification. But if you look at Article 40, 40 says that the seller does not have the right to call in the limit of Article 39, because the seller, double condition, the seller knew of the defect or should not have been unaware of the defect, so that is based on the good faith obligation, and so there is a bad faith that needs to be proven, one, and secondly, you need to prove that the seller intentionally did not disclose. Now, that means that if there would be an action before a court to prove that this exception could be called in by the buyer, yeah, you have a dispute because the buyer says you were in bad faith. If you then go to court, the buyer is intent on drawing the rug out from underneath the notification obligation. If we then allow a lawsuit with a claim under Article 40 to start 14 years later, then the buyer simply wins, because there is no longer any reference to a notification obligation, because he just said there would be no notification necessary. So then if you take Article 40 and you look at the national time limits, we have a more serious question. And there's no doubt that Article 40, just as for Article 39, needs to be, you need to be willing to apply national time limitations for a lawsuit with regards to 40. And this is then, in those disputes, Article 40, the digest mentions 37 cases based on Article 40, and just over half of them are rejected, but in 16 cases, it was withheld that the seller was evidently in gross negligence or in bad faith, and that means then that the buyer wins. If you then look at a case, like the Canadian case, where people call in the bad faith or the gross negligence of the seller and refer to a Belgian time limitation, there is no limit at all, because if this was a case of a subsale, if you were notified after 14 years, you can then introduce your claim, and then if you can discuss the issue under 40, the bad faith and the non-disclosure, and then, of course, you see that there seems to be no end to this. So, in the Canadian case, The judge did apply Belgian law. I think he made several mistakes in applying the short term, because the Belgian law also says this is a cutoff date. This is not a time limitation. But the judge accepted that the introduction of lawsuits in Canada with regard to tortious claims in the 14th year were enough of a communication to the original seller of the broad type of claim with regards to the cooker-fryer. But in Canada, in Alberta, the original 2006 claims with regards to tort were declared time-barred. They were all thrown out. The party restarted lawsuits in Ontario based on contract in 2009. They were declared time-barred with regards to the German original seller of a part, and now at the end of 2017, they were called not time-barred vis-à-vis the Belgian party, because the judge said in applying the Belgian rule of a short term after notification, in applying that short period, no notification, prior notification was necessary. This time limit has no link to Article 40. Article 40 does not hold a time limitation. And the idea was it's the Belgians, their own fault, God help them. And so after the judge said the fact that the original claims in tort were time-barred and unfounded could suspend any running of the time period, yeah? And so the decision was that it could be continued. I must stop, but now comes the funny catch. The judge said, you remember, he said, that we started out by looking at the contract. I decided that it was a Belgian contract. Hence, that's why they called me into the case. And thus, it came under the old rules of 64. He said, if I would have called this a Canadian contract, honestly, in the decision, if I had called this a Canadian contract, hey, we would have fallen under CISG. Darn it, he says, that is exactly the same text. But if it was Canadian law, I would have had to apply Canadian time limitation to this action. And he says, it would have been barred after 2 years, long time ago. So this is the irony of the fact, the Belgian limitation term is exactly the same. Yeah, less than 2 years. But the judge made two decisions on the time limit. And the jump that I want to make with regard to Article 40 is we must make the link to 39. We must say that there ought to be a link to the 2-year period. And Ingeborg and Stefan, when they look at the issue of bad faith, they say the bad faith has to be within that time period of 2 years. They do not pronounce on the time limit, but they say it must be in that period of time of 2 years. So my suggestion is, if you take any national time limitation, you add it on to the 2 years, and there you stop. And thank you so much.
Thank you so much, Johan, for bringing to our attention this truly difficult problem of time limitations and their relationship to the CISG. And our next speaker will be Milena Djordjevic. Milena is an assistant professor at Belgrade University in Serbia. She has been involved also for decades now with the Wismut and especially organizing the Wisprimut 1 week before the Vienna competition in Belgrade. And furthermore, Milena is also very active in different roles as practitioners like arbitrator, counsel, or expert. And today Milena will talk about the special case of damages and uniform interpretation. And now I'm trying to bring up your slides, Milena. Here we go. Milena, the floor is yours.
Thank you very much. As a consequence of me being very active, I have a very bad knee, and as I will be sitting here while speaking. Thank you for the introduction. The CISG at the middle age, Ron? So if I'm 3 years older than the CISG, what does that make me? And just this morning when we were talking about our relationship with the Pitt, I realized that I'm turning legal age. And all of a sudden, you know, during the day, I'm at the middle age. We'll talk about this later. But it is wonderful to be here. Indeed, this year is the 18th year since my LLM studies at the University of Pittsburgh. And it's a wonderful opportunity that I have in this audience and with these people present to thank you both, my CISG parents, for all the legal education that you have provided me with and for being the source of inspiration for many endeavors that I have accomplished in my career. Also, thank you so much for everything that you're doing for the region. It has been mentioned already this morning. Really, you have been a great driving force for the the region that has encountered a turbulent past, and you have brought a lot of peace and prosperity to all the students and professors and legal community in the Balkans. So, moving to the topic of my presentation, my colleagues and co-panelists have discussed of some of the most litigated issues. I have decided to choose some of the least litigated issues, but which have raised a lot of academic attention to the topic. In particular, I have decided to single out some of the issues that Harry Fleckner has written a lot about, and to see, or to prove to him how much a source of inspiration he was for me in my academic writing, as on many points, for civility regarding Article 25, Jack, Harry and I agree. So I have named the title of my presentation, Uniform Interpretation in the Case of Damages, and then the subtitle is Not Running Wild with the CISG. And many of you recognize the subtitle being the title of Lukovsky's article. The verbatim copy is here on the slides. And I will explain to you, and perhaps at the end of the presentation, you will understand why this is the subtitle of my presentation. But before I get there, let me share an anecdote with you. And I'm sure many of you could relate to the story. Somewhere around the year when the CISG was born, my parents were having a celebration in our apartment. I was 3 years old. They had all their friends and our family, extended family, coming over. I think the occasion was my father being promoted to the appellate court judge, and many of their male and female friends were present, my grandmother included, my father's mother. So when everything was over and when all the friends left the apartment, my grandmother approached my mother and she told her something along these lines, well, Ljubica is the name of my mother, in all fairness and honesty, and objectively speaking, my son is the most handsome man that was here in this apartment tonight. So the reason why I'm bringing this up is that sometimes, I think we all, sometimes the attitude that we share towards the CISG is the attitude of parents towards children. We look at the CISG as this most handsome, beautiful, smartest child on the planet, and we turn a blind eye on some of the deficiencies that perhaps the CISG entails. And those deficiencies are there from the very conception of it, and they're there for a reason. The CISG could only come into being as a result of a compromise of different legal traditions and trading nations. And thus we should accept those, what we might perceive as deficiencies, and build upon it and see if we can resolve them, not necessarily within the ambit of the CISG, but within the ambit of a different uniform law projects, or by creating a uniform practice or advice to legal practitioners which would make the whole story full. So that's the not running wild with the CISG advice that I tend to share with you. The specific issues that I'll be discussing with regard attorney's fees, disgorgement of profits, and hardship. But before I start, Instead of introduction, I would like to read a few sentences from one wise man sitting here in the audience. Professor Fleckner has written in one of his many articles the following: "It has been suggested that doubts regarding the Convention's reach should be resolved in favor of applying uniform international law. Although caution in the use of this approach has also very sensibly been urged, particular caution is required when the question involves the scope of the Convention, determining which issues the CISG governs when it applies to a transaction, as opposed to its sphere of application, determining the transactions to which it applies. Extending the Convention's reach to issues that the drafters did not consider part of the CISG project and for which there was, as a consequence, no opportunity for proper debate, impedes rather than advances its purposes." The next 3 slides represent the legislative framework of my presentation, Article 74, 79, and Article 7. And I'll start with Article 74 and the issue which has been touched upon today to some extent, and it regards the language of expression of both the Convention and judges and academics writing and talking about the CISG. The problem, the good thing about the CISG is that it's available in English. Translations of the cases from numerous jurisdictions are nowadays available in English, either thanks to the PACE website or thanks to the Swiss Global Sales Project. But the problem with English is that some notions and terms cannot be translated to English without changing its meaning. All of us coming from non-English speaking world have encountered difficulties translating text from German, Italian, French, Serbian to English, whereas sometimes some institutes just cannot be translated. And the point with the damages is something that I have encountered as a particularly good example of difficulties in translating different legal concepts. And then again, the difficulty of us as lawyers trained in different jurisdictions being impacted by the terminology that comes from our jurisdictions. And as you can see, whilst Article 74 does not define losses that are recoverable under the CISG, you can find in the scholarly literature all kinds of definitions of the losses that are covered by Article 74, and as you will see, they're somehow flavored by the jurisdiction from which we come from. So we'll see differences between positive as opposed to negative losses, expectation loss versus reliance loss, incidental versus consequential damages. Then for us coming from the Roman law kind of inspired countries, damnum emergens versus lucrum cessans, direct versus indirect losses and damages. And although many of the authors, and I have to thank Professor Schwenzer in her book on global sales law, have explained the differences or kind of have attempted to provide us with definition of how these different concepts fitted into the lingua franca of international sales law, still the problem is that as long as we stick to these different terms that kind of resemble the concepts of laws from our national legal systems, we might encounter difficulties. And I was happy to see when the invitation was sent out by Professor Ron that he actually points out to some of these problems in the invitation letter. As a source of inspiration for us to choose our topics, there was a sentence saying that limitation of damages clauses using European concepts such as the dichotomy of direct and indirect damages or using UCC concepts such as incidental versus consequential damages are subject to the risks of being misinterpreted by the jurists from other jurisdictions. The use of these and other words and terms which are alien to the other party can be misleading and therefore likely to create confusion in a CISG contract. Thus, they should be avoided. And I can fully subscribe to what the invitation letter spells out, and I can only invite all the people present here for the future purposes in their academic writing in English on CISG to avoid using these terms that kind of resemble our national concepts. Moving to the 2 illustrations of the difficulties that Article 74 has caused, not in case law, not that much in case law, but more in the academic writings. And the first one is the question of attorney's fees. Well, often it has been stated that, and I quote again, when an international commercial dispute arises, the cost of resolving it may be as important to the parties as the merits of the claims themselves. So the issue here is whether the costs of litigating or arbitrating a dispute under the CISG contract qualify and constitute loss within the meaning of Article 74, and can they be reimbursed under the veil of Article 74? So there was a case in the United States that brought the issue to the global attention, and much thanks to Professor Harry Fleckner's writings and previously mentioned John Lukowski. But the academic community picked up the topic, and this issue has found a place in most of the commentaries on the CISG, although again, as I have mentioned, the case law does not really show the relevance of the issue. And why is this so? It's not because in CISG contracts, when they're litigated or arbitrated, the costs, attorney's fees, are not reimbursable, but it's because they're reimbursed under otherwise applicable procedural sets of laws or rules. And this procedural nature of the attorney's fees as costs has been emphasized by the court in the United States and Justice Posner as well as one of the reasons why they should not be considered covered under Article 74 and why they should remain outside the realm of the CISG. Well, although many scholars agree that the outcome, the solution that the Justice Posner suggests, and that leaving the attorney's fees outside the CISG is correct, the methodology by which he reached his conclusion is not supported by, again, most of you present here, as it has been said that we are not contributing to the uniformity of interpretation of the CISG if we are defining the concepts or the terms, institutes contained in the CISG by the notions that come from our national legal systems. And who is to say that the attorney's fees and recovery of attorney's fees is an issue of procedural law? Or who is to say, and there are other issues where it's not universally accepted that certain issues fall within the ambit of substantive versus procedural law, such as the issue of recovery of interest or the statute of limitations or the issue of burden of proof and standard of proof. While it would be nice, in a way, to have the attorney's fees covered by the Article 74, as this would enable parties from all jurisdictions worldwide, even those following the American rule that does not allow you to be reimbursed for your attorney's fees even if you succeed in a case. It may well not be the case for the CISG to resolve this matter. Generally speaking, for those authors, and there are some, who advocate for attorney's fees to be covered under Article 74 of the CISG, they focus on the wording of the article, and they focus on the principles of full compensation, foreseeability, mitigation, and reasonableness, which they believe speak in favor of having attorney's fees covered by Article 74. But then again, many of the authors speak against it, and the reasons invoked therein are either of the procedural character of the recovery of attorney's fees, or they base it on the drafter's intent. The American delegation would never subscribe to the CISG had it known that this convention would change this American rule that is so close to our hearts. Although we do allow by-party autonomy to change the rule, right? In contravention, this attorney's fees, recovery of attorney's fees under CISG is in contravention to the principle of equality of the parties, which is one of the main arguments advocated by the CISG Advisory Council in the opinion that does not allow recovery of attorney's fees under Article 74. And then again, some say that the CISG principles cited by those who are in favor of recovering attorney's fees under the CISG are just not well suited for resolving this issue. What does the case law tells us? Well, apart from like very limited number of decisions where this issue was in dispute at all, like the Zapata case in the United States, and apart from a very few cases where the costs of representation were actually awarded as loss within the meaning of Article 74, the vast majority of cases, I mean, these exceptions are negligible in comparison to the over how many, 2,000 or 3,000 cases that are available only on website. These cases did not deal with the issue of recovery of attorney's fees under the CSG. They did not discuss why, as it came natural, I guess, to all the participants in the dispute, be it plaintiff or defendant being, attorneys, or the judge, that a party would seek reimbursement of attorney's fees under the applicable procedural ambit of the dispute. Already? Disgorgement of profits. I haven't seen a CISG case, and I am sure Professor Schwenzer will correct me if I'm mistaken, where this issue was actually discussed in the CISG context. Yet, so many scholars, some of us included, have written on the issue whether the CISG allows calculation of damages versus this disgorgement methodology, or whether disgorgement of profit is another remedy available under the CISG. Those speaking in favor of calculating the loss by breaching parties' gains say that this is in line with the purposes of the CISG and the general principles contained therein, that the drafting history does not exclude it, meaning it does not address it at all, so it's not excluded, and that the other party's gains may be valued as a presumption of the loss that the aggrieved party has sustained. So this speaks in favor of disgorgement. Against disgorgement, you would see arguments that say that this is not in line with the purpose of the CSG, the language and the general principles. It's not discussed during the drafting process. It doesn't mean that it gives a leeway for including it later on. Gains of the other party most certainly do not equal to the loss. And if we accept disgorgement of profits, we would risk undermining the uniform interpretation, as this remedy, even in those national systems where it exists, is not uniformly regulated and is not based on the same prerequisites. Thus, how are we going to introduce it to the CSG without a word being mentioned about it? Case law, as I said, zero to the best of my knowledge. The CSG Advisory Council opinion that has published 2 opinions specifically on damages does not address the issue. And Professor Fleckner is about to write on the topic. Thank you, Jack, for covering the issue of hardship for me. I'm going to be within the time allocated to me, but the question is, does Article 79 covers hardship? And Jack has presented a good introduction to the topic. And although he did not cover all the possibilities that I have seen addressed in the doctrine, one is that hardship is excluded under Article 79. So there can be no mention to hardship either within the CSG or outside the CSG. Hardship is covered under Article 79, but then the question is, what are the remedies available? Is it limited that only to the exemption from liability to pay damages, or are there other remedies available within the CSG, which is an argument that the CSG Advisory Council, in its opinion, has advanced? Then hardship is an internal gap that should be filled in by recourse to general principles or by recourse to domestic law. The one case, but 2 different conflicting opinions decided by Belgium courts again. And then some think that hardship is not governed by the CSG. It falls within the exceptions, area excluded by virtue of Article 4, as hardship might be considered a validity issue in some countries, and thus there is recourse to domestic remedies that some of them present here, would think that they are preempted by the CSG. Can we use the principles of international commercial law as gap fillers, in general for the CSG or specifically for the issue of hardship? Specifically for the issue of hardship, my answer would be no, as not only for the reasons that have been mentioned earlier in the panels today, which relate to, let's say, the legal history of CSG and the principles of international commercial law that came afterwards. The issue of hardship is one of those topics which is not globally universally accepted and by the same means addressed, even in the countries that know the concept of hardship. Thus, we cannot speak of the UNIDROIT principles representing something as general principles on which CSG was based, not only for these time constraints, but also for the substance of the argument. Are there usages of trade? I don't think so. But they could be agreed upon rules on law And this is where one could advise parties, if they like the rule contained in Principles of International Commercial Contracts regarding hardship, to combine it with the CISG rules and have the outcome that it prefers. And instead of a conclusion, another quote of my favorite CISG professor: "The entrenchment of different approaches to interpreting the CISG by tribunals from different legal traditions would mean that the Convention's ultimate goals, the ambitious vision that inspired it, would not have been achieved. That would be a loss to the prosperity of the world. It would also be a serious setback to the process of developing a global legal culture, a process on which I genuinely believe the very survival of our species may depend. So let us at least make the attempt to listen to and to understand each other." Thank you.
Thank you very much, Milena, for addressing these controversial issues under Article 74 and 79. Just a question to the organizers. We are running a bit late. Can we have 5 more minutes?
We're scheduled to break
At 3:20, yeah. It's only 13 minutes. 3:25. Okay, the floor is yours. Possibility for question. Harry.
Well, thank you. And I got to say, it's kind of an amazing thing to have two of my favorite students at all, both of them talking about me and talking about some of the things I've written that I would like to have as a testament to my educational prowess. It may very well be that I've so beclouded their minds that they haven't escaped the influence yet. But either way, I've had an impact, and that's pretty good, as a matter of fact. I thank you both for that. And yeah, I wanted to say one thing about the quote, Francesca, that you indicated. I remember hearing for the first time Ingeborg explain how the Noble, what became known as the Noble Month approach developed. And I must say, that was not only a laudable goal, it has been an effective approach. Now, I don't abandon what I said in that particular quote yet. I'm not sure that's the right way to do it, but it worked, and it was certainly the right thing for the CISG, I think, in Germany. What has occurred to me as I'm thinking about this is, I'm thinking, if by case law, commentators, including myself, might say, the question of the reasonable time for giving Article 39 notice is kind of coalesced around, it's generally, 30 days, and then give or take depending upon the circumstances. Would I have objected to that? And if I didn't object to that, basically I've just got common law bias in objecting to a different way to approach it. So I am not reconsidering, I think, the ultimate idea, but reconsidering exactly what I was thinking when I wrote that, because I think it has, in fact, been a good thing for the CISG that you came up with that idea, even though, yeah, maybe it's not theoretically the right way to do it, but it has been a good thing. So I wanted to say that make that particular point as we go along. And thank you both, Milena and everyone on the panel, but I got to particularly thank the people who quoted me,
Further questions, comments, remarks? Ulrich.
Thank you. You said that I proposed 2 weeks as notice period. Indeed, I did so, but in the first or second edition of my commentary on the CISG, I approximated it now to 14 days to 1 month. And I think if you look into the case law, it is rarely the case that really the month matters. In most cases, you have specific aspects, specific facts, for instance, the flower cases or when you buy animals and so on, where you have different periods of time, and there is also quite unanimity that these periods must be shorter than 1 month. And then you have cases where even more than 1 month may suffice if it's not necessary to, or it's very difficult to check the object for with respect to defects. So the month is not or is rarely really decisive, but I feel it's and I agree with you, Harry, it's an effective rule to say if you need more than 1 month as buyer, you are always run a certain risk that you may lose your case. And that is helpful for each merchant. If you are faster than 1 month, it's normal in those cases which are the normal cases that you are on the right side. Therefore, I feel that is a helpful and practical rule and should be promoted and further applied. I would also like to address the disgorgement argument. The CISG damages rules are based on the compensation principle. That means the loss that ensued must be compensated. If the profits of the other side are equal to the loss that may be possible, but only then I would agree that the disgorgement of profits may be the right remedy and the right measure of measuring the damages. But normally it's outside the CISG, in my view, and should not be mixed with the compensation principle of the CISG.
Further remarks, questions? Yes, please.
Thank you very much for the presentations. This is a remark and a question because it has been in my mind for, I think, quite some time, and I still haven't managed to fully grasp what I'm what I'm going to say. So when I was first introduced to CISG, I was a Vismuti. The Vismu that year revolved issues around Article 39, and I remember struggling so much. I spent a lot of time trying to figure out what would be the best argument for us. And then I came across to Professor Fleckner's article about, an approach that was so different from others. And at that time, it made so much sense to me from both. Of course, it was in favor of what I was trying to achieve, but it was also a very reasonable approach in terms of both legal and those commercial interests, which was the length of reasonable time should be assessed from the aspect of prejudice, right? With that notion of prejudice that does come from common law. So for me, as a civil law lawyer, a common law argument was very persuasive. And that brings me to an idea of, are we, can we expand the idea of uniform approach to interpreting the CISG to open up interpretations that would achieve those that would achieve a different purpose than the one that we are doing now? So I guess what I'm trying to say is that taking that as an example. Although that interpretation was influenced by a common law approach, coming from a national law, if it still fits the analysis of Article 7, can it still be a way to interpret CISG to achieve broader application and broader application of it for the commercial parties? Does this make sense, what I'm asking?
Let's see, I think I understand your question. I'm not sure that it matters as much whether it comes from a common law or a civil law perspective. is it matters whether you are seeking a uniform interpretation of the CISG or you're trying to add some additional gloss on it. I think that to the extent that you can look, for example, I think Harry's prejudice argument, as I understand it, if you look at the CISG and you're interpreting Article 39, and you find as a general principle under the CISG, which I think you can, that it promotes the idea of cure and keeping the contract together. And I think you can find that in a variety of contexts. If that's a general principle, then you could say that to the extent that the later notice didn't prevent cure and still allowed the parties to fulfill the terms of their contract, then perhaps we should say that the notice was timely. The fact that, as Ingeborg suggested, that's a concept that comes from UCC Article 2, and I agree it does. I don't think that precludes it, as long as as long as the concept happens to be in Article 2, but you really found it in the general principles underlying the convention. You can find estoppel in UCC Article 2. I think you can also arguably find estoppel as a general principle under the CISG. So the fact that something and I see some shit, the fact that something coincidentally comes from common law or civil law, I don't think makes a difference. If I could just briefly speak to the standards issue, since I, for a minute, got the mic on. Here's my concern, and I'm probably where you were, Harry. Here's the problem with the standard, is I understand the proposal, whether it's a noble month or 14 days or 14 days. The concern with identifying some sort of a uniform amount of time is you've sent this as a presumption, as a signal to the parties. And this party who says, you know, I think I'm on the right side of 30 days, the noble month, and I don't think there's anything unique about that contract. So maybe I have a false sense, an ex ante, false sense of security. And so instead of providing notice in 10 days, I provide it in 15. But after the fact, the arbitrator says, oh no, this should have been 14, should have been 2 weeks. I'm out of luck. So my concern is that when you employ presumptions with respect to a standard, you may be sending an ex ante signal to the parties that they can depend on those presumptions when they can't. If it's a rule, I'm all for sending strong signals to the contour. But if it's a standard by which we're going to judge your behavior after the fact, I'm a little nervous of the false security that might be provided through a presumption. I understand the value and I understand the aspirational, why, but anyway, so when I think of these as standards, as ex ante standards for an adjudicator to resolve a dispute, it makes me nervous when we start talking about presumptions. Just my thoughts on it.
Further questions, remarks, Harry? So, if there are no further questions or remarks, I may close our session and ask you, let's give a warm hand to our presenters. And now Ron has a couple of remarks for housekeeping.
Housekeeping again, and the first one is errata. The red dots, I was not exactly right. Those who will be are registered for dinner tonight, you have received an email from Austin LeBeau this afternoon. So check your emails. If you received an email from Austin, good. If you didn't and you think you're registered for dinner, please check with Austin during the break. Second, this afternoon, at the end of the next session, I would ask all the speakers to hang around and come up here so that we can do a group photo of the speakers. And I think that's it, yes, for now. Take a break. What's that? We are scheduled, we're right on schedule at the moment, and so we're scheduled to be back at 3:40.
Last panel for today, what has been a very productive day, and the first speaker will be Professor Nina Tepes from the University of Zagreb. She will talk about a topic which is in an environment where you have civil and where you have lawyers coming from a civil law background, a commercial law background, common law background, usually one of their hot topics, the role of good faith. The Germans know that good faith is everything, and the English believe that good faith is something you have on Sundays in church, but has nothing to do with commercial law. And thereafter, there will be something you rarely see. You see a couple, husband and wife, or wife and husband, on a panel, talking on two different topics, and they promise that they will not contradict each other. And we have Francesca Ragno speaking on the topic of, let me see, she's speaking on, first is the husband. First is Marco speaking on applicability and application of the CISG to non-sales transaction, something you might see in the future in one of the moot court cases. And then you have Francesca speaking on the CISG in choice of law, which is a fairly interesting topic at the end of every session, in particular when you have the dinner looming, and then keeping the audience, you must have someone who is a very good speaker and has also a very interesting topic. For that, without further ado, I would ask Nina to start, and we are 2 or 3 minutes behind, but I'm pretty sure that you speak fast.
Don't worry about it. Of course I can. Okay, so I came to Pitt yesterday, woke up at 4 a.m. Back home, it's now 8:45 p.m. I'm sure this is the latest I have ever given a presentation in my entire academic life. So I may be very short. or too long, so just show me the cards. This is my first time at the University of Pitt and Pittsburgh. I would just like to say thank you to both Ron and to Harry. You know, I don't consider you colleagues, I consider you my friends, have been for a long time now. Hopefully we will still be friends after this little experience. Okay, so when my paper is co-authored with my colleague from University of Zagreb, Professor Hrvoje Markovinović, he also works in the same department of commercial or corporate law, and when we tackle the topic of good faith, we very soon realized that it was much too broad for our taste. Then afterwards we realized that it would take us probably 5 lives to read everything there that was ever written on the topic of good faith in CISG, mind you, not good faith in any particular legal system, only good faith in the CISG. So when we began our research, what we immediately started to do, we started to do a little triage, so to speak, and we started to outline the issues that we will not address in our paper. And the list became slowly became longer and longer, and some of the issues that when you read papers and scholarly writings on good faith in CISG, some of the issues that we kind of set aside, and I will come in a minute to the reasons as to why we did it, are the well-known issues of whether it is only an rule of interpretation, of whether the good faith is a principle that parties to a commercial transaction, to international sales contract, must adhere to, although Article 7.1 does not say so, but there is abundance of legal writing that would suggest otherwise. Is it a normative rule? Is it should we take a more descriptive, factual-based approach? And then a number of circular questions and circular arguments if you use it as a rule of interpretation, but not as a rule that parties are supposed to apply in their international sales transaction. What does it say about the rule if you're interpreting the provisions in light of the CISG without applying it as a standard of behavior to the parties? What does that mean? Or vice versa. If you use it as a rule that parties must adhere to in their international sales transaction, is it not at least to a certain amount, at least to a certain extent, amounts to a situation where you are effectively introducing a new legal rule within the CISG, which will then be applied presumably parallel to Article 7.1 as a rule of CISG interpretation of the CISG. But we did this list and we kept excluding the things that we will not write about, primarily because all those issues that I mentioned now, it's just, we just thought that those are the questions that cannot really be answered if we do not answer the ultimate question before that, and that is, what is the good faith in international trade, and what does it mean to apply or to take into account or to consider good faith, whether in terms of interpretation technique or in the terms of practice conduct. Now, when I had my first lecture on the CISG as a student, it was my old professor, he's retired now, he literally came, it was within the course of commercial law, and he came and he said, okay, we have to talk about the Vienna Sales Convention, and I will take 1 hour to do it, and now I will explain and I will teach you how to exclude it from your contract. And this is basically everything that we did. He said, just grab your pens. That was before PowerPoint presentations. I will just give you an example. Now, or examples on how to do it properly so you don't have problems in practice. Now when I teach international commercial law, I take a full semester. So you see that it's some things have changed, but some things are still the same. If you really want to frustrate your students, you give them an assignment on Article 7, Paragraph 1. And if you want to drive them mad, you assign reading on good faith in international trade. I mean, it works. It has worked for dozens of generations for now. And when we start working it on a seminar, which I tend to, when I tend to ask them what have they read and what do they think about it, we usually, within the time span of 5 minutes, we encounter problems. Very same problems that we encountered when we started to write this paper. Now, I don't consider myself as much of a comparativist lawyer. I barely know my own law. But when I teach my students, I always try to keep in mind that, first of all, I want them to be better lawyers than I am. And second of all, I always keep in mind that vast majority of them will be practicing law. So it always strikes me to a certain extent as troubling to impose on them this obligation to act as a comparative lawyer in order to reach a solution that could be applied within the CISG. So one of the problems that we had when we made the list and when we started to write the CISG is the same problem that I encountered on my seminars when faced with the direct question, what is good faith in international trade? That I very often say, I literally do not know. Or it is open for debate, but I cannot give you a straightforward black or white question. Now, what struck us as particularly interesting is that the issue of good faith, as you have mentioned, especially in civil law countries, me coming from a civil law country. I mean, the principle of good faith, we can debate it, we can talk about it, we can apply it in numerous solutions. We more or less have your classic all-encompassing, open-ended rule on good faith. The issue with good faith, when I analyze it and when I understand it and when I try to relate it to my students from the perspective of Croatian law, is that it is primarily a standard of conduct. It is a standard on how the parties should discharge their rights and obligations, contractual rights and obligations in the international transaction. What the CISG did is take the standard of standard of parties conduct and elevated it and put it in Article 7.1 as one of the interpretative criteria which must be used when interpreting presumably ambiguous provisions within the CISG. Now, what confused us is that the standard of good faith, this is simply not the function of the standard of good faith, at least not in the countries such as my own or legal orders such as my own that recognize it as a general principle of law. And if we want to, it seems to me that if we want to understand what is a general principle of good faith and how to apply it, at least as a first step, and I'm not invoking homeward trend here, but at least as a first step, we should look at those systems that actually have general principle of good faith, just as a source of inspiration, if nothing else. And coming from a civil law country, standard of good faith, as I said, is a standard of parties conduct, and it's a pretty straightforward rule, which says that parties are expected to discharge their rights and obligations while performing their contract in the manner which is considered acceptable by the particular legal system, by the legal order within which this general principle of law works. And then when you take that kind of reasoning and try to apply it to the CISG, obviously you will have the problems. And when we started to think about the good faith like that, it seemed to us that the problem may not be in the fact that the good faith is, as the majority of scholars seem to suggest, this elusive concept that has no boundaries, that we are presumably intuitively familiar with, and we know what it means, just like we know what the bad faith means. But the problem within the CISG and the good faith is that we literally do not have a workable frame of reference against which we can then try to measure substantive meaning of good faith. If within a specific national jurisdiction, if you want to know what the good faith is, you will try to find substantive meaning of good faith by measuring it against what is considered appropriate and acceptable within that particular legal system. How do you do that within the realm of the CISG? We don't have a Supreme Court of the CISG which would tell us, which would try to unify. I mean, it is quite common approach to use an open-ended rule, because you have to make the standard of behavior adaptable to societal changes, if you will. Those are the requirements of applying the general principle of good faith. And then it is the task of jurisprudence, and it is the task of legal theory to fill the content of good faith, and to be careful never to cross the boundaries of what is set by that particular legal order. So it's not a subjective notion. It's very much objective. But there is a clear frame of reference. It is not something that you are intuitively born with. My teachings, my lectures on good faith in Croatian Code of Obligations is very much different than how I approach the topic of good faith in CISG. And rightfully so. But just coming again from a country that is a civil law country and that is very much familiar with the concept of good faith, this is something that we find very problematic. We found very problematic within the CISG. So this is where we actually started. We asked ourselves, what could be the workable frame of reference? What could be the frame of reference that we could maybe agree on to start the more constructive debate on good faith? Now, the first answer that comes rather intuitively to those people dealing with international commercial law would be to say that good faith in international trade smells dangerously like lex mercatoria. And those people that know me know how I feel about lex mercatoria. It was one of the first things on the list that we said not to write about. But when you read the number of the scholarly writings on the topic of good faith, you cannot help the feeling that it is in the air. It is constantly in the air. It is as if the scholars are patiently waiting for, in the lack of a better word, for the universal recognition of lex mercatoria as the ultimate source of the general principle of good faith that would somehow help us to mysteriously understand what was meant by Article 7.1. Now, as I said, those who know me know how I feel about lex mercatoria, so we kind of presumed as a second step that maybe that is not the answer to the question of what is good faith in international trade in Article 7.1. But then when we were reading the scholarly writings again, we noticed that a lot of them, including the jurisprudence, and they are talking about Article 7.1 and good faith, they are talking about good faith. They are not talking about good faith in international trade, which is the full wording of that part of Article 7.1. So we asked ourselves, why international trade? Would it be different if Article 7.1 said only in interpreting CISG, be observant of good faith, not good faith in international trade? So There were a couple of authors that tried to, 5 minutes? Oh. There are a couple of papers that addressed this issue. But what seemed to us is that when you try to think about good faith in international trade, the conventional answer would be that reference to international trade seems to indicate that you must interpret the notion of good faith autonomously, so that you cannot have recourse to domestic law. That seemed to us as somewhat, I wouldn't say wrong, but it is the fact that Article 7.1 already provides for such a criterion. So unless it's meant to mean nothing, it surely must mean something else. So our idea is, while searching this frame of reference that could be used, is to say that international trade, the reference to international trade, does not mean that you should interpret good faith autonomously. It does not mean that the CISG applies only to international commercial transactions and not to international consumer transactions, for example, because those things are defined by the scope of application. In other words, it must mean something else. And when you look at the CISG, the only other place where we find reference to international trade, apart from the preamble, it was in Article 9, paragraph 2. And it was the reference to international trade usages, which says that the parties are considered to impliedly made applicable to their contract, a usage of which the parties knew or ought to have known, and which in international trade is widely known to and regularly observed. We engaged in a little teleological reduction in our paper, basically to conclude that to be widely known in international trade simply means that a usage must be perceived as such by critical number of subjects which are participating in trade, and that likewise to be regularly observed by parties to the contracts of the type involved, relates to the level of observance, again, of the parties which are conducting their sales in particular sector of international trade. So basically, when we started to interpret Article 9.2 in order to see what does a reference to international trade mean there, we have concluded that reference to international trade is not merely of a generic nature, but it is a reference which tends to include into the analysis those specific subjects which are participating in international trade. And then we wondered if Article 7.1 and the reference to good faith in international trade could maybe be interpreted in a similar manner, and whether such an approach would give us at least a first step. I'm fully aware of the potential problems with this kind of approach, but whether or not it could give us at least this first step in trying to find a workable, at least an agreement of a workable frame of reference against which then we can compare and try to find a solution of what is substantive meaning of good faith. So in our analysis, at least as a suggestion, and by reference to Article 9.2, good faith in international trade would mean that there is a requirement that good faith is an existing and operative principle which is perceived, recognized, and acknowledged by critical number of subjects which are participating in international trade. So at that very point, the search for the notion, substantive meaning of good faith becomes much less theoretically based, becomes much more factually based. It is functionally the same analysis as the one that you're doing under the auspices of Article 9, paragraph 2, when you're searching for the international trade usages. But the purpose, so this is not the idea is not to find an international trade usage and then apply it as a good faith principle. That is not the idea. But the idea is, and the purpose would be, so not to declaratory identify a good faith principle, because mind you, it is highly unlikely that a trade usage will explicitly provide for a good faith. But the idea would maybe be, and its purpose, to identify specific standard of parties' behavior, which is considered and perceived as appropriate in the particular sector of international trade. Then the frame of reference that we have as an applicable national legal order when we are dealing with general principle of good faith within our own legal systems, the alternative would be international trade, what is perceived as a behavior which is tantamount to good faith by those subjects which are participating in international sales transactions. Again, just with the idea of trying to reach an agreement on something that could resemble a workable frame of reference, while we are all patiently waiting for the big entrance of Lex Mercatoria, or if you believe that it all started in Middle Ages, for the second coming of Lex Mercatoria. Maybe this could be something that could unify the jurisprudence in this respect, maybe bring some order into the jurisprudence and on this issue of good faith that we have today. And I'm sure, as I'm sure that you are also, Lex Mercatoria is just around the corner, so just a short time that we have to bridge. Thank you.
So, thank you, Nina. There is probably a lot discussion thereafter on some of the points. I at least have a number of issues from a German side, which I would like to discuss. But before we do that, we have Marco Tosello. Marco is a full professor of comparative law at the University of Verona School of Law, and he's a global professor at New York University. He must have a twin somewhere, yeah, because wherever I go, I see him. He is teaching for various institutions, and in addition to that, he is one of the leading practitioners in Italy in the area of commercial law, international commercial law, and arbitration. So it's a great pleasure that you talk here on the topic. You don't have to.
Thank you very much for the kind introduction. And let me actually start with a disclaimer about the family panel. This is usually something we don't do. I actually think it's the first time we happen to be the same conference, and not to mention the same in the same panel. As a disclaimer, I would say that I was actually, and this is also the disclaimer for the order that you rightly confused beforehand. I was originally scheduled to talk tomorrow morning. Then on my way here yesterday, when I was in Paris, I received a request to move from the Saturday to the Friday session. I said yes, so I'll give rid of the tension and be relaxed for the dinner without having the perspective of my intervention. So I agreed, but any advantage comes at a cost, and the cost is that now I'm talking in the same panel with my wife before her, and I'm probably never been so tense in my life. The more so, the good part of that is that Stefan will not need to look at the time, because I will not dare going late. It's the first time that we are in the same panel, but I know by experience what happens when I get back home late for dinner. So that I will stick to the time. That said, let me thank very much Ron and Harry for putting this together, for having us both here. Actually, the problem was that we are so affectionate to Pittsburgh and to you that neither one of us could give up the invitation, so we're both here. And in the early days of my career, which unfortunately was also kind of coincided with the early days or quasi-early days of the CISG, my first conference on the CISG was in Verona in '99, and I was presenting on reservation, a paper that then was published in 2000, Uniform Law Review. And at the time, I didn't know Harry Fleckner, but the only paper that I could find that extensively and satisfactorily dealt with reservation was a paper written on challenges to uniformity by Harry Fleckner. And so just a few years later, when Harry and Ron were waiting under the two towers in Bologna for me, because we had a meeting because they were spending some time as visiting scholars in Bologna, I remembered I was trembling and so emotional that I was going to meet such an authoritative scholar that I had read and cited and learned so much from. So I'm particularly happy to be here to celebrate this occasion today. So, but the title is not the early days, is the Middle Age. And let me start with a dogmatic proposition. I probably will be making several dogmatic propositions throughout my presentation, but my first dogmatic proposition is Middle Age, it's better to be optimistic. So when I started working on the paper, I was looking around and I came across a recent paper. Actually, it was the inaugural speech given by Bertomazzoni on the occasion of a UNIDROIT Queen Mary program in London. And I quote, "These are not happy days for international commercial law. The anti-protectionist winds that started to blow in Bretton Woods back in 1945 have lost by now much of their vigor. With that, vast sectors of public opinion are no longer convinced that free commerce and multilateral economic cooperation at a global or regional level are a powerful factor of peace and prosperity," unquote. So there goes my optimism. Not so much. Well, I take it as a dogma, so I still try to find good reasons. But then I look at the context in which the CSG was created and the current context, and I notice that the idea of the CSG and what followed was that the CSG could be the first step towards the building of a larger framework of international conventions and the creation of real international commercial law. So we had the Agency Convention and then the Ottawa Convention. So the agency, the representatives in sales, then the financing related to sales and so on and so forth. So what happened to all these other building blocks of international commercial law? And some of them never entered into force. Some other of them enter into force but have a very, very limited, very scarce application. And the Uniform Lawmaking Agency seems to have shifted, at least in the field of substantive law, and maybe also in the field more recently of private international law, from the creation of treaty-based hard law to the creation of the less problematic soft law instruments, taking a very different approach, which may then open the way for transformation in various ways into hard law in the form of model law that will turn into state laws, or in the form of principles which have the aspiration of becoming of consolidating into usages and possibly being turned into conventions. So the context overall, with this neo-souverainisme or the trade wars and law-making agencies that shift from hard law conventions to soft law doesn't look so promising overall. But again, I took a dogmatic approach, which is the optimistic approach that you should have at middle age. So I said, well, let's review a little bit more carefully the situation and let's see what about the CSG. And one could say, citing George Washington, it's better to be alone than to be in bad company. And the CSG has done a great job by itself in many respects. And many of the arguments that may be drawn by all this external factors may also be turned around and be regarded from a different perspective. The context itself does not suggest that we should limit the applicability and the application of the CISG. The CISG remains a common bridge, as has been mentioned in some of the presentations today, between different cultures. The CISG continues to play a relevant role especially, if not only, for small and medium-sized enterprises, to play a role as a valuable tool to reduce transaction costs, in that it prevents the two-step approach based on identifying the domestic law applicable first by virtue of the private international law rules of the forum, and then finding the substantive rules to be applied in the specific case. So, and even the shift to soft law may tells us something about the difficulties of having the conventions, the treaty-based unification adopted, but it confirms the idea that there is out there, and there is a lot of pressure and request from operators for some sort of unification, although soft law or restatement-based or contract-based instruments of unification. And in fact, in this respect, the traditional critiques to uniform law conventions may be referred to and seem not to be so convincing today as they were not convincing in the early days. The so-called genetic critique, the CISG is a compromise solution. Okay, objection noted, but that is an issue about the process of creating an international convention. There might be an issue there. There might be room for discussing how the process should work in the future. But with respect to the CISG, which is already in place and has a lot of case law in support of it, that critique does not really play a convincing role nowadays. The relational profile, the CISG reduces cultural diversity, reduces pluralism in the sources, but again, the CISG can be opted out. We have heard today that it is opted out in many instances, so it's only another competitor in the regulatory competition in international business transaction. And the operational profile, the operational type of critique, novelty and learning externalities in respect of the CISG, but again, this has been discussed in several of the other interventions. We do now have a very significant amount of cases. We do have the knowledge, and by and large, especially for small and medium-sized enterprises who may come across or deal or go international with many different type of counterparties in many different states, becoming acquainted with the CISG, so with one set of known national law, it's probably more cost efficient than becoming acquainted with multiple set of rules. So that said, I will move on with the two other optimistic dogmatic propositions, stating or trying to identify the grounds or how the CISG on its own, or largely on its own, left alone at middle age, may be extended, how the application of the CISG may be extended beyond its scope. From an internal perspective, meaning the notion of sales in particular, the interpretative extension of the CISG, and externally in cases where the CISG would not per se apply. So in situation where the CISG is not even at stake as a possible source of the rules. And the first approach, the interpretative extension, the only goal that is provided by the rule of interpretation in Article 7 is the goal of uniformity. And that, if we couple that with the idea that the interpretation of the convention should favor insofar as there is a solution within the convention solution over the domestic solution, think of Article 4 as an example for that, may lead us to the opposite, turning around the argument, to the opposite conclusion that, therefore, when we have a notion from within the convention, which should try to expand its interpretation so as to prevent the need to resort to domestic law as the alternative. I think in support of that, Article 3 may be read in a way that would expand. I will not deal with extensively with Article 3 because I had the pleasure of reading Professor Schwentzer's paper on the plane, and I'm very much looking forward to hearing on her presentation of the paper on services, but I just use Article 3 as an interpretative tool in two ways. First, the first paragraph, I think it's possible to read Article 3 as providing a general rule and an exception. And when we have a general rule and an exception, obviously we are in a position to interpret the exception restrictively. So the general rule under Article 3 is very clear. Contracts for the supply of goods to be manufactured or produced are to be considered sales, period. Unless, and here comes the exception, and we all know what the exception is, but it makes only sense to me to interpret that exception restrictively. Similarly, Article 3, subparagraph 2, applies when the sales type of obligation coexist with labor or service type of obligation. And I think there are two aspects that are not so settled also in the scholarship. The first one is the notion of preponderance. And I would posit that preponderance does not mean only that service should be greater than the sale type of obligation. I think it should be by far greater. I think the wording was used to show that it's not only a 50% plus one, but it should be by far greater, the non-sale part. And this is supported also by the fact that the Article 3.2 is written in negative terms. The CSG does not apply if the preponderance part is relevant. So the Article 3.2 suggests that there is a negative implication in the reading. This is when the CSG does not apply. It does not have a positive implication. It does not say, well, otherwise the CSG applies. Why not? Because the CSG is per se non-exhaustive. The CSG does not need to bring the interpreter to the alternative, either you apply me or you apply something else. Because it's by definition meant to be applied concurrently with other sources, possibly arising from the domestic law or arising from other sources. So the supranational commercial law, in this respect, it's an incomplete puzzle that it needs to be filled with domestic law at times or with international sources. Now, when the second approach comes into question, the internationalist approach, not resorting to private international law and the domestic law of the applicable by virtue of that, there are possible alternatives that may be referred to. The first one has already been introduced earlier today. It's the opting in by the parties. That is one possibility. The second one that I would simply mention and refer to the paper is the possibility that there be an interconventional interpretation. Article 11 of the Cape Town Convention deals with default, and it may well apply in a situation where there is a sale of goods covered by the CSG with a retention of title clause covered by the Cape Town Convention. In that case, the notion of default under the Cape Town Convention should, in my view, be interpreted in the light of Article 25, CISG on fundamental breach. The CSG can be the expression of more general internationally accepted principles, and I would like to refer to the rock advertising case decided by the Supreme Court of the United Kingdom just 2 months ago, where the issue of non-oral modification clauses was discussed, and the traditional English law rule was overruled by reference primarily to Article 29 CSG. And of course, Article 29 CSG was not, before the English court, applicable in that case. And this would also lead possibly to the issue of lex mercatoria and possibility of using the CSG as one of the sources of the rules applicable, as source of the lex mercatoria where it would not be otherwise applicable. So let me come to the final point that I want to make, and in the paper I've listed also other type of contracts like distribution agreements and other agreements that may be taken into account. But let me focus just on, at this point, on counter trade and barter transactions. Why? Because the majority of scholars tend to say, well, barter transactions are not covered by the CSG. Although usually there's not a lot of discussion about that. And an interesting comparison, interesting reference in that respect may be done by looking at the 92 UNCITRAL Legal Guide of International Counter-Trade Transaction, which provides a list of different counter-trade transactions and arguments which may be taken so as to review the general proposition under a different CISG approach. The first type of transaction is the buyback transaction, where the importer of equipment and technology pays, in part, by delivering goods manufactured by means of that technology. And of course, here we can have an issue under Article 3.1 of the CSG to discuss whether or not the technology is essential. But if not, I honestly don't see reason why not the CSG should not be applied, whether it is a single or double type of a single contract or a double sale. The same applies to counter-purchase transaction, where the goods are not produced with the same technology, and to some extent with the type of transaction which is usually referred to as offset, where the exporter commits to purchase products not necessarily from the importer but from some other company of the same country of the importer, and obviously that is typically two cross sales, so there's no problem in applying the CSG to both of them. But the problem arises, and I think that the commentators, the scholars had in mind the traditional barter transaction when they say CSG cannot apply to the barter transaction. And let me suggest in that respect that one should make a distinction. At times this distinction is referred to as first-generation barter and second-generation barter transaction. I will try to rephrase that and say unequalized barter and equalized barter, where by equalized barter I refer to barter where the delivery obligations are quantified and there might be a money adjustment about the values of the transaction. Whereas an unequalized barter requires no money adjustment because there's no measurement of the economic value of the opposite transaction. Now, I don't see a problem with respect to the equalized barter, but even if we consider the unequalized barter, which is the traditional exchange with no money, let's just focus a moment on what happens in most cases, if we don't apply the CSG. The result will be domestic law applies by virtue of private international law, and in most cases, if you look into domestic law, either by virtue of a legislative provision or by virtue of court decision, the result will be sales law applies. What sales law? The domestic sales law? Or isn't it appropriate in any event that when reference is made to sales law, in that case, the CSG would be applied as a sort of paradigmatic expression of the general principle of law or general principles of sales law? So the optimistic conclusion that I would like to draw in this case is that either by virtue of an internal expansion of the CSG or by emphasizing the possibility of resorting to the CSG as a source of general principles of law per se, or in a functional approach to lex mercatoria, where the multiple sources of law are compared and selected according to various possible criteria, the CSG has a long way to go for the coming years. Thank you.
Thank you, Marco. You were on the safe side still, yeah. You managed to stay in time. Now I have the pleasure of introducing Francesca Ragno. She's a tenured researcher and adjunct professor of international law at the School of Law of the University of Verona in Italy. She has been also teaching basically everywhere, and last year as a Fulbright scholar here in Pittsburgh, so for her it's also like coming home. And she will talk about CSG and conflict of laws. And Francesca, the floor is yours. Put your slides on.
Perfect. Thank you so much. Should we go? should I use the microphone? It's here. Okay. Hello. Thank you so much. Or is it already here? Oh, this one. Okay. Sorry. Okay. Hi. Thank you so much for inviting me here. It's a great pleasure for me to be back at Pitt, where I spent a really wonderful semester last year. And it's just wonderful to be here to celebrate Harry and his amazing scholarship. So thank you so much for inviting me here. Thank you so much for organizing this family panel. It's not easy to sit at the same table with my husband for so long time because it's extremely busy. So this is really a nice chance. Thank you so much also for that. Well, my task today will be to not only to prevent you from having dinner, but also to try to offer to you some thoughts on the interaction between the CISG and the choice of law agreement as a separate contract vis-a-vis the international sales contract in which might be incorporated. And by saying that, I already anticipated which is my position, which is very in line with the German Supreme Court that Stefan was mentioning this morning. And this is not surprising given the fact that I was born and raised in the German part of Italy, South Tyrol. So in this respect, I feel that the position can be shared 100%. So the principle of party autonomy, as we all know, is basically the cornerstone of conflict of law regime in matter of contractual obligation. The idea that granting to the parties the possibility to choose the law applicable to their contractual relationship is to be considered flexible connecting factor to be employed in order to promote, on the one hand, legal certainty, and on the other hand, to protect the expectation of the parties. So this idea is largely recognized around the globe, is largely recognized in many domestic legal system. I provide you with some example on this slide, but it's also recognized at the regional level in instruments like the Rome I regulation within the EU and the Mexico Convention. Recently, the principle of party autonomy has been acknowledged and addressed also in a new instrument elaborated by the Hague Conference on Private International Law, the Hague Principle on Choice of Law in International Commercial Contract. This is a very interesting instrument, not only because somehow completes the Hague Convention on Choice of Court Agreement, which is the brainchild of Professor Brandt, as we all know, but also because it is the very first non-legally binding instrument elaborated at the Hague Conference level. And this is also an interesting instrument because it has been conceived on the one hand, as being a model for legislator, a model for national, regional, and supranational or international instrument. On the other hand, it has been conceived as a mean to supplement, interpret, and develop rules of private international law. So in this respect, the Hague Principle are capable to interact in some way with existing rules of private international law. And I will back to this issue later on. So given the large recognition of party autonomy around the globe, it does not come as a surprise that international sales contracts are often equipped with a choice of law agreement. As a matter of fact, choice of law agreements have in some instances a crucial role in determining the very same applicability of the CISG. As we all know, a choice of law agreement is a factor leading to the applicability of the CISG pursuant to Article 11b. If the competent forum sits in a contracting state which has not declared a reservation according to Article 95, and if the choice of law rules of the forum recognize the principle of party autonomy, then the selection of the law of a contracting state leads to the applicability of the CISG. On the other hand, however, choice of law agreement can be also a factor bearing the applicability of the CISG. Since Article 6 of the CISG is commonly understood, at least outside the US,
as a, in a way, allowing party to implicitly opt out of the convention as a whole by the way of designated the law of a non-contracting state as the law applicable to the contract. Such a choice of law usually displaces the CISG. Well, at this point, we can conclude that the effectiveness of a choice of law agreement might represent a gateway issue for the applicability of the CISG. If the choice of law agreement is contested, is disputed, is challenged before a court, then the court has to perform a scrutiny on the choice of law agreement, and the question that arises is which are the legal parameters to be used by the court in performing this scrutiny. But first of all, which are some factors that may affect the effectiveness of a choice of law agreement? Well, we all know that in order to produce effect, a choice of law agreement has to be de facto agreed upon. These questions relate to the so-called existence of the agreement. Once that consent, I would say external consent, has been established, a national court may be asked to verify, to ascertain the validity of a choice of law agreement, and this ascertainment, of course, comprises two profiles: the profile of formal validity, the compliance of the choice of law agreement with the possible applicable formal requirement, and the question of the material or substantive validity of the agreement, which refer to the question of the genuineness of consent or lack thereof, and includes issues like fraud, mistakes, misrepresentation, and duress. So given the fact that, of course, formation and form are issues governed by the CISG, basically national courts have two options. On the one hand, first, a national court may be considered authorized to rely directly on the CISG rules on contract formation and form as directly applicable to any contractual term included in the international sales contract, including choice of law agreement. On the other hand, national court could consider themselves allowed in a way to rely on choice of law rules as a necessary complementing tool to solve CISG related issues. So we have basically an alternative approach, a direct approach, or a conflict of law approach. Well, in my paper, I argued that the conflict of law approach is the preferable solution, not only in relation to a scrutiny conducted for the purpose of Article 11b, because in this case it's quite clear that the court have to refer to private international law because private international law is precisely referred to by the provision, but also in the context of a scrutiny on a choice of law agreement selecting the law of a non-contracting state for the purpose of Article 6 of the CISG. Despite the contrary opinion held by some distinguished scholars present also here in this room, I think that the fact that the CISG, that the matter of exclusion is one which is governed by the CISG, does not mean that the CISG governed a genuine choice of law agreement, meaning a choice of law agreement for the purpose of a private international law analysis. So on the basis of the principle according to which ex nihilo nihil fit, I'm not able to pronounce it the American way, so I'm really sorry, but according to the principle, according to which nothing creates nothing, I think that the question of the existence and material validity of a choice of law agreement for the purpose of the applicability of the CISG should be dealt with by relying on the conflict of laws of the forum. Only then the court can evaluate on the basis of Article 8 CISG whether the existing and valid choice of law agreement was intended to exclude the CISG. I think that applying directly the CISG as the law prima facie applicable to the main contract does not take into consideration that the choice of law agreement needs to be distinguished from the main agreement on the basis of principle of separability, because it pursues an autonomous and typical goal, which is the determination of applicable law with the effect of displacing the objective connecting factor of the conflict of the laws of the forum. So, given that one should rely, in my opinion, on the conflict of laws of the forum, and my paper, I took into consideration the model choice rule to be found in the Rome I regulation. And interesting enough, the Rome I regulation creates a vicious circle by employing a so-called bootstrap principle. According to Article 3, Paragraph 5 of the Rome I regulation, the existence, the material validity of the choice of law are subjected to the law that would apply if the choice of law were existent and valid. Basically, the law putatively chosen. So it follows that, for example, if the party have chosen the law of a non-contracting state, like Portugal's law, the issue of the existence, the material validity, but also the formal validity of the choice of law agreement has to be addressed on the basis of the general contract law of the legal system of the non-contracting states, so in this case, Portugal's law. Whereas, if the parties have chosen as the law governing the contract the law of a contracting state of the CISG, in this case we have to make a distinction, because the issue of the existence of the choice of law agreement has to be addressed by relying, in my opinion, on the CISG, as, of course, part of the legal order chosen. Whereas, the issue of the material validity of the choice of law agreement has to be solved by applying the non-harmonized contracting state law chosen, which is my scenario, Italian law, strange enough, Italian law. So the circular approach embraced by the Rome I regulation can be certainly be applied also in relation to the issue of incorporation of a choice of law agreement contained in the starting term of one of the parties. The problems arise in relation to the so-called battle of the form scenario. So a scenario in which colliding choice of law agreements are exchanged and are contained in the party's standard term. Here the question is quite simple, but at the same time very difficult, which is the law mutually agreed on. So the Rome I regulation does not provide an answer. There is no black letter rule in the Rome I regulation that court could use in order to solve this issue. So considering the fact that the Hague principle contains a rule, an explicit rule in this respect, why one may wonder whether the Hague principle could be used as a kind of supplementing tool in order to be used in presence of ambiguities or gap of the EU choice of law regime. And in my paper, I give to this question a positive, an affirmative answer. So if the Hague principle contains a rule, let's take a look at this rule. Well, according to Article 6, 1b of the Hague principle, if the parties have used standard term designated to different laws, and under both of these laws the same standard prevail, the law designated in the prevailing terms applies. If under this law different standard term prevail, or if under one or both of these laws no standard term prevail, there is no choice of law. So quite a straightforward rule. Well, now that we are familiar with the rule, let's try to apply the rule to an hypothetical scenario. Let's assume that a Spanish court, on the basis of an exclusive choice of court agreement, is seized in relation to an international sales dispute arising out of a contract concluded between an English seller and a German buyer. Let's assume that the seller, issued an offer with attached standard term including a clause designated English law as a law applicable to the contract. The buyer reacted and issued a purchase order with attached standard term including a clause selecting German law. So In this case, of course, the Spanish court cannot apply the CISG on the basis of Article 11A. The court has to rely on private international law of the forum, meaning the Rome I regulation, in order to solve the question of the identification of the law applicable, in order to verify whether the law of a contracting state is referred to. Well, as we said, the Rome I regulation does not provide a black letter rule. So let's assume that the Spanish court applied the Hague principle. So in this case, the court has to make a comparison of the approach taken by the German law vis-à-vis the problem of the battle of the forms and the solution provided by English law. But this triggers another question. Is the reference to German law to be considered as comprising the CISG, or has to be considered as referring to the purely domestic German law as it has been proposed by some conflict law scholar, not CISG scholar? So the question has, of course, a crucial importance. Let's assume that what matters is the purely domestic German law. So given the fact that the German law provides a no-out rule in relation to battle of the forms, whereas English law provides a last-shot rule in relation to a battle of the form, we have here a situation of a true conflict situation. Since one of the designated laws apply a no-out rule, no standard term would prevail and no choice of law would be deemed to exist. This determines a situation in which the court has to rely on Article 4, the Rome I regulation, and has to identify as applicable law, English law, as the law of the seat of the seller. Of course, this would lead to the non-applicability of the CISG. A different situation arises if the court would apply the CISG as part of German law. So, of course, this issue of the battle of the forms is a little complicated, and I do not have the time to deal with this issue right now, but let's assume that the CISG embraces a last-shot rule. So, if the CISG embraces a last-shot rule, in consideration of the fact that also the English law embraces a last-shot rule, we have here a situation where both the CISG and the English laws enforce a last-shot rule, and this determines the fact that the law which wins the battle is German law, and thus the CISG is applicable. So the fact that we have to answer to this preliminary question is the CISG to be applied, or the reference to the German law is to be understood as referring just to the domestic German provision is quite important. To sum up, I think that dispute on choice of law agreement for the purpose of the applicability of the CISG should not be dealt by simply referring to the CISG as the law directly applicable, but are to be solved by referring to the conflict of laws of the forum. Of course, this has two implications. The first one is that the national court have to identify the model choice of law rules to apply, which is not always an easy task, as we saw in relation to a battle of the forms. The second implication is that in the light of the bootstrap principle employed in the Rome I regulation, we, at least in Europe, can still think with Professor Fleckner that we have the CISG. Thank you so much.
So thank you very much, Francesca, also for staying in time. I think there is sufficient food for thought and for discussion. Anyone wants to start? If not, I would like to start then. I'm very glad that you don't ask a question, that I can ask mine now. Nina, you started off by saying when they have the, when they drafted the CISG, they upgraded good faith into an interpretive rule. From a German perspective, I would have said more, they downgraded it from a behavioral standard to a mere interpretative rule, and by that try to avoid it to being a standard in the CISG. By contrast, the German courts have nevertheless very often turned it back into a behavioral standard, imposing certain obligations upon the parties directly, for example, providing their general terms to the other side, which you would have under German law as well, but I'm not sure whether that was the intention when they drafted the convention. So why do you think it's an upgrade or an...
Well, but I think that whether you consider it an upgrade or a downgrade, you still have quite a peculiar situation. Because you have a standard of standard of conduct, which is treated as an... Yeah, it makes sense, yeah, sorry. You still have a rule, an interpretative rule, which requires application of a standard of conduct. And in my view, a standard, at least my view being formed by a particular legal tradition that I come from, the application of a standard of conduct is simply, its function and its role is simply not to be an interpretative criterion. Now, you have mentioned whether or not that was the idea of the drafters. Interestingly enough, the first proposal that came, I forgot which delegation it was, but it was a proposal for a straightforward rule, which was based on the good faith being a conduct of parties' behavior. I think that the very first proposal even contemplated the pre-contractual sphere, the pre-contractual obligation. The second proposal that came through also followed the same frame of mind, the same idea. Often you will read that the Article 7.1 is a result of a compromise, and I would argue, at least we have argued, that it is a very peculiar compromise with some rather unfortunate consequences for the CISG. But even if once you accept this idea that you have a standard of parties' conduct elevated or downgraded to the level of being an interpretative rule, even if you accept it, there is still this second question that you have to answer, and this is, what is the good faith? I mean, it is still, the way it is framed within the Article 7.1, I don't think there is any doubt that it still encompasses the idea of being a party's conduct. So I don't see a room of attributing some different functions to the syntagm that Article 7.1 is using. It's just, it is put on a rather unfortunate place, and even if you accept it, you still have to answer, what is good faith? And in our opinion, you have to answer, or ask yourself rather, not what is good faith, but rather what is good faith in international trade. And this was our proposal, just to start talking about what is the frame of reference. Where do I look if I want to search for the solution of what is good faith in international trade? What are the steps? What are the suggestions? Unless, because if we don't have answers to those questions, it seems to me that either we can run with this idea that we are all born with this idea of good faith and we are intuitively familiar with it, we can run with that. But this is also a homeward trend in disguise. Let's just all be clear about that. If we don't have clear guidance, what lawyers will often do, they will come back to the concepts that are familiar in their domestic law. Or we can conclude that Article 7.1, especially this part relating to good faith in international trade, is inoperable, which I think should be the last resort. In the meantime, I would definitely advocate a very restrictive application of the rule.
I have to say this whole discussion about good faith really worries me, because in discussions with common law lawyers, I very often experience that this good faith is one of the reasons why they are reluctant to have or to apply the CISG, like in Australia also. And I ask myself, and with, I mean, we have it in the mood problem this year too, all teams coming from civil law countries, they are relying on good faith from A to Z. I used to tell my students, always in my lectures, if you rely on good faith, you don't have an argument, yeah? And I think we should start discussing, and you said it, what do we mean? And I think we should have a big research among civil law countries. What cases are developed under the notion of good faith? I mean, you mentioned some, like culpa in contrahendo is based on good faith, or, I mean, I was in Brazil. In Brazil, boa fe is everything. It's incredible. Even compared to German standards, Germans are very reluctant to develop something from good faith if we compare it to our Brazilian colleagues. So, for example, they are discussing breaking off of negotiations without having a good reason to do so is against good faith and should lead to damages. So I think wouldn't it be a good idea to really sit down and discuss the groups of cases, especially among civil lawyers and common law lawyers, and then ask the question, how do we want to have these cases resolved under the CISG? Do we want culpa in contrahendo, or some, I mean, the principle pacta sunt servanda is based on good faith, and I just said to Harry, I mean, the whole law is based on good faith. I would say on good faith and reliance. So what is it? And we should start with examples and then discuss them and decide it in a discussion among between civil law and common law, whether we want to have it and whether we can find a compromise to have these cases, how we resolve them under the CISG.
So I think that was already the topic for the 6th conference we have here in 2 years' time.
A good faith discussion of good faith.
Yeah.
Yes, and I also just want to ask Nina, first of all, there's the question about whether a good faith obligation is imposed on parties under the CISG. That's the initial question. I understand your position. It might not be my position, but I understand your position. I was very interested, and I want to make sure I understood what you said when you were talking about how to give meaning to the definition of good faith, and specifically the definition of good faith in international trade. You invoked Article 9.2, and I wonder if you could describe in your view what is the relationship between the obligation imposed by Article 9.2 and what you see as the obligation imposed by good faith. Are they the same thing, or are there differences between those two?
What do you mean obligation imposed by Article 9.2?
Well, Article 9.2 says the parties are bound by usages of trade that are widely recognized in international trade.
Because they're impliedly
part of the party's contract. That's right.
Okay. So the question is?
So the question is, first of all, did I understand you correctly that you were saying that you could refer, one of the ways you could put meat on the bones of good faith, figure out the meaning of good faith, is by looking to those trade usages, and in fact what you might require is something like recognition of a particular mode of behavior common in international trade. And it sounded to me like you were saying something like Article 9.2 and good faith are kind of overlapping, if not...
I apologize. It's now almost 10 p.m. back home. So this is the latest I ever talked in a conference. Our proposition, or the starting point, if you will, was simply the fact that you have international trade. You have good faith mentioned in CISG only once, thank God. International trade, if I remember correctly, it's mentioned 3 or 4 times, 3 times in the or 2 times in the preamble, and 1 time in Article 9.2. Yeah? So Article 9.2 is the only provision, but you have it combined with, and of course in Article 7.1. Yeah, so 7.1 and 9.2. So we asked ourselves, what does international trade mean? And there are a couple of answers that you can give. First, you can say it doesn't mean anything. It's a reference of generic nature. International trade, why not? We are all dealing in international trade and removal of legal obstacles and barriers and whatnot. Then you can say international trade means an autonomous meaning of the international trade usage, for example, or good faith, to which my answer is, it cannot mean that because Article 7.1 also provides that. Then you can say it means international commercial transactions, to which my answer is it doesn't mean that. That is specifically devised by the scope. And then we came to this idea that international trade are the subjects that are participating. Now to answer the question, if you identify an international trade usage by the standards of Article 9.2, now I'm not saying that that would be a direct way to saying that we have a principle of good faith, or this international trade usage is emanation of principle of good faith. But if you have identified an international trade usage which is of such a nature that one could, so to say, that one could identify a specific behavior as being expected from the parties. And I understand, by means of it being an international trade usage, I understand the secularity. But the idea is not to insist that the good faith principle either exists or not, but rather whether you can take this kind of specific behavior and then apply it as a means of interpretation, as an interpretative criterion, if there is a need for interpretation. So in limited number of cases, because not all provisions need to be interpreted. So basically, to partly answer, to comment on what Professor Schwenzer said before, I don't think that common lawyers are reluctant because of the good faith. Maybe that was the case during the drafting process. Because as I said, I don't think that the problem is that the good faith is elusive in its character, in its nature, that is a concept or a notion that we don't know what it means. I think that the problem is that we do not have a specific, straightforward path on how to get there. We don't know how to define it. We don't know what is the workable frame of reference. And we do not have, as I said, the Supreme Court of the CISG, which could help us. And we obviously don't have a legal theory which has taken a unified stand during these last 30 years. So to answer you, the concepts are overlapping, but I am not suggesting to apply international usage as an interpretative criterion. I'm just saying let's observe let's make what parties are considering expected, what parties are considering an expected behavior in their particular transaction. Let's then analyze that kind of behavior, because whether you downgrade, as I said, whether you downgrade or upgrade it, interpretive criterion from Article 7.1 is still a standard of parties' conduct. So,
Professor Magnus.
I think it's very difficult to discuss and find a solution on good faith in abstracto. It's absolutely necessary and unavoidable, I think, to develop case situations or typical situations where you can say that should be decided in this way or in another way. For instance, that no party should profit from own wrongs. That is typical for what you find in a case situation for good faith. or that a party should not go against own former declarations and so on. And we need this development of typical cases. I think that can help to fill the notion of good faith. You left that more or less open, what the contents of good faith is, and only that can be developed in this way, I think.
Are there any other questions on the two other very controversial propositions?
Okay. No, sorry, I just wanted to say I hope the other two speakers don't feel left out, that we kind of all talk about good faith. I think I start with actually agree with what I agree with. I think I see another CISG Advisory Council opinion coming. Yes, I think there is probably need for more research what good faith means, and I completely agree with you what you said, what Nina said about setting it out. But what I would really like to be very clear here about, I think we are all intellectually slightly dishonest, the common lawyers as well as the civil lawyers, and I've done the same for my presentation tomorrow. It is not true that the common law doesn't know good faith. Yeah? First of all, we have, for example, some New Zealand decisions regarding to contract law using good faith, at least in dissenting opinions. There are enough English decisions which actually are using good faith. There is now scholarly even writing about how the English law is accepting good faith. And I'm sure, if I remember rightly, even in the US, we find some decisions using good faith. It is not an unknown concept. What we're all doing is, to mark the differences, we actually take, I think, the utmost outside positions. We're never starting from the proposition, yes, we both legal families know the notion of good faith, where are actually the differences. There is a whole area of law called equity, which is definitely based on the notion of good faith. And it depends also, of course, how you look at it. Do you look at it very dogmatically? Did you take a big picture view? But I think we would also, regarding what Nina just said, we should actually take the first step and looking at the commonalities rather than always starting from the position, or one knows one is good faith territory, the other legal system isn't.
Yeah.
Just briefly to comment on what you said. I completely agree. And that's why I said I don't think that common lawyers have a problem with the elusiveness of the concept. It's just a matter of mechanics. They basically reach the same conclusion by employing different methods. That's not the problem. So as I said, the problem is not the perceived elusiveness of the concept. The problem is how do we get there. Our proposition is to find something tangible, and that is the closest that you get to something tangible is the concrete parties' behavior within the realm of international trade. And you're quite right that we have left it open because we don't know. As I said, all those things that you said, we could all reasonably agree that they would form part of good faith. My question is just why? Because we intuitively feel so. I would have the answers on your questions within my own legal system without batting an eye. I could answer you why there is a principle of reliance, why there's a principle of secondary obligations. What does the good faith mean? When is it applied? I could criticize every case law which only mentions good faith but doesn't sufficiently substantiate the problem. My question is it enough that we feel like that for the purposes of the CISG, or should we try and find some more tangible mechanisms to start working the problem?
Well, unfortunately, time is running out. No, go ahead.
I paid for this microphone. I'm going to move us from Article 7.1, good faith, to Article 7.2, which has the words which has the words private international law. And there's been a lot of discussion about whether this unification of law gets us away from private international law, but Francesca, I think your presentation shows us that we can't get away from it, and both Article 1 and Article 7 show us that we can't. But this party autonomy is a pretty recent concept in legal history, and something that has really been a 20th century thing, moving from parties can't choose law and can't choose forum to parties can choose the law and can choose the forum. But then we get rules that once we have the prevailing rule is party autonomy, we have to have the bootstrap rule, right? Because we have to have a rule to determine whether we have the existence of an agreement to do something. Your analysis, as I see it, leads us back to that existence question. What law governs the existence of an agreement? And once we start saying, well, it's the law chosen by the parties in their agreement, then we're really in a vicious circle. And isn't it better if the parties are both from contracting states to really just start with the contract formation rules of the CISG, and this gets back. It's the same question on arbitration agreements, and even though now a lot of every arbitral institution rule that I've read says that the tribunal, in its competence rule, can rule on the existence, validity, and effect of the arbitration clause. But the courts in the United States have not been willing to go that far. The House of Lords didn't go quite that far. They said, look, existence, you don't have existence of arbitration unless you have an arbitration agreement. And you can't and there's this bootstrap process. And so what we're doing, we get into a vicious circle with private international law. How do we exit that vicious circle?
I don't think we can exit in Europe because it's a more choice rule provided by the non-regulation. So I don't think there is a possibility to exit because this is precisely what the EU legislator wants. I mean, this is a solution provided in the Rome I regulation. So if you think that the CISG governs the existence of a choice of law agreement, so there is no problem in this respect. But I'm not persuaded that this is the case because I feel that the choice of law agreement has an autonomous function. And in this respect, in a way, the choice of law agreement addresses the court. It's not an agreement that is conceived to regulate the relationship between the parties. So, but I know that this position is not shared by many CSG scholars. Maybe it's more, and also in the family, actually, because we argue about that. So.
But we'll solve this later. So, Marco, would you like to address that question?
No, please no.
No, Rob, this is really...
We're out of time. And
that may be a good place to end.
She knows everything about it, so subscribe. Any further questions? There is one over there.
Hi. So I think I'm probably the only tourist in the room here today, from what I've understood, is that everyone seems to be on a first-name basis. I'm here because on Monday I was looking for some CLE credits and found a very cheap way to get 11 credit hours and thought I'd show up to this. I was expecting something completely different, like a room full of students and some professors. I'm thinking, how in God's name can we talk about the CISG for a day and a half? But it's been very enlightening, I have to say. I've enjoyed it. It's really, motivated my inner nerd to go out and spend a little more time rethinking the CISG. But I do have something I'm curious about, and since I find myself in a room full of experts on this, I'd like to see what your opinions are. Listening today, I've been wondering, where a lot of this goes. Because obviously these conventions, it's not just this one, there are many of them. Hague Conventions, New York, there's so many of them. Are in a lot I think they're aspirational in many sense, right? It's optimistic and aspirational. It's part of what was our trend starting in the late 80s through the 90s of globalization that seems to be going the other direction now. And specifically my question is, in our current environment with the United States Senate rushing through judicial appointments that are all seem to be coming from a very specific ideological list of people who are clearly hostile to the entire concept of the internationalization of law and the uniformity. You know, where does this all end up? I mean, are the judges, because if you don't have judges adjudicating, then talking about the uniformity of concepts across our civil and common law systems is meaningless, right? Because if the judges don't care, or they're actually trying to find ways to empty out the conventions into empty vessels, you know, where do you all think this is going, is what I'm curious to hear. Thanks.
To arbitration. I don't want to promote myself, yeah, but any comments on that one?
Other than agreeing with you? No, I think it's a good comment, and that's why I introduced my presentation by saying that I was making an optimistic proposition and a dogmatic proposition in some respect. But on the other hand, I think we're probably experiencing a change, and of course the international policy and political atmosphere is changing. In Italy, we are very good at being very bad before others, so we have experienced this kind of change, and we are experiencing that kind of change of attitude. But this is not affecting the fact that there is a request for simplicity, predictability, and uniformity of the rules at the international level. And the point that I was making, which actually goes toward arbitration, but not only towards arbitration, is that maybe the way forward will be that because the CISG is kind of isolated, and the project that was foreseen in the 80s and 90s to start from the CISG and then have a series of other conventions is not moving forward at this point. And the approach is different. Let's create soft law instruments. They're less difficult to adopt, less complicated to present to states. And then we probably have to consider and start to consider also the CISG as one of these multiple different instruments that may be applied in a very different form. Maybe just in international arbitration from a comparative point of perspective of a sort of lex mercatoria, if you want to use that notion, or anyway in an approach where you compare the available instruments that you have, irrespective of the normativity and irrespective of the traditional conflictualist approach toward the instrument. But clearly there is that request coming from the business sector to have instruments that somehow provide rules available for international disputes and international relationships, and the CISG is still there and still have a role to play, even if not directly applicable in some cases.
Are you amending my contracts in the future to apply the CISG and the international change?
No. I as a practicing lawyer, I never do that.
You got the point. We have the CLE credits already. Reach the class goal.
I just wanted to say, you know, the present is not the future. It wasn't the future in 1980, as we see in 1988, and you know, we do not know what's going to happen. So, you know, if you believe in this kind of thing, and I got to say, I'm impatient with soft law kind of approaches. I like a harder approach. I think it's what's going to work, right? But we're perhaps finding out that the time frame for something like that to work is quite a bit longer than we hoped. Yeah. And if it is going to work, it'll prevail. And if it's not, it won't.
I think the longer was now the catchword for me. To thank our three excellent speakers. Please join me. And then hand over to the organizers to housekeeping and other things. And I'm pretty sure you can ask them questions over dinner as well.
A couple of quick housekeeping. matters, those speakers who are going to be reimbursed for flights, see Austin in the back. Tomorrow's session begins at 9 a.m. The doors of the building will be open at 8 a.m. Those of you who are getting CLE credit, please keep your yellow sheet and your checklist for tomorrow and hand in the checklist at the end of that tomorrow. On the program, for those of you who are registered for dinner, it says 7:30, but there 7 o'clock reception begins. We'll have dinner at 7:30, and then the actual program with the dinner will be dessert. Or you will also get other dessert, but that'll be dessert too. but I want to thank everybody for what I think has been just a very enlightening, enjoyable intellectual day, and I'm looking forward to tomorrow morning. But right now, I ask our speakers to come up here so we can get a group photograph of all the speakers. We'll see those of you who are going to join us at dinner at the University Club Ballroom B, which is on the main floor of the University Club. If anybody has questions. What's that? Ballroom B is upstairs. Oh, it's the upstairs ballroom, not the... Okay. Ballroom B, it's the second floor. All right.